continuing. So
So you already,
what's that? You're live and ready to go. So I'm gonna step out so I can find people.
Brianna mentioned to you when I told her yesterday about the audio. The only microphone's up there.
Right, I need to go find out where people are. Let's talk later about it.
Uh-oh.
How are you, Dave?
I'm good. Another great day in real estate.
yeah, how far away are you? Oh, wow. Okay. Yeah, I'm getting ready to start right now.
Okay, thank you so much,
Okay.
I'm gonna mute my phone. I'll mute my phone, Steve.
Okay. All right, good morning.
Morning.
Where is everybody? Well, thanks for being here. Is anyone here attending a contract class for the first time? Okay. And for the three of you, have you written an offer yet using the contract?
Yeah.
One of you hasn't, the other two have. Okay, very good. Just always want to know the experience level so I can keep it all relevant. For those of you that haven't been to one of my classes or haven't formally met me, my name's Steve Pierce. I'm the broker of the office. I've been selling real estate for almost 33 years and have been an attorney for almost 40 years. A lot happens at the end of this year. Did for anniversaries for me.
Yeah, you got older.
Exactly, that's for sure, yeah. The copy of the contract that you have is what was created by one of my colleagues when the new contract first came out, and it has a lot of highlights on it to kind of point out changes from the previous contract and so forth. And I thought it was good just because I knew there'd be some people here that were new and didn't have a lot of experience with the contract. I thought it'd be good to use that same version again. It kind of helps point out things that, it does point out things that you need to pay particular attention to. To start out, the first thing that you have to decide if you're sitting down with a buyer, you know, preparing an offer, the first thing you have to do is determine which version of the contract do I use. What we're going to go through today is the residential purchase agreement. There are other contracts in ZIP forms, okay? And I don't know if you've taken time to go through ZIP forms. In addition to this form and the last number that I heard, there are 92 forms in ZIP forms, okay? So there's a lot of forms, and there are other contracts. And the other contracts are residential income, there's vacant land. Now there are contracts for probate sales and for mobile homes, but this contract now has provisions for addendums which eliminate the need to do a separate probate purchase agreement or do a separate mobile home agreement. We now have addendums that you can use just attached to the residential purchase agreement. None of you here are commercial agents, but there is a commercial purchase agreement as well. The other one that we don't run across too much, but we may in the future, and that is a contract called a Notice of Default Purchase Agreement. And that is used when you have a property, there's four elements where the seller's property is subject to a notice of default, meaning a foreclosure has been initiated. The first formal step is the notice of default. So if a notice of default has been recorded on the property and that property is owner occupied by the borrower on the loan that's subject to foreclosure. And it's a single family 1 to 4 unit property. And your buyer is an investor, meaning they're not going to own or occupy the property. If those 4 elements apply, you have to use the notice of default purchase agreement. And there are significant sanctions, monetary and prison time, for not using that agreement, because that agreement has a 5-day right of rescission notice to the seller. So all sellers who are subject to foreclosure, who are occupying their property, and an investor's buying, even after they accept that offer, they have 5 days to rescind the contract. And the reason for that is the consumer protection law is to protect sellers who are in financial distress from being taken advantage of by an investor. Investor coming along and say offering a very low price for the property, and them thinking, oh, I'm under, property's going to be, I'm going to lose this property, I better take this deal. And then after they enter into a contract, maybe they talk to a friend or an attorney or something and realize this is a terrible deal, you need to get out of it, and they can, okay? And that notice is in that notice of default purchase agreement. So should you find yourself in a situation where if you're dealing with an investor, that's your first element right there. So then you have to be aware of the fact, that if you've got an owner occupying a property with a notice of default, you've got to make sure you use that agreement. Now the question always comes up, well, what happens if there's no notice of default when you enter into the contract, but then while you're in escrow, there is a notice of default recorded? You got to go back and create that new contract again. Okay, it could happen. How are you going to know if the property is subject to, has a notice of default recorded? In most cases, you're going to see it in the preliminary title report. And that's one of the reasons why it's so beneficial to have listing agents open pre-sale escrows and have preliminary title reports run, so that you as a buyer's agent, when you have a buyer interested in a property, you can look at the preliminary title report and see what is the status of the title and what has been recorded, okay? As a listing agent, you need to be aware of that. Obviously, if you're going to meet with a prospective seller, one of the first questions you want to find out from someone is, why are you selling? And if they're in, quite often, you can run into sellers who are selling because they are in financial trouble. It was more prevalent back in the mortgage meltdown days. We dealt with a lot of foreclosure properties. See if we can get that picture back here. Yeah, okay. I can see you guys all staring at the screen, so I knew something was going on. I knew something was going on back there. So just keep that in mind. Like I said, it may not come up a lot. Usually what will happen in a real segue real quick, usually what will happen when you've got a seller in financial distress, they're usually in denial, they're usually embarrassed, and what will happen is that you'll ask them, well, you're in foreclosure, what's the status? Well, I'm not really sure. Well, have you received anything in the mail? Oh yeah, I have. And then they'll walk away and they'll come back. I've had people come back with a stack of letters that thick, and they haven't opened a single one of them. They're just in denial. They just put it away like it's going to go away, and so then you have to sit there and proceed to open up all these envelopes, put them all in chronological order, and figure out, well, what is going on here? Oh no, your house is going to sale tomorrow. That's a little tough one to deal with. In any event, so first thing is make sure you know what type of property you have and that you're using the right contract. The question comes up, or some of you may be thinking, well, what about residential income? Is for this contract that we're using today is for a single family dwelling, be that a detached single family home, a condominium, a townhouse. If you have a duplex, triplex, or a fourplex, then you're using the residential income purchase agreement. And remember, when it comes to doing your agent visual inspection, you do a separate visual inspection of each unit. You don't try to combine them all into one AVID. You have a separate AVID for each unit. Well, what's popular today? What are people building in their backyards or attached to their houses? ADUs. Well, how do you handle the ADU? The easiest way to handle the ADU is this. If the ADU is occupied by a tenant, use the residential income purchase agreement. Treat it as a 2-unit property. And you're gonna do, again, separate AVIDs for each unit. If it doesn't have a tenant in it, if it's vacant, or it's just, it's a family member, they're not a tenant, it's okay to use this standard purchase agreement, but again, treat it as a separate unit for your visual inspection. Don't try to combine it.
So separate for ADU only?
Yeah.
Your other resident would be?
Residential income, you could, if it's got a tenant in it, residential income's gonna be okay. But if it's vacant, or it's a family member using it, it's okay to use this contract, okay? But when you do your visual inspection, make sure you do separate visual inspections. The other thing you need to make sure, and we've had this happen, is when it comes to pest control inspections, an inspector's not going to inspect a detached structure unless you tell them to. So if you have a detached ADU, it's not gonna get inspected by pest control unless you tell them. And if you need to make sure your property inspector needs to be told, inspect that detached ADU. Same goes for garages. Don't assume that the inspectors are gonna just naturally inspect it. We had a major issue in a transaction about a month ago or so, where none of the inspectors inspected a garage that was converted to an ADU. And there were issues with that ADU that didn't come up until after close of escrow. Now, my position was, shame on you, inspectors, and it was the notable company in San Jose that does all 3 inspections. Shame on you. You should have asked the question when you got to the property, do you want these inspected? They didn't do that. They just went ahead and ignored them.
Was that an attached garage or detached?
It was detached.
Oh,
It was a
okay.
detached garage, it was converted to an ADU. It had roof leaks, it had all kinds of problems. It never got inspected.
And if it's an attached garage, will they do the?
Oh, yeah, attached structure, yeah. If you read the contract, attached structures are inspected.
Was it pretty obvious that it's an ADU, or it was just like a
Oh,
structure?
yeah, oh,
It
yeah.
was- Okay.
But they didn't even go look at, they didn't even look at it. They didn't even ask, do you want that inspected? Well, who was really at fault? The listing agent.
The listing
When
agent.
the
for not
listing
being
agent
there.
ordered the inspections, the listing agent should have told them, oh, by the way, we've got a detached garage converted to an ADU, please make sure you include it in your inspection. That never happened. Buyer's agent didn't, they didn't consider it, no one thought about it. Escrow closes and then it's got roof leaks. So it was a messy situation. There was kind of fault to go around, around almost everyone.
How was it resolved?
I don't think it's resolved yet. At least I haven't been updated yet as to where it stands.
So what you're saying, if there's an ADU, you want to use the residential income?
If it has a tenant in it.
If it has a tenant?
Yeah, because you basically have a 2-unit income property. That's one way to look at it. It really isn't gonna make that big of a difference at the end of the day, because with if you've got a tenant occupied, if you're gonna have a tenant occupying the house or the unit, you're gonna use the tenant occupied property addendum, and that's gonna cover all the things that are important in the thing is,
Does it cover the one form for the?
tenant estoppel, yeah, the tenant
Estoppel.
occupied property, yeah, you've got a copy of that. No, it includes the tenant estoppel certificate. that's why, if you use the resident income, you know it's covered, but the TOPA has tenant estoppel in it as well. And it asks for income and expense statements and rental service
Yeah,
agreements.
right.
So the TOPA, the tenant occupied property income, asks for the stuff that you would be in the residential income. You know, so that issue of forgetting the tenant estoppel isn't as great, assuming you read the form.
So would you use this if the house is owner occupied?
No, if the tenant, yeah, that would apply to the ADU.
Yes,
The TOPA would apply to the ADU, if there's a tenant in it, yeah. So you could use this as a contract, use the TOPA if you've got a tenant in the ADU.
Or any property's got a tenant.
Well, yeah, no, yeah, I'm saying, but I'm trying to, we're just discussing he said owner occupied property, okay? Yeah, so you could use the TOPA as to the ADU.
Okay.
That's what I'm saying, you can do it either way, not, one isn't, you know, you get the same result.
What if they're renting out the garage that's attached, but?
Well, you shouldn't be renting a garage, that's not a.
It happens. It happens.
That's not, I know, but that's an illegal
Okay.
dwelling.
Okay,
You know,
see, I didn't know
see,
that.
that's a huge liability issue for people, that people still don't appreciate. I'm amazed how, you know, the ghost ship case in Oakland should have woken everyone's eyes up to renting out illegal structures, but people still do it.
So I didn't know that, so a garage is legal to rent out, I mean, you always.
No,
hear
it's
that.
it's not certified for occupancy. It's a dangerous room to be sleeping in.
Yeah, because you know, sometimes they always say garage converted to.
Yeah,
this.
well, you can do a legal garage conversion with permits, but there's certain things that need to be met. Like if you've got a furnace or a water heater in the garage, that has to be blocked off from the unit, from the rest of the garage, and most people don't do that.
Okay, so
You
you would
gotta-
have to check, if they say garage converted, then you would check.
You've got to
see
check, see if it was done with
permits.
permits or not.
Yeah.
If it wasn't done with permits, then it's as if it's illegal, it doesn't exist.
So if it's done with permits and it is legal, would you use this?
If there was a
With the garage?
tenant occupying it, yeah.
'Cause, all right.
If you have a tenant in anything, you've got to have an agreement that addresses the tenant.
All right.
Yeah.
I have a question, if the seller is not aware of conversion of garage having permits or not.
They can only disclose what they're aware of. So if they don't, if you can tell it's been converted, it's got a kitchen in it, you know, if it's got stuff, you can tell, you know, it's got a bed in it, you can tell, you know, maybe they've tried to seal off the door. If you can tell it's been converted and the seller's unaware, what should you do? The buyer should go to the city and check the permits and see, does it have a permit or not? And if it doesn't have a permit, then they should not be renting that out, they should not be occupying it, they should be converting it back to a garage or going through the steps to get it permitted so that it is legal.
Can they have problems down the road, the buyers, if they would be like, okay, I'll buy it the way it is?
Yeah, they could have problems.
So
Well,
you
they could
should
have,
work-
well, it depends on how they're using it.
So you should warn them about it.
So could
Yeah.
the seller. If somebody died in there.
Yeah, exactly, no.
Yeah.
Yeah, you got major issues. I mean, it's a,
I would advise the seller to go down and check the permits. And if he doesn't
well,
know.
no, the seller doesn't have a duty, the seller
I
doesn't
know,
have a
but
duty, no, the
they
buyer
have-
has the duty to do that.
They have a liability.
Well, yeah, but they don't have a duty, they don't have a liability to, they only have a duty to disclose that which they're aware of. If they didn't do it, if they bought the house and it was like that, and they only know what was disclosed to them, if they've never gone and checked permits, they don't have a duty to go do an off-site permit
Okay.
inspection. They only have a duty to disclose that which they're aware of. But the buyer should be the one that should be going and checking on the permit status during an investigation contingency period, or before they make the offer. Remember, we're talking about reviewing public records. There was a case where, the buyers had removed all, had been disclosed, that the seller disclosed that there had been an addition, and there was addition out of the house, and they didn't know if it had been done with permits or not. They weren't aware, because it was done before they owned the house, and there was no disclosure one way or another when they bought it. And the new buyer removes all contingencies, goes to the title company, signs closing papers, and on the way home, husband says to wife, honey, we got a few minutes, why don't we go stop by the city building department and check out the permit records? And you can imagine what they found out. You know. There was no permits, okay. But it was too late. They'd bought the property as is, had an investigation agency, had removed the investigation agency, so now they assumed all risks. Wasn't a smart thing to do. So again, if there's ever any question about, the biggest issue with permits, I mean, you can get a permit after the fact, but it can be difficult to do depending on the nature of the addition, because you gotta provide drawings of what you did. Sometimes in the contractor not around, you can't do that. The biggest issue is insurance. If there's a problem with a property, let's say there's a fire and it's tied back to electrical work done without permits, insurance carrier is going to likely deny the claim, meaning there'll be no insurance money to rebuild that house. Imagine if it burned the house to the ground. That would not be a good situation. As well as the liability issues that could come if you were renting a non-permitted room to a tenant and something happened to that tenant. You'd have civil and criminal liability in that situation. So be very careful when you're dealing with non-permitted additions. Now with that said, kind of going off on a tangent here, but there's a lot of new people. With that said, an appraiser can give value to a non-permitted addition as long as it was built in a workmanlike manner, meaning it was built the same as the rest of the house. They can give value to it. But you've got all these other issues with insurance and permits and all these other things going on that a buyer needs to understand. We get all excited because, oh wow, it came in at value at the price because they gave value to that non-permitted addition. So that's all great for the buyer being able to get a loan to buy the property, but they're still sitting with a non-permitted addition. If they went to do another job with permits and a city inspector came in and noticed it, went back to the office and checked it out and said, oh, this doesn't have permits, he could notify them, hey, you've got to get a permit for this or you've got to remove it. They've got the power to do that.
Yeah.
So remember, there's good and bad things with permits.
Well, I want to add to that, my father-in-law did an addition, he's a contractor, and no permits, and the neighbors didn't like each other, and they called, and
Yep.
he had to go and tear down the whole structure.
Yeah.
It's like that.
That's, the cities rely on what their own inspectors observe, or they rely on citizen complaints. Yeah, I mean, they've got Google Earth, they can look and see what's going on, but citizen complaints will be triggered. All right, moving on. When we get to the paragraph 3 is what we call the grid, and the grid talks about a lot of different timelines and so forth. So what I'd like to do is I'd like to start with the whole notion of the definitions of days and counting days, so that you understand this whole concept as we go through all these time periods. So turn to page 13 of the purchase agreement. And look up at the top at paragraph I, which is actually highlighted in orange. Okay, first of all,
I guess you can't change it up there.
yeah, I can. I just haven't gone to this
Oh.
yet.
Keep it online.
What's that? Actually, drop down to J. Day or days means calendar days or days. So it means calendar days. There's one place in the contract that refers to business days. Business days are all days other than Saturdays, Sundays, and holidays. The only place in the contract that refers to business days is on the first page, paragraph 3D1, and that's talking about the time frame for putting your deposit in escrow. So that's the only place we deal with business days. All other references in the contract are to days, which means calendar days. Okay, but it goes on to say, however, delivery deposit is based on business days. I get that question a lot. When the contracts, if anywhere it says day or days, that's calendar days. I think what confuses people is when it comes to counting days and figuring out when a contingency period ends, that it can't end on a holiday or a Saturday or a Sunday. And that's what I think kind of throws people off. So go back to counting days. Here's how you count days, and this is kind of a long, drawn-out explanation, but it's done this way because people still have questions and don't understand what we talk about when it comes to counting days. So counting days is done as follows. The first day after an event is the first full calendar date following the event, and it ends at 11:59 p.m. So whatever day we're referring to, if it's, say, 7 days after acceptance, that 7th day is the full day, and it ends at 11:59 p.m. We don't have any time frames that are like 24 hours or 48 hours. We used to have a notice to perform that had an hour increment in it. That's no longer. It's all based on days. Okay? For example, if a notice to buyer to perform is delivered at 3 p.m. on the 7th calendar day of the month, or acceptance of a counteroffer is first received at 12 noon on the 7th calendar day of the month, then the 7th day is zero for purposes of counting days. Okay? To respond to the notice of form or calculating the close of escrow date or contingent removal date, and the 8th of the month is day 1 for those same purposes. So most of our time frames are based on X days after acceptance. So whatever day is acceptance, the day of acceptance is day 0. You start counting the next day.
Well, is it safe to say that the time frames don't matter, like when it says 12 noon?
Doesn't matter. Doesn't matter what time.
Doesn't matter what time, yeah.
Because the day ends at 11:59 p.m.
Yeah.
I remember one time an agent got a notice to perform at noon, and it was for 24 hours. It was supposedly for 24 hours, and the agent was freaked out. She called me about 11:45 and said, "Calm down. You have till 11:59 p.m. That the agent that told you, if you don't, the agent said, listen, if you don't respond by noon, we're canceling the contract." No, that's not what the contract says. You have till 11:59 p.m. on that last day. Doesn't matter, the hour of the day is irrelevant. Okay?
To deliver like email, how long does it deliver by 11:59 p.m.?
Yeah.
Oh.
All calendar days are counted in establishing the first day after an event. All calendar days are counted to determine the date upon which performance must be completed, ending at 11:59 p.m. on the last day for performance. Does everyone understand what we're talking about here? If you've got a contingency that's to be removed, let's just go by the default. Contingency to be removed 17 days after acceptance. Today's acceptance. Tomorrow's day 1. We count out 17 days. Now, assuming that 17th day is not a weekend or a holiday, the buyer has till 11:59 p.m. on that 17th day to remove the contingency or cancel the contract. Okay? If a
So
buyer
weekend?
was, what's that?
You're excluding weekends, you said, and holidays?
Yes, if we haven't got to that part yet. That's coming up in the next paragraph, once we're in contract. But again, when you count days, you count out, and whatever the day for performance, the last day for performance ends at 11:59 p.m. That holds true for a notice to perform. Seller issues a notice to perform, the buyer gives them 2 days to remove a contingency. The buyer has 2 days all the way to 11:59 p.m. on that second day. Doesn't matter what time the notice came in. Notice could come in any time today. Come in right now, come in at noon, come in at 5 o'clock, come in 11 tonight. Doesn't matter what time it came in. Day 1 is tomorrow. Today's Wednesday, right?
Yeah.
Okay, I'm still on vacation mode. So day 1's tomorrow, day 2 is Thursday, and day 2 is Friday. If a notice of perform came in to say remove a contingency in 2 days, the buyer would have till 11:59 p.m. on Friday. Now, if the buyer doesn't remove the contingency, doesn't cancel the contract, the seller can cancel at midnight.
If they so.
Yeah, if they wanted to. Because that day's over. So that's what you always have to remember when you represent a buyer. You gotta make sure you either take action by 11:59 p.m. or you request an extension. You can always request an extension. Okay? That's the other thing to consider, depending on the circumstances. Maybe you're waiting on something from the lender on the loan contingency. You go, oh, we'll have it for you tomorrow. Well, I'm supposed to do something by 11:59 p.m. Well, pick up the phone and call the listing agent and say, hey, what you want us to do is, we can do it, but we're not gonna be able to do it till tomorrow. Can you give us one more day? Because you want to eliminate the seller's ability to cancel the contract if the seller is acting like they're going to cancel the contract. Okay, moving on. Here's what's really important. After acceptance, if the scheduled performance day for any act required by this agreement, including close of escrow, lands on a Saturday, Sunday, or legal holiday, the performing party shall be allowed to perform on the next day that is not a Saturday, Sunday, or legal holiday. They refer to that as an allowable performance day, and ending at 11:59 p.m. This comes up, so what you need to understand, when you write an offer and you end up with an acceptance and you end up with a contract, the first thing you should do is look on the calendar and count out when your contingencies expire. What day does that period run? Because if it hits on a Saturday or a Sunday, or Monday's a legal holiday, you have till Tuesday. You actually have 3 more days. And that can happen when you just run it out on a calendar, and if it's 17, could land on a Saturday, Sunday. And we've had them fall on, and the same thing goes with a notice to perform. When you're issuing a notice to perform, you've got to remember, you issue a notice to perform. We've had where notice to perform was issued on a Friday of a 3-day weekend. Well, the buyer had 4 days, didn't have 2 days, because the second day fell on Sunday. Can't make them do anything can't make them perform on Sunday. Monday was a holiday, can't make them perform on Monday, so they actually got till Tuesday. So they had a full business day to satisfy whatever it was that the seller was upset about. So you got to be mindful of that when you're deciding whether to issue a notice to perform. Well, how many days are we going to give them, and what day do we do it? Remember, you have to give the other side a reasonable time to perform. Just because the form says 2 days doesn't mean it's reasonable. Okay? You've got to look at the situation and decide what is a reasonable time given the circumstance that they're in. And one of the reasons for that is because in all contracts in California, they contain what's called an implied covenant of good faith and fair dealing. The parties have to act in good faith. So if you know the buyer's having an issue satisfying a contingency, and it's no fault of the buyer is doing everything they can, it's usually the lender that's dragging or lagging, okay? You got to be careful when it comes to issuing a notice to perform. You've got to take the circumstance into consideration to determine what is a reasonable time given the situation that the buyer is in. Because the judge won't take kindly to you trying to cut a buyer off at the knees when the buyer's has not done anything wrong, is doing everything they can. It's a third party who is the cause of the delay. So you always got to remember that. That implied covenant of good faith and dealing overrides everything that goes on and applies to every aspect of the contract. And quite often, we will rely on that. A lot of times when it comes to analyzing an issue, it comes down to, do we have an issue of good faith, a party acting in good faith or bad faith? That may help trigger what the possible outcome is of the issue. Lastly, for purposes of close of escrow, any day that the recorder's office in the county where the property is located is closed, the close of escrow shall occur on the next day the recorder's office in that county is open. Close of escrow is considered day 0 for purposes of counting days seller is allowed to remain in possession if permitted by this agreement. So they're talking about a seller rent back. You don't count the close of escrow day, it's 0. Day 1 is the following. If escrow closed today, tomorrow's day 1. If you have a seller is going to be 29 days or less, you start counting 1 to 29. The day after close. You don't include the day of close.
Can I ask
Legal holidays. There's an actual California Civil Code statute that names all of the legal holidays. Okay, if you have a doubt, you can. If you don't want to look up the statute, just check with your escrow officer to determine they know all the legal holidays. Valentine's Day is a legal holiday. Let's go figure.
Really?
Yep. Yep, I had a case, I had a transaction where Valentine's Day came into play, and I had to look it up to confirm it. Yep, there it is. It's listed as a legal holiday.
Not Mother's Day.
No, Mother's Day and Father's Day, no, but Valentine's Day, was it Valentine's Day or was it Columbus Day? I'm trying to think. May have been Columbus Day, now that I think about it. It was kind of an obscure holiday, and then I looked it up and go, oh, it is a holiday. Actually, maybe Columbus Day I'm thinking of. Anyway, you had a question?
Well, going back to paragraph C, 3C, expiration of offer, the default is 3 days, calendar days.
Yeah, but remember that this pre-contract, it doesn't matter. In the negotiating the contract, you don't get into that.
Really?
No.
Strictly calendar day.
So
Yeah.
the seller.
Because
could
it's not a contractual performance because you don't have a contract yet.
So the seller could have it for a week.
Seller have what for a week?
The offer, expiration of offer.
No, it expires 3 calendar days after buyer signs the offer.
Right, so the offer expires
Yeah,
in effect on the 3rd calendar
Correct.
day at 11:59.
correct.
So this is probably one of the biggest things that's ignored.
Right,
all
well,
the
yeah,
time.
and here's the issue. What Jerry's talking about is the default in an offer is that the offer is considered revoked after the 3rd day after the buyer signs the offer. Okay, now there's a presumption that you present the offer right away, and the seller's got it right away. Well, what happens after the offer is revoked? The offer cannot be accepted. Now, if the seller's going to issue a counteroffer, there is an acceptance, but it's subject to a counteroffer. So it really doesn't matter if the seller waits and issues a counteroffer. If the buyer is willing to go forward, that's fine. The issue is if the offer has been revoked by passage of time. Let's just say it's day 7, the seller's still sitting there with it. The seller goes, oh, I want to accept this offer. The buyer can say, oh, I'm sorry, seller, you're too late.
So that needs to be addressed then on an addendum.
Well, it would, yeah, you would need to memorialize that both parties agree that we have an agreement, even though that the time has lapsed.
So
Now,
this-
if you're a seller's agent, you don't let that time lapse. If you can't respond within the 3 days, you call the buyer's agent and you ask for an extension of time to respond to the offer. That's how you handle it. You don't just let it pass. But because especially in this market, your seller may very well want to accept that offer, but they can't. They're out of luck if on day 4 the buyer says no, it's too late, and the buyer can say that because by its terms the offer was revoked.
And this is a formal extension of time or just verbal?
Yeah, no, you should do it in writing. Now, memorialize it in writing some way. Now, what I do is, and I do this a lot in the multiple offer situations where I'll get all these offers and I'm not going to be able to respond to any of them within 3 days. And I see some of them have shortened the time frame, which drives me crazy. It's like, you have no idea what I'm going through and you want to shorten the time on your offer. I have to go through them all and I look for the ones where if I think I'm going to respond within 3, but I see some that are shortened, I got to call up the agent and say, hey, I can't respond to your offer within this time frame. I need an extension of time to such and such day. And I'll usually say, give me an extension of time till, say 10 p.m. on a certain day. And then what I do is, if I do issue a counter, and in most cases we're not dealing with acceptance of offers, we're dealing with counter offers. Then in my counter offer, the first line of my counter offer memorializes the agreement that we made. It'll say, buyer hereby agrees to extend seller's time to respond to buyer's offer on such and such day by such and such time. And then that's line 1 of my counteroffer. So that's how I memorialize the agreement to extend the time. And then the buyer got that counteroffer. It's the first thing they see. Well, if they've got any issue with it, that would be the time to bring it up. But it's never come up as an issue.
It usually
But the other way you can do it is literally do an agreement, have an agreement, do an addendum. If you're not in contract, you do an addendum that provides for an extension of time. That's the best practice. But again, if the seller's not going to accept buyer's offer, it's not the end of the world. Yes, technically the acceptance, the offer's expired, but it's the buyer's prerogative to decide whether they want to continue to go forward with that counteroffer. They don't have to if they don't want to. They can ignore it. But if they do want to go forward, the buyer wants to go forward and negotiate, then that's fine. Basically what you have is called estoppel. In other words, if the buyer's offer technically expired, but then the seller issued a counteroffer on day 4, day 5, day 6, and then the buyer gets the counteroffer and goes, yeah, this is cool, and buyer accepts it, well, at that point, they're stopped. They basically, from going back and arguing, oh, this is too late. No, you just agreed to it. You've agreed to it. You can't go back now and try to argue that the counteroffer came in too late. That's why it's not that big of a deal if there's a counteroffer. The issue, especially given this market, is if the seller's got an offer on the table that here's a typical scenario. You get an offer right away on a listing, but you're thinking you may be getting some more offers, so you want to sit on that offer. You don't want to accept it right away. That's in today's market. So then what do? Well, you better protect the seller's right to accept that offer by extending the response time. Because if you don't, who knows, that buyer, in 3 days, that buyer might be off going to, squirrel off to another property, and you've lost them. So you want to keep them, you got to keep them in the running.
We have a form now called the extension of time addendum.
Mm-hmm.
That probably is the one that should be used
Yep,
as,
you can
as,
use that, or-
as opposed to an addendum.
Well, the extension of time, yeah, you could use that too. It doesn't have a pre-written paragraph for extending the time to respond.
No, it doesn't.
No, it
I'm
doesn't,
looking
yeah.
at it right
No, it
now.
doesn't have that, but, yeah, you
But
could
it
use
says-
you could use the ETA
It
or a
says
regular
Paragraph
addendum.
3's other extensions, the
Yeah.
time
Yeah.
for acceptance.
Right.
Which
So the
would
buyer-
be-
While we're on, is that-
The buyer's agent could use either the extension of time or addendum if they.
Does the ETA refer to the purchase agreement at the top? Does the ETA refer to the purchase agreement on the top?
ETA, yes, says following terms and conditions are hereby incorporated and made part of California residential
Okay,
purchase
yeah,
agreement.
all right, so it has that in there at
So
the
then
top,
the
right?
paragraph 3 says other extensions to time
Right.
for, and you would type
You can do
in
that, yeah,
seller's acceptance.
correct, yeah.
Shall be extended.
Well, the expiration of the offer would be extended. Before I forget,
They've got more forms when we know what to do with.
well, yeah, it was 93. Before I forget, it's come up over the last month or so within the legal circles of the California brokerage community and so forth, that the addendum form is being improperly used in a lot of cases. And here's how it goes down. Technically, an addendum should only be used as an addendum to an existing document. For example, there can be addendums to an offer, okay, that are referenced in paragraph 4. 4A has addendums that the agreement is subject to, that the offer is subject to, okay? And so addendums can be added. What's being expounded now is that once you have a purchase agreement and you want to make a change to the purchase agreement, you don't use an addendum. You use what's called an amendment to an existing agreement. The form.
Everybody uses an
The form,
addendum.
I know, the form AEA. That is the correct way to modify an existing purchase agreement. You don't use an addendum form is not used once you have an agreement. You use form AEA, the amendment to existing agreement. Now, it's gonna be a tough one to get everybody on board doing that, but that is the correct, proper way that it's to be done. That AEA form. And remember, the nice thing about that AEA form is it's set up, and you can have two situations where you want to use an addendum. One is the parties have mutually agreed to a change, but quite often you've got one party proposing a change, which, then that's when you get into what I used to call the dueling addendums. The AEA form is set up for a proposed amendment, and it has language for how to respond to whether that amendment's going to be part of the contract. So it covers both situations. So I'm just sharing that with you because this has kind of been filtering through the brokerage community over the last 30 to 45 days. You're gonna have people making a big issue about it. I'm just explaining to you why they're doing it, okay? Because it's come down, and CR Legals is on board too, saying addendums are being improperly used. Once there's a contract, you shouldn't be using an addendum. And there's third parties that are saying, lenders and everything, oh yeah, we need an addendum to the contract. That's just how everyone's always taught. But to be technically correct, you should be using that amendment form, once there's a purchase agreement, okay?
It's not showing up.
The AEA
Yeah.
should say it's called amendment, well, it may say
Oh, amendment.
amendment to existing agreement, that's the AEA.
Yeah, amendment.
Yeah, amendment to existing agreement, yeah. That's what you really should use when you're modifying an agreement, once you already have the agreement.
So what
That makes
should we use addendums for?
Addendum would would be like, you've got a standalone form that you want to add something to.
Yeah, there you go.
Oh, yeah, yeah.
That's an addendum. An
Yeah.
addendum is, you've got this form, but I'm adding another form to it.
Yeah, when I was
And that-
typing
Yeah.
on a
Form
contract,
is
it automatically added addendum to that.
AEA-1 or whatever, AEA, not.
All right. I think we're good for now on day. So everyone understands days and business days and how to count and so forth.
So
Because
business-
I get a question on that, I get about one a week. People still don't understand, oh, how does this work? I said,
So business day is just for deposit of funds.
I'm sorry?
Uh,
Business days is only deals with the initial deposit. That's the
Yeah.
only place the contract says business days. Beyond that, it's all calendar days. But again, once you're in contract, if the last day for performance lands on a weekend or a holiday, you go to the next day,
Yeah.
which is typically a business day. You know, because a holiday or a weekend is not a business day. That's where people get confused, because you keep moving the day out, though that next day is a calendar day, but the reason that's the day for performance is because it is a business day, because it's not a weekend or holiday. So you just be mindful of the weekend, of the months that have 3-day weekends. And when you're negotiating deals, prior to an upcoming 3-day weekend, it may come into play. For a long time, I was a proponent for having a specific day for close. Don't use 30 days.
Okay, I see what you're saying.
Especially depending on your client's plans. We're not there yet, but I always say, when you're sitting down with a buyer to write an offer and you get to the close of escrow time period, you gotta ask your buyer, well, tell me what's going on in your life over the next 30 to 45 days. Do you have any vacations? Do you have any business trips? Do you have any religious holidays? What's going on? Because you need, there's 2 time frames where you need those people physically present. One is, ideally, is for inspections. If there haven't been inspections, you're doing inspections, you want your buyer there for those inspections. But then you're gonna need your buyer there to sign the escrow instructions and the loan documents and all that 3 to 5 business days prior to close. They need to be around. People travel a lot now. I probably deal with an absentee buyer at close once a month. It comes up. They're in another country. Agent never even fought to find out what they had planned, and they don't think it's any big deal. And now, from what I understand, you can't, in China, for example, you just can't walk into an embassy and get an appointment in 2 days to sign paperwork. They're backed up. And I've heard of months and months delays to get, and that's true in a lot of embassies throughout the world. You can't just go in and say, hey, I need a notary to sign the papers. But the worst thing is, what drives me crazy is when the client's on vacation and their hotel's 2 hours or 3 hours from the embassy, assuming they can get an appointment. You just wasted 1 day of their expensive vacation fooling around signing paperwork because you never bothered to find out where they were going to be when it came time to close escrow. It's like, that just drives me crazy when I've got those issues. And it's because the agents aren't asking questions up front. Back when we used to have those big desk calendars, I would bring we did everything in person. I'd bring the big desk calendar with me in the conference room and lay it down. And, all right, Mr. and Ms. Buyer, tell me what you've got going on for the next 30 to 45 days. So we could look at the calendar and figure out, and then sometimes I would specifically say, this is when we want escrow to close, because that's when they're gonna be around. And maybe they're planning to be gone the week after, so this is really important to them to get the closing on this day, not say 30 days after acceptance. Because your negotiations may be protracted. I remember in a similar market to this, it took 9 counteroffers to enter into a contract. Well, how long does it take to do 9 counteroffers? It could take 9, 10, 12 days. So whatever day you thought you were gonna close when you started, gets pushed out almost a week and a half to 2 weeks. That could be a totally different time frame for the client. Okay, back to page 1. So the date prepared is basically a date of reference. If there's going to be a counteroffer prepared, then yeah, you would reference that date for purposes of identifying the offer that was made. But once you enter into a contract, that date prepared is no longer a significant. It's significant in it shows, when it was prepared. The time frame for the expiration of buyer's offer comes when the buyer signs it. The buyer may not sign it the day you prepared it. They may sign it the next day, maybe. That's your controlling day as far as when you start, the clock ticks on the expiration of the offer. (1A), this is an offer from. This is where you name the buyers. Remember, if you have more than 2 buyers, then you're going to use what's called an additional signature addendum to put that 3rd buyer or that 4th buyer or that 5th buyer or that 6th buyer. Use additional signature addendum even when you have more than 2 sellers. This contract is set up for two buyers and 2 sellers. And if you have more than 2, then you use an additional signature addendum.
Can I ask a question?
Yeah.
What's the significance of the date prepared?
It's just a reference. It's just to refer, to the date that it was prepared. Yeah. Some of you deal with investors, and they'll tell you, oh, we want you to add my name or assignee as a buyer. Don't use or assignee in this contract. This contract has a specific assignment clause, and that assignment clause requires that the seller, the identity of the assignee has to be given to the seller, and the seller has to approve of that assignee. So you don't start out with a contract with an unknown assignee. That's why you don't put or assignee in there. And there's still investors out there that want to do that. A lot of times they're doing that is because maybe they're planning to set up an LLC or a partnership or a corporation, and they haven't done it yet. So they in their mind, they're thinking, oh, I want to be able to enter into this contract in my name, and then I want to be able to assign it to my LLC. They can't just do that carte blanche. The contract has specific assignment provisions that have to be satisfied. That's why you don't put or assignee in the offer line. Okay. All right, moving on. Property acquired, that's where you would put the address of the property. You put the city where the property is located. You put the county. You put the zip code, and then you put the assessor's parcel number or numbers. So they actually expanded on this because they know that sometimes there's multiple parcels that are being purchased, and so they've got a provision where you can put more than one AP in there. Okay. And it's really important to do that because sometimes, issues can come up as to what property buyer's buying. There was a case once where an agent showed 2 condos next door to one another, and I don't know all the details, but he wrote the offer on the wrong condo, and the buyer bought the wrong condo.
Quite often addresses are not correct.
Yeah.
They don't identify the
Did you have a
actual
question?
property.
Did you have a question?
Oh, no, I was saying, for sometimes the tax record, the seller record is different from the actual seller, so you just call the agent and say how you want it to be on the purchase contract, or?
Well, no, well, you need to investigate where it gets really kind of tricky is vacant land. There's a lot of most vacant land doesn't have an address yet because it doesn't have a dwelling, so the post office hasn't issued an address. And a lot of times the numbers that you'll see are basically, what we do is we use an address that will come up on GPS. Okay? And it's not an actual address, but it falls within the sequence of the numbers on the street, and it gets you to that property via GPS.
Across
And
the
that-
street.
Yeah, and that's why, that's sometimes, I have a listing like that right now, where and I put in the listing, this is not an actual address, but it will get you to, the GPS will get you there. Okay.
The biggest issue is Castro Valley, because for years they only had a San Leandro post office.
Yeah,
So their address was San Leandro, when it's actually a Castro
Yeah.
Valley, and it's in the county, not the city.
right, yeah.
So it's
Yeah.
two issues there. One
Yeah.
of them is the transfer tax.
Yeah. Yeah, so, and then it says, postal/mailing address may be different from city jurisdiction, buyers advised to investigate. I had one a month ago or so, there's a street in Pleasanton that has two different names. It's got, some people have, like, so we'll just say Court, and the other people have, I think it's Lane or Terrace. I can't remember the street name now, but, and you look at the tax records and there's no uniformity there either. The tax records say one thing, and you go to the US Postal Service, and they, I tend to, usually the post office will be in sync with the tax records, but I've seen them not be the same either. So it can get confusing. Go, well, what address do I use? Well, at the end of the day, if you want to make sure you're getting mail, you need to be using the address that the post office recognizes. And they're the ones who, the post office is the one who actually issues addresses to properties. But sometimes the tax record won't be entirely accurate. And that's why the assessor's parcel number is important, because that's the official description, identifier of the property, is the APN. Does that make sense? Yeah, like I said, it doesn't come up too often, but once in a while we'll have a little issue with that. Agency, they've kind of simplified things for the most part in that, when you go to generate an offer, you automatically get all of the appropriate agency documents, so you can't forget. One thing to remember, though, is that, and it states in paragraph 2A, that buyer's agent is not legally required to give the seller's agent the AD form signed by buyer. Now, we do almost all the time, because we just copy the whole package and send it off. But you don't technically have to give that. And the listing agent, the seller's agent, doesn't need the buyer's agent exposure. And vice versa. The buyer doesn't need the agent goes and give it to the seller. It's not needed in the file. But we're still all prone to want to exchange these documents. And usually it's not a problem, but like I said, seller's agent's not legally obligated to give the buyer's agent the AD form signed by seller. So,
But does it still
if
need to
someone
be-
asks for it, say, I don't have to give it to you, and you don't need it. And if your broker doesn't understand that, just have him read 2A. It's right there in writing.
Does it still need to be signed by the buyer?
Yeah, the agent needs to have it signed by their own client.
But they don't have to
But
exchange
they don't
it.
have to give it to the other. Now, like I said, buyer's agency is almost 99% of the time is given to the other side, because it's part of this whole package that
Yeah.
goes over. Okay? Same thing with the possible representation of more than one buyer or seller. See, all that's important is they each get the document, but you don't have to have that. You don't have to have that from the other side. But we just generally do. It generally gets created.
So
because it's
has
all
it
part
always
of the package.
been like that, or has it that recently changed? Has it always been?
No,
like
that's actually, well, it used to be that, this is what changed. Is it used to be, as buyer's agents, we had to give an agency disclosure to the seller. And we had to have seller signature on either a combined or separate agency disclosure. So it used to be a buyer's agent had to have both. Had to have one given to the buyer and one signed by the seller. But then we had a form that was combined form for both to sign, and that was how we satisfied that. It was the same form given to the seller too. On the seller side, the seller's agent only needed sellers. Okay, well, they did away with that. It's been about, I don't know, 3, 4, 5 years. They did away with this whole, making the buyer's agent give the seller an agency disclosure.
Why?
Because it really wasn't necessary. It was kind of an archaic thing,
Yeah.
and it just really wasn't necessary. And now, like this says, it's just, you just have to have, each side just has to have their own agency disclosure signed by their party. But again, as a practical matter, we exchange the buyers because it's part of that offer package. And usually there's no issue with people, signing it. But you just have to be aware, if you get resistance from, if you represent a buyer and you get resistance from the listing agent who doesn't want to give you the seller's AD, they don't have to. We can't force them. Now, when you're writing an offer, you should know who the seller's broker is. You should know who the seller's agent is, and so you complete paragraph B in its entirety. I still see offers where the buyer's agent only fills out their half. It doesn't. It's like they think like, oh, well, I'm not that agent, so I'm not. No. One element of agency is confirmation. Confirming who represents who, and that's what this paragraph 2B does. So then that means you gotta look at the MLS. Does it have the broker's license number and the agent's license number? Sometimes one's missing, so then you gotta go on the DRE site, pull up the agent's license number. I mean, it's kind of like I have multiple steps when it comes to writing an offer. What do? I print the tax report, I go print the DRE record, and then I look up, if I've got an incomplete offer, I'll look up what's the address and phone number of the broker's office, because that may not be, so I'm getting all this information that may not be there, so that I can fill everything out completely.
It automatically connected. If you put the MLS number, so from Paragon, it fills out automatically.
If it's there. If the numbers are on the MLS, yeah. Yeah, well, see, what I see a lot of times is sometimes both license numbers, if I recall, I think both license numbers are required on input, and just the broker's is required on input. So the agent can leave theirs out, and then you don't have it. So then you've got to go look for it. At least the last time
Are we using the KW Advisor as the firm already?
well, the numbers haven't changed.
Or the name?
Well, once it's official, it's not official yet. No. It's still going through the publication process. No, they haven't, the paperwork has not been I have not submitted the paperwork to the DRE to make it official yet, so we're still using it. Keller Williams Benchmark Properties. So any questions on agency? Remember, if it's dual agency, you check the box, both the buyer and seller. Now, what is dual agency? Dual agency is when either you personally represent the seller and the buyer, or anyone within the office or market center, one represents the buyer, another represents the seller. So anybody that's in the Fremont Market Center, if we have a Fremont Market Center listing and the buyer's agent is in the Fremont Market Center, that's dual agency. So you check the box, both the buyer and seller. Then you put in the individual names for each agent. Now, For a while, at one time, I was the broker for 6 market centers. Was it dual agency? If an agent in Fremont wrote an offer on a listing in Pleasanton or in Danville, was it dual agency? No, because they were each separate entities. They were each separate corporations. The common denominator was me as the designated officer broker of those corporations, but they were each individual corporations. So it was not dual agency, even though I was the broker of both. Because the broker is actually the corporation. And I'm the designated officer broker for that corporation.
So it has to be same broker of record?
No. Same office.
That's same, not broker, the same broker. See,
Brokerage.
brokerage is in most offices of corporations,
Right.
that's the brokerage of record.
Okay.
But they have to
the
have,
same
but there has to
broker.
be an individual, a designated officer as the broker for that corporation.
Because the broker.
And I have personal, even though there's a corporation, I have personal liability as the
Yeah.
broker. But you gotta look at who's licensed. It's a corporate, in most cases, a corporation license. Now you take Coldwell Banker. Coldwell Banker has a whole bunch of offices that are under what's called NRT. And they're all under one broker, Valley of California. Valley of
It was
California.
Long Vanel was the broker for a long time.
Yeah, and so so that's dual agency in their world, because they're all under one big umbrella, one broker. And then they have all these separate offices, but that's technically dual agency. Same thing with Compass. They've got one broker up on top. I don't know how Kathy Maringer keeps track. I'm on calls with her, and it's just, that woman's just, it's just constant chaos with her. You can imagine it's just crazy. I don't know how they can keep track of what's going on. She's in constant mediations, arbitrations, just on a daily basis, just like, because it's just so many agents who just, all right, any questions at this point? Now, 3C, if there's going to be a co-broker arrangement, either on the listing side or the seller side, then that's when you check the box for, did I say 3C, 2C. More than one brokerage represents either the seller or buyer. See additional broker acknowledgement, Form ABA. So when you're going to have co-broker, then you have additional broker acknowledgement, acknowledging that there's 2 brokers representing the seller or 2 brokers representing the buyer. See that from time to time. So now we're starting out with the grid on paragraph 3. I like the orange there. So this form is 16 pages. The parties are advised to read all 16 pages. Well, I would at least hope that you read all 16 pages. Maybe they won't, but you read it. So now we got the grid. What I'm going to do is I'm going to kind of go through the grid. I'm going to go through the grid and the timelines. When it comes to a lot of the detail, we're going to cover that when we get into the actual body of the contract. Otherwise, it's going to be kind of repetitive and kind of out of sync. So 3A is where you state the purchase price. If it's an all-cash deal, check the box off to the right, it's all cash. Close of escrow, you put one or the other. You either put so many days after acceptance, or you put a specific date. And we've already talked about, the pros and cons of that. Okay. You may have a situation where the actual close date is very critical. Let's say you're doing a
1031 exchange.
1031 exchange. Could be running on the end of 180 days. You could have a Prop 19 situation where you've got to close on that second property within 2 years.
I think schools also are very important.
Schools can ask for, proof of residency, they'll want the settlement statement, you gotta hit a deadline. Again, I think a lot of them, it's in August, like late August, there's a cutoff date, and they wanna see an estimate, give them an estimated settlement statement to show you close escrow by that date, and you're good to go. There's probably other ways around that, but that's one of the common ways. In the Prop 19, let's say you got 2 years to finalize the other sale to keep that assessed value low for the over 55. So let's say today's, what is today, 21st?
Yeah.
Today's, God, I'm still on vacation. September 21st. So then 2022, the 2 years ends September 20, 2024. So you've got, that's your timeline. If you want to, let's say you either you sell or you wait to buy, you've got to buy and close by September 20. Let's say you close today on, say, the sale, you got to buy by September 20.
So you don't go one day after
No,
the start?
it's got to be the day before. No, it's got to be, the actual year ends the day before. The 1 year from today is, 1 year from today is September 20, not September 21. Okay. So let's say you buy first. Do a Prop 19, you can buy first. Say you've got the money, you can buy first. You've got to make sure you sell your house. If you close today on the purchase, you got to make sure you close on your rental. Hopefully at this point, you got to make sure you close it on September 20th. That's your deadline. You wait another day, you're out of luck. You don't get the county won't accept the transfer. Jay, just real quick, if you got, I know this doesn't get you a listing sometimes, but it'll get you a client for life. If you got someone with a highly appreciated property and they're gonna have a huge capital gain over $500,000, if they can afford to buy a house now, they're over 55 and afford to buy a house now, you tell them to make that a rental property, and then you rent it out for 2 years, and then on 2 years to the day, you close escrow, you sell it and close escrow, you get to do a 1031 exchange and take a 500 exclusion, and assuming you're not buying a more expensive property, you're gonna be able to keep the assessed value of your old house, you're gonna take the 500 exclusion, and you're gonna be able to 1031 exchange the rest of the proceeds and not pay that extra capital gains tax.
Steve, could you repeat that?
Okay, you've got someone who's lived in a home a long time, has a low assessed value, and is gonna have a high capital gain that's gonna be greater than the 500,000, assuming married couple, greater than the 500,000 exclusion. They buy a house first, and they can buy anywhere in California now, doesn't matter where. Buy a house first and rent the old principal residence for 2 years. Most tax advisors say 2 years. Some will say less, but some say, I think if you sell in month 23, you're probably okay. But they say 2 years, rent it for 2 years. But then on the Prop 19, the transfer of assessed value, it has to be no later than 2 years. So you gotta hit that 2-year date right on the mark if you're gonna satisfy everybody across the board. Again, off the record, I think if you closed in month 23, a few days or a week shy of 2 years, I don't know the IRS is gonna make a big deal out of it, but they could. Some CPAs are really paranoid about that.
So it can be over 2 years?
No, not for the property tax. It can be over 2 years if you're not worried about property taxes. But the goal for most people is, if I've got a low assessed value on the house I'm living in now, I wanna transfer that to the new property and not pay higher taxes on the property I buy. Assuming you're gonna buy a property that for a price greater than your current assessed value. Okay?
It's gonna be a little tricky though, right, to get it sold within.
Well, yeah, I plan to do this, but yeah, the plan is you've gotta, depending on market conditions, you've gotta get that property on the market sooner than you might otherwise to allow time to negotiate the deal and actually negotiate an actual close date. I've kind of been thinking it all through. I'm gonna tell the lender, hey, on paper, we're gonna schedule to close the day before that last day. Cause I want 1 day cushion in case you screw up and something goes wrong. I got one more, cause that's not gonna be the actual day, it's gonna be the next day. You gotta get, the other side's gotta be in sync with you, because it's, but again, personally, I don't think it's the end of the world if you close a week early.
Did you have up to 2 years to do a 1031 exchange?
No, the 1031 exchange that comes after. You've got 45 days to identify and 180 to close. That's another time frame. That doesn't start till escrow closes.
Okay.
All I'm talking about is what you need to do to get up to that 2-year period in order to allow you to do a 1031 exchange. Take the 500 gain and transfer your low assessed value on that rental property, which was your principal residence, to the property you bought 2 years ago. So you don't apply for the transfer until after you closed on both properties.
So you could buy the new property early on and then sell the rental in the 2030.
2 years later.
Yeah, but for purposes of the property tax transfer, you can do that anytime within the 2 years. But most CPAs say if you're gonna convert your principal residence to a rental, you have to hold it for 2 years.
Yeah.
That's what conservative CPAs say. My CPA says that. Which means you've gotta close on that exact day, that 2-year date.
Yeah.
I'm just saying, if I closed 5 days earlier, is the IRS gonna come after me? Cause it's a question of intent.
How
Did
many
you truly
people are
intend?
willing to wait 2 years? Really? A few, but.
Well, no, why not but it depends on market conditions too. What's happening over those 2 years? Is the property going up in value? Is it flat or is it going down in value?
Yeah, there's
I mean, it's a
lot of things.
it's a timing issue. But you could stand to save hundreds of thousands of dollars in taxes.
Yeah.
Well, and remember too, if you've already bought your replacement principal residence, what are you gonna do with the money when you sell the house anyway? Why not put it in 1031 it into a residential income property that generates income? You gotta put it somewhere. Why not put it in a property and pay no taxes? I mean, I've had clients pay $275,000, $300,000, $400,000 in taxes because the 500 exclusion doesn't cover their whole gain because they've been in the property so long. That's a problem with people that been in the houses 30, 40, 50 years. Does that make
I had
sense?
that problem. I paid-
Yeah.
Yeah, I did. I paid the tax.
Yeah, well, I remember when you sold, I saw it, go, man, I bet he's got
Oh,
I said, I bet Jerry's got a huge capital gain, yeah, because the 500 didn't go far enough.
So
Almost.
there's definitely a 1031 exchange. You will have to do a 1031.
Oh, yeah, that's the only way you can
Yeah,
defer the tax.
Yeah.
So you have to set it up, it's a rental property, by converting it to a rental, that's what makes it eligible for the 1031. And then when you sell it, all those remember, you've already bought your house. See, the trick to this is you have to be able to afford to buy the house first. So you already got your new house. You already got your new house, assuming it's your retirement house. You got that. And then you go 2 years, you sell it, and you do a 1031 exchange, and you go find another rental property. Preferably a multiple unit property to generate more income.
So there are two goals, to postpone the taxes on the rental.
To defer the taxes on the sale of the property, which is now a rental property, and transfer that low assessed value back to the house you bought initially.
So you can do that after
Yeah,
2 years?
yeah, you can buy and then sell, or sell, and you can go in either direction. Because you can't apply for the transfer of the assessment until after you've closed on both properties. See, if I buy a property now, but you'll get the credit, you'll get refunded for it because it all relates back. So it all gets, it all works itself out in the wash. Yeah, that actually has been around. since 2005, but it doesn't get a lot of press. I mean, I've told people, my CPA didn't know about it.
It's a fabulous idea.
My CPA didn't even know. I started talking to him, and he goes, "What are you talking about? There's a revenue procedure here. You don't know about it?" I gave him the number. I said, "Here it is. Allows you to use the section 121 exclusion, the 500, and a 1031. Now, understand if you're not worried about property tax transfer, then you have 3 years to sell to take the 500 exclusion. Because remember, we look back 60 months. So once you move out of it, you got 36 months. So say you got someone who's moving out of state, they bought out of state, well then you don't care about property taxes. So now they move out, convert it to a rental, they can hold as a rental for up to 3 years and still do a 1031 exchange and take the 500. Does that make
They can
sense?
do what I did, bought a mobile home.
Right.
I live cheaply now.
All right. We're gonna have, lunch is coming at 1 o'clock, so we're gonna go just a few more minutes and then we'll take a short break and we'll resume again. Get anything out of this? Okay. We're probably we're going off on some bunny trails here, but it's all relevant stuff. I think we kind of exhausted expiration of offer already. Initial deposit amount, we generally, recommend because of liquidated damages, when you're dealing with owner-occupied residents, putting a maximum limit on liquidated damages at 3% of the purchase price, we recommend that the initial deposits be 3% of the purchase price, because most sellers agents or sellers are going to be looking for the maximum deposit amount in the event of a dispute between the buyer and seller. So when you type in the dollar amount, it'll calculate what that is as a percentage of purchase price. So you'll be able, as an agent, you'll be able to look at it immediately and know whether, you don't have to do the math. You can see whether it's 3%. That does that for you. It does say that the percentage number is for calculation purposes only, is not a contractual term. Meaning, if there's it's for some reason they're different, the dollar amount's controlling, okay? And just if you don't know this, when it comes to a check that's written out or however it's done, the longhand amount is what controls, not the number that you write. Okay, it's what's written out. I had someone give me, it was part of my class reunion, someone was donating money and they wrote me a check for $500. And I was in a meeting and I just took the check and put it away. I didn't think much of it. And then when it came time to deposit the check, I looked, he never wrote $500 over in the number sign, but the check said 500.
Oh.
$0. So when I go to the bank and I had a bunch of checks and Teller looked at it and goes, "Oh, this needs the 500." I said, "No, it doesn't." So she left and talked to the manager. Manager came and she goes, "Yeah, you're right. It's okay. It didn't need the number in it. It's the
What
written number."
did it say in the numbers?
It's gonna be blank. It
was blank.
Yeah, it was blank. He forgot to write it in, but it didn't matter because it said $500 written in it. That's what controls. You can have that number could be totally wrong. It's how it's written.
That's the
Yeah.
negotiable instrument.
Sometimes it doesn't even need the signatures.
Huh?
We sent 3 rental checks.
With no
to the
signatures?
restaurant.
Yeah.
Those signatures were missing and they all cashed.
They cashed it, yeah.
Pass anyway.
Every bank has different, The one that drives me crazy is when you got a trust account, and you try to deposit a check that's not payable to the trustee. Well, we can't take this because this is a trust account. It's got to be payable to the trustee. Oh, God, give me a break. They're the same person, But some banks will get, I've had some banks be sticklers at that and others not. Okay, I mean, I actually, it's just depends on the bank. Now, 3D1, you look to the right, you know, that's where it says it defaults to 3 business days after acceptance and the deposit to be by wire transfer. So again, wire transfer is the default. If it's gonna be by some other form, cashier's check, personal check, then you've gotta check the box and write how that deposit's gonna be done. Now, I haven't checked with Lucy. I haven't got an update from Lucy at First American, but she told me about 3 weeks ago that they received a forged cashier's check.
Huh.
So that's kind of scary. I don't know, I haven't heard the detail, but they actually got a fake cashier's check.
What do they think they're gonna get away with? They got 30-day escrow or something, that's gonna show up.
Yeah, I haven't heard how that all ended up, but 3D2 talks about increased deposit. Where this comes up sometimes is when you have a buyer that doesn't have 3% of the purchase price at the time that they write the offer. So typically you're dealing with oftentimes a first-time buyer putting a real low down payment. Maybe they're getting some of their down payments coming in the form of gift funds.
That's interesting.
And they don't even have 3% of it. I mean, they can't even write a check for $500 sometimes. I mean, I've had that happen because or even in a VA transaction, no down payment, and the veteran may not have much money at all. So sometimes you'll say, all right, well, write a check for whatever you can right now, and that'll go in under the initial offer, and then how long will it take you to get the balance, and then you make that an increased deposit. But then when you do that, you got to make sure you use Form DID, which is delivery of increased deposit, and liquidated damages addendum, because the liquidated damages clause in the contract only applies to the initial deposit. If you receive an increased deposit later on, you need a new liquidated damages provision, and that's in that delivery of increased deposit. Very important that you have that. War story. We had a case where they went to mediation over whether or not the buyer was in default and whether or not the seller was entitled to buyer's deposit. They spent all day in a mediation from 9 in the morning till 5. Finally decided, yes, seller's entitled to buyer's deposit. Well, buyer had put up 1% initially and 2% later on during escrow, and their attorneys were going through the file, putting together the settlement agreement, and all of a sudden someone goes, now back then it was called the RID, receipt for increased deposit. Attorney's going, where's the RID? And everyone's looking through the files. There was no RID, no receipt for increased deposit for that additional 2%. Well, what did that mean? That meant the seller was only entitled to 1%. It was like, and it was $800,000 house. It was about 20. It was a big deal then. Seller should have got 24,000, but the contract, there was no RID, so he only got 8. Well, guess who wrote a check for $16,000? The agent. Because, I mean, no one caught it. Neither agent caught it, neither transaction coordinator caught it, neither broker, no one. I mean, there was at least 6 people that touched that file. Because the seller's going, I'm supposed to be getting 24,000, you screwed up. So their seller's agent wrote him a check for $16,000, because that's what he should have got. The devil's in the details. So when it's like, whenever I make a big deal about something, it's usually because it's a big deal, or it can be a big deal.
It's a big deal.
Stuff happens. What's our big phrase now? Shift happens. Okay, it happens. All it takes one little thing, just simple one piece of paper, cost that agent $16,000. That's a lot of money. And it's got a default increased deposit upon removal of all contingencies, because that's one of the arguments that'll be made. Well, until all the contingencies are removed, my deposit's not at risk. So I'll give you a small deposit down and I'll increase it to 3% once I remove all the contingencies. Sounds good, but it forgets one thing. What did I talk about earlier? The implied covenant of good faith and fair dealing. Even with all contingencies still in place, a party could be in breach of that implied covenant of good faith and fair dealing and still be found in default under the agreement. It doesn't matter that they've got all these contingencies, they're acting in bad faith. So it doesn't necessarily hold true that it's okay to wait till all contingencies are removed. But that's a risk you take when you agree to stagger the deposits. Okay, loan amount. You put in the dollar amount, and again, it'll generate what that represents as a percentage of purchase price. You know, ideally, if you don't have mortgage insurance, you want to have 20% down. Then you're not going to have to worry. Buyer's not going to have to worry about mortgage. Anything less than that, it's going to either trigger mortgage insurance, or you're going to have a higher interest rate to absorb the mortgage insurance that the lender's covering themselves. And obviously, if you're doing a VA deal, your loan amount's going to be 100%. You're going no down. FHA typically is, your loan's going to be 96.5% if you're putting the minimum, 3.5% down. Now here's the part that everyone still has problems with, and that is the interest rate. The interest rate is defaults to a fixed rate, or if you check a box, initial adjustment rate not to exceed blank percent. You must insert a number in that interest rate. Section. Your contract is not enforceable without the interest rate stated. And this is still a challenge for people. What happens in a lawsuit, the first thing that happens in a lawsuit, in a real estate transaction, the first thing the attorneys do is they look at the contract to see if it's enforceable, to see if there's a valid purchase agreement. Guess what? If that's blank, the contract is for a contract to be enforceable, there needs to be what's called a certainty of terms. And one of those terms that needs to be certain is the interest rate.
So if you receive an offer without
You
that
counter it.
blank, you just counter?
Yeah, in my counters, I put regarding paragraph 3E1, interest rate shall be, and then I'll put a number, and I'll usually bump it up. Like if like, well, I don't know, where are rates going after today? Well, where are rates going over the next 3 days after today? Let's put it that way. What did the Feds do? Anybody know?
6.27.
What's that? 0.75? They raised it 0.75?
Oh, no,
Basically, that number, right?
No, you said, but 6 and, what'd you say?
6.27.
On the jumbo?
Yes.
Yeah. Yeah, so yeah, they've gone up, yeah.
So you can put in the specific number.
It's anything that is blank in an offer, you put it in a counter offer. I mean, I did a counter offer the other night. The guy, it's like he forgot to fill out the second page. He literally did. So my counter offer went on to a text overflow addendum, and it's like this counter offer was like that long. Because I had to do the whole second page because he left it all blank. He was in a hurry to write the offer. Like, geez.
You didn't ask him to resubmit the offer?
I'm sorry?
You didn't ask him to resubmit the offer?
No, because I was trying to move things along, and he did redo it, but I had already sent it out for signatures. I said, you address any changes you're gonna do, you address them the next time around, and he didn't do that anyway. It's like, oh my goodness.
It's interesting that you've got to put the interest rate in not to exceed X amount.
Yeah. So
And that protects the buyer.
Right.
But it's also not a contract if that's not in there.
Correct.
And
So
enforceable.
so Teresa said to me, right now Jumbo's running around 6.25. I would put 7 in there
Yeah.
to allow for any changes in the rises in the rate between now and the drawing of loan docs.
Provided the buyer can afford it.
Well, yeah, well, that's part of our challenge now, is these rising interest rates, how much flexibility do these buyers have? Because remember, the buyer has to pursue that loan in good faith. So whatever's on here, they have to pursue a loan up to whatever rate is here.
The buyer
So again, so
approves
see, the
bump
challenge
bill.
is in today's market, if you put today's rate in 30 days, if they don't lock in right away, see, that's the other problem is, how soon do they lock in? What's their loan officer, I mean, I think most loans are probably locking them in right away. As soon as they get a contract, they're locked in.
So if the offer has already been accepted with this blank.
You don't have a contract
Still
We can
enforceable.
address it as an addendum, in the addendum.
as an amendment.
Amendment, not addendum.
Yeah,
Amendment.
So now we know amendment, not addendum.
yeah,
Okay.
you should.
I have a situation like that for
Sure.
a mentee.
Interest rates are gonna continue to rise.
Yep.
I've been through these markets in the
Oh, yeah.
past. We're gonna see.
Yeah, well, it's just, we're just not used to seeing them rise so quickly.
Yeah.
Quickly.
Control the
Yeah.
inflation, right?
Okay, moving on, then it goes to, under points, buyer, it defaults to 0 points. Now, I'll tell you that I've seen some of these rate sheets on a high balance conforming that they're not even, there's no rate offered at what's called par at 0 points, not even on the rate sheet. Like, the lowest rate on the rate sheet was still about 5/8 of a point. Didn't even have a 0 points option. So you gotta, depending on your loan amount, see, when we're talking jumbo, we're talking over 900, 970, 800. But when you get under that, you're in the conforming or high balance conforming. There's a different rate structure, which is, right now, is higher than the jumbo. I mean, the first time buyer trying to get in entry level is really getting hammered on the rate, because it's even worse than the jumbo. Probably, I haven't seen a rate sheet in a couple of days, probably pushing 7, because it was already over 6. It was over 6 when jumbos were at 5 5/8, so I know it's. See, and part of it is because Fannie Mae and Freddie Mac, they don't have a big appetite for doing loans right now. That's why they're making the rate so high, because they don't want to do the loan, they don't want to be doing the loans.
Some banks are doing, the convention, they are giving buyers the lower rate of a conventional loan, of the ones that are supposed to be over 900.
Well, what's going on right now is most of your borrowers are not taking a 30-year rate. They're taking a 10-year rate or a 7-year rate or a 5-year rate. And then you've got a lot of sellers who are agreeing to pay points to buy the rate down. I mean, I closed on a deal a few weeks ago where my seller paid 2.4% of the purchase price, which was 3 points, and bought the buyer's rate on a 7-year fix, bought it down from 4 1/8 to 3 1/8. Bought it down 1%. That 3 points bought it down 1%. I mean, it's not actually, a buyer considering a long-term ownership, if they've got the cash, they may want to look into that themselves, even if they don't negotiate it with them, because there's a break-even point where if they're going to stay long-term, it might make sense to buy that rate down, more, because it can stretch your buying power and so forth. So we got so fat and happy with these low rates, we never thought of all these other options because the rates were so low. I've never seen a 30-year that low. But now with the rates so high, you got to be a little more creative when you're deciding which loan to take and how much to pay in points and all of that. But it's all based on long-term ownership. But then you got a lot of people that are doing 5 and 7 years, figuring that the rates may come down at some point, and they'll be able to refi out of it into hopefully a lower rate loan, or that the adjustable won't be that bad when they come. There have been times when the adjustable rates weren't bad loans; they were better than the fixed rate. But a lot of different factors right now. The default for the The type of financing is conventional, but again, if you're doing FHA, remember that's 3.5% down. VA can be 0 down. You've got, remember you've got forms called the, I'm drawing a blank here on the FEAC. Federal, a mandatory clause, the FHA VA mandatory clause, which states that regardless of whether there's an appraisal contingency in the contract or not, the borrower cannot be obligated to purchase the property if it doesn't appraise for the purchase price. So that's what the FEAC form states. So you print that out form, you put the purchase price in there, and the buyer's not obligated, even if there's no appraisal contingency in the contract. That federal law overrides. That's what that FEAC form states. Now, they can the buyer can waive it. If the appraisal comes in low, if they've got the cash, they can still go forward, but they're not obligated to. So that applies to all FHA and VA transactions. Property has to appraise, has to get what's called a CRV, certification of reasonable value. And then HID form is the home inspection disclosure, recommending that they get a home inspection. That's what the HID is. Why don't we stop there? Well, no, let's just finish this page real quick. For FHA or VA, there's a 17-day period for the buyer to submit to the seller a list of lender required repairs. So that's where you don't know what the lender may require, either for FHA or VA. FHA has no Section 1 pest control certification requirement or roof certification. It did in years past, it doesn't anymore. VA does, however. So you should know, if you're writing an offer for a veteran, a VA transaction requires a Section 1 pest control certification and a roof certification. So you should be writing your offer accordingly right up front, rather than having it subject to a 17-day,
But not Section
period.
2 though.
Not Section 2.
Just
Certification's
termites.
on Section 1.
Take care of the termites.
Yeah, just Section 1. Not gonna be termites, fungus damage, dry rot, beetles, carpenter bees. If you got a second loan, that goes in an E2. And yeah, that's something to keep in mind. I haven't really seen where seconds are right now. I don't know if an 80-10. Last time I did the numbers, an 80-10-10 didn't make sense. A 90 made more sense than an 80-10-10 because of where rates were. That may still be the case today. Occupancy type defaults to primary if check, secondary, or investment. People buying a second home can get essentially with the many lenders get the equivalent of owner occupied rate on a second home. So that's where if it's a second home, you want to make sure you check the box because you want to get that better rate. But if it's not primary or second, then it's going to be investment property. It's going to be a higher rate, generally 3/8 to 0.5%. It's going to be higher, okay, on the investment. And then balance of down payment will automatically calculate from the other numbers that you put in, and then purchase price to. All right, we'll take a break. It's 11. Try to come back about 10 minutes, and then we'll go to a lunch.
It's funny, Steve. I don't know how many times I've sat through this class, and I pick up something new every time. And all these other agents that aren't here think they know it all, or they just don't care. They just blow me away.
Steve, I missed that.
They will care once they go
That
to court.
$16,000 mistake, I missed that. 'Cause I didn't do it then over the line. What were you talking about?
The offer was written with an initial deposit of 1%, and then there was an increased deposit of 2%. The money was paid in, but there was no, at that time, we didn't have a DID form, it was called a receipt for increased deposit. And that receipt for increased deposit contains liquidated damages clause. The initial liquidated damage clause in the contract applies to the initial deposit. If you increase the deposit, you need another liquidated damages clause to apply to the increased deposit. Yeah, back then it was and they didn't generate that. So that meant the liquidated damages didn't apply to the 2%. So the seller, won the case, but was only entitled to 1% because there was no RID as to the 2%.
What happened? Did they back out?
Yeah, I've been trying to.
Yeah, the buyer, there was a buyer cancellation, and they were trying to fight that they had some reason. They had spent all day in mediation, finally agreed that the seller was entitled to the deposit.
They lost the deal, I ended up paying money.
The agent that, basically, the listing agent screwed up. So the listing agent should have made sure there was an RMD.
I don't want to take lunch and
Oh.
take it.
Oh, thank you.
Are you with Adrian group or you with somebody? There is that Mojo Housing. Yeah. So I signed up for it ever since I have joined the company, but I maybe I have not consistent, but family and friends,
I mostly go to Zambia.
Yeah, so you work there.
I've got Jackie under hospice now at the house. She's failing fast.
Oh, I'm sorry to hear that.
Horrible.
So sorry. Yeah, I just had a close family friend pass away while I was on vacation. I had a close family friend that passed away while I was on vacation.
Oh.
I saw him on the Friday before I left the next day, and he passed the following Tuesday.
Had they been sick or just didn't?
Well, he had a weak heart. He had an LVAD. He had a weak heart.
Did you know Bob Binion?
Yeah.
He passed away.
Did he?
Yeah, I love Bob. He was a neat guy.
Yeah. Yep.
Bob Binion, Lou Smith, and
Right, yeah.
we used to play poker over at Walt White's house. They're all gone. That's the sad part about getting old.
Yeah,
Jeez.
tell me about it, I know.
So are you gonna rent your house out?
That's the plan.
Where are you gonna move to?
Don't know yet.
And-
Still trying to figure that out.
I was up in Auburn the other day. Whole new world out there. Beautiful, beautiful area. From Roosevelt up.
Yeah.
That's for everybody.
The only problem is the fire
Huh?
insurance. The fire insurance has gotten so expensive.
Well, not in the.
Well,
not-
Auburn, Grass Valley is, well, it depends on
It
where you
depends
live.
where you're at.
Depends on where
If
you
you're
are,
in
yeah.
some major subdivision, there's nothing
Yeah,
around
yeah,
it.
it depends on where you are.
Yeah. I'm looking at tax deeds.
Yeah.
I looked at 10 properties. Took me all day, but I took my little electric car up and it worked out pretty good.
Yeah, cool.
3 years.
Yeah.
And then
Yeah, that's the plan right now.
2 years if you want to.
We'll see how things play out over the next.
You
couple
gotta
years.
feel like a big weight's been lifted off you,
Also take
Yeah, there's been some, yeah.
or a little
Well, I still
sad.
got the broker part of it. you know.
Yeah,
I
a
still
little
got
sad
I
at
still
the
got
same
broker
time.
part hanging over my head.
This is a tough year. You know, in '89, I almost went bankrupt. When the defense industry quit spending,
Yeah.
the government quit spending money on defense. They laid all these men off, they went home, they were at home for a year. My phones quit ringing at my office, and then the earthquake hit.
Yeah,
Yeah. There's things out there just out of our control.
that's right. Yeah, there are.
Completely out of our control. In fact, most of life is.
Yeah, for sure.
Then define, yeah, and define the date The 3 years is, to, finalize the sale of your former, to finalize the sale. You can finalize this, from what I understand, in under 3 years, and after that you have 45 days and then 180. But you have to not sell later than the 3 years, from what I. Yeah. Or there are some, articles and groups, I think it's, a good strategy. So, I know there are groups like Meetups and other realtors that just do this. Anybody, people attend one exchange with a special accountant or special firm to do all the company, all the paperwork.
key, I don't know if there's a key. Downstairs, downstairs.
No, that he's,
Okay.
he's opens all the men's rooms.
All right.
Where is he?
Oh, boy.
Yeah, because then everyone is not only here, it's everywhere. Yeah, we just came from a work, vacation in Hawaii, that was a surprise for my mom's birthday. And then, she never been to Hawaii, was one of her properties. She, and for some reason, just the traffic were very low. I just happened to be maybe in the right period of time. I was-
Did you see that affordability rate in the Bay Area is 16%? Yeah, that, you know, when they did that economic, he mentioned it, and I bet it just flew over everybody's head. I saw it, I said, Bay Area is 16%.
I remember,
That was probably a month or two ago.
I remember back in
But now they are like.
the nineties, I think.
Yeah. So I was.
90s, early 2000s.
And when I came back to there, let me look maybe after.
It was right around
the period of time was just after the
The guy,
school started.
Levy,
and
the economist
just
from
working the
Berkeley,
weather, never rained, it's still beautiful.
he said that,
But when,
he said that the Bay Area market wouldn't be drastically
For
affected
sure, for sure.
unless it hit
And I've
14%.
in,
But that was years ago. That was-
Well, I
that
can
was-
well
that was
imagine
numbers.
that
That
the
was
rate,
numbers.
these interest rates are going up.
And I
Oh, yeah.
saw,
That's gonna come down.
Yeah, yeah. He, you know, he said, he goes, we don't have to worry until it's 14%. But again, that was like 20 plus years ago.
low fare, then we show you the whole month.
Yeah.
So don't choose a day. Low fare, and just month, the month is gonna go. Let's say you try, look at September, you look at October and November, and they will say for this day, leaving is this much, coming is this much. But then you have to go through in the day and see if that low price is actually not available. Could be a 6 o'clock in the morning, or could be a 12, that is, super long. So you have to make sure that that good price is actually, a good trip.
How you doing?
Good, how are you?
I'm doing great.
With, when I go to LA, and I travel a lot,
Yeah.
that makes sense because even if it's that time, it's only like 45 minutes or.
Yeah, yeah, yeah.
But for long flights,
Yeah, yeah, and, or times, like if it's super early and then you have to come to, I don't wanna wait till it's 4 o'clock and, but this, so you'll find good prices for good flights. I'm ready for lunch. Direct flights, and I usually do direct flights.
Yeah.
Even in October, it was like, but the fact is that the same day, so it was like not expensive.
Oh, he was here.
at all, but the.
He was setting up the live stream.
itself is not cheap. Yeah, yeah. His eyes everywhere. But this one, decided to stay in hotel because the air.
All right.
So the demand is great, the ability is.
What's that?
Not so great.
Yeah. Well, you know, then you
The fact
come.
that the demand is great is good.
Yeah, then you compound the interest rate rise with the drop in the stock market, you got a lot of people's damn payments affected too.
We've come up with some creative ways to make things work.
Well, some people, I mean, some people, whenever you get into the, you know, 1.5 million, 2 million, the stock drops and then they have problems coming up with, you know, they don't wanna sell more stock, you know, they don't wanna eat into their stock more than they. and they would rather. All right, moving on. We're on page 2, and we're
Oh, my God.
got to pick it up here. Well, less war stories here.
It'll be done before you know it.
Okay, paragraph 3G1. Basically, this is a new clause that was never in the contract before that actually has a seller credit pre-written. Has a provision for a seller credit pre-written into the contract. So basically it says seller credit if any to buyer, and you check a box, and then you put in the dollar amount, and then it will then calculate that as a percentage of the purchase price. There are limits on the credit depending on the type of loan and basically depending on the type of loan and the loan amount. For our purposes, if you're dealing essentially in the jumbo financing world, a credit can, in a jumbo loan, a credit can be actually as much as 6% of the purchase price. So, but it has to be applied towards closing costs. So if you look over to the right, it says seller credit to be applied to closing costs, or I'm not aware of any or that's acceptable to a lender, okay? Before you're gonna apply a credit for anything other than closing costs, you better get the lender's approval for that credit. Otherwise, your credits are only to closing costs. If you're gonna negotiate, say your buyer wants to request the seller to do some repairs to the property, but in lieu of doing the repairs, take a credit for the amount of the repairs, that credit cannot be, quote, for repairs. That credit is to be for closing costs. So what are closing costs? Closing costs are all of all your title and escrow fees, your proration of property taxes, your homeowner's insurance, your loan points, your lender fees, your appraisal fee, your inspection fees, whole host of fees that are all closing costs. Now you have 2 categories of closing costs. You have non-recurring closing costs and you have recurring closing costs. Non-recurring closing costs are all your one-time costs that are charged at the close. Recurring closing costs are those that continue after close. What would those be?
Property taxes, insurance.
Property taxes, interest, insurance, HOA dues. Those are all what we call recurring costs. Some lenders, there was a time when some lenders would only allow credits towards non-recurring closing costs. Now most lenders will allow credit to all closing costs, non-recurring and recurring. But you need to make sure of that before you calculate how much a credit's going to be. Now what's become popular these days is, with the rise in interest rates, is to get a seller to agree to buy the buyer's interest rate down. Like I mentioned earlier, where I had a seller paid 3 points or 3% of the loan amount to buy the buyer's interest rate down a full 1%. That's an additional closing cost. So that a percentage could be calculated in the credit as well. So let's just say, now people always want to know a number for closing costs. If you assume a 0 points loan, I mean, actual closing costs could run on a 0 points loan. Your actual closing costs, depending on sellers, see, the variable is seller's property taxes. Sellers own a home a long time, they have low property taxes. Sellers own a home a short period of time, they probably have high property taxes. So depending on what month of the year you're closing, the proration of those taxes could be high or low. So that could seriously affect the closing costs. Obviously, if you have a city transfer tax, that could significantly affect the closing costs depending on the city and how much the city transfer tax is, okay? Generally speaking, buyer's closing costs could run anywhere from, depending on purchase price, anywhere from 0.75% to 1%, maybe 1.25%, somewhere in that range, assuming 0 points. Now, as soon as you start paying points to a loan, well, then it goes up. So when you're trying to figure out a credit, if you're trying to do a credit if you're trying to do a credit just for interest rate, remember, this credit is a percentage of purchase price. So in my situation, I said the seller paid 3 points, which is 3% of the loan amount, because that's how points are calculated as a percentage of loan amount. But on the credit side, it's a credit in percentage of the purchase price. If you assume that the buyer's putting 20% down, then a 2.4% credit of the purchase price equals 3% of the loan amount, okay? So that's what you work from. Again, and that 3% of loan will buy the rate down about 1%. Sometimes it depends on where rate sheets are. It might be 7/8, it might be 1 1/8, but generally about 1 point. And you can go to your buyer's loan officer and say, hey, how much buy down would there be with 3 points? And then they can look at their rate sheet and tell you it'll be this % based on the loan the buyer's getting. Well, then you take, if it's 20% down, that 3 points is 2.4% of the purchase price, and that's what you put here. Now, if you wanted the seller to pay for the other closing costs beyond the buy down, you've got to inflate that credit up, say to at least 3%, maybe even up 3 1/4, let's say. Say 3 1/4 purchase price would basically buy the rate down about 1 point and absorb all of the other closing costs, assuming they're all within the normal reasonable range. Now remember, the way the contract says, credits are use it or lose it. If you put a credit in and the closing costs end up less, the buyer doesn't get the benefit of that difference. The seller gets it. Well, you would try to use that credit up on an interest rate buy down. Never give it away. Use as much of it as you can towards an interest rate buy down. Maybe the buyer might even want to add a little money to it, depending on how close they are to the next drop in rate. Because it's in 1/8% increments. But what you really want to do is, if you're contemplating a credit, you want to get with your loan officer and figure out, try to estimate closing costs as much as possible. Try to come up with a number. That's what I do. Is and I think I taught that class. I'd figure out what are the closing costs going to be. I wouldn't guess. I'd figure out what are the closing costs going to be. What are they as a percentage of the purchase price, and then how much of a rate buy down do we want to ask for? Combine the two. That number shows up there. Now, you're going to have 1 of 2 situations here when you represent a buyer. The listing agent may have already, an experienced listing agent may have already talked to the seller, and it's in the listing remarks that the seller will pay it. Okay, or there's been no discussion of it by the seller, but you're looking at the price of the house and it's priced too high and it's sitting on the market, and you're going, here's the scenario, rather than beat the seller up on the price, you offer them a higher price with that credit that nets them an amount that's acceptable to them. It's easier because what's happening is you're getting the house sold too. See, it's better to say, seller, I'll give you this higher price if you pay me this, which gets my rate lower and nets you this amount of money. You got your house sold. Otherwise, just sitting there trying to beat them up on a price, and then you're paying, getting a high, it works. It's a win-win situation because you're bringing them a deal that makes it more affordable to your buyer. Does that make sense? Because if you don't get a different rate buy down, you're looking at prevailing rate, depending on which loan you get. Because right now, buyers are compromising. They're going for 10-year, 7-year, 5-year fix because the 30 years gotten so high. Well, I mean, I'd rather, if I know I'm going to own a home long term, I think I'd rather try to buy the 30-year rate down. It depends on what you think is going to happen with interest rates in the future. It's hard to say. It's hard to predict. It was a little easier to distinguish between the two, 3 months ago, 4 months ago, when rates weren't as dramatically as high as they were now. they've gotten so high. Yeah, again, the seminal question, when you represent buyers, because not all loan officers ask this question of a buyer: how long do you plan to own this home?
That's the key point.
That's the key question, because it's all about cost of borrowing the money for the length of time you need the money. Don't, and see, we just naturally went through the 30-year rate because it was so low. And the differential wasn't that great, but now that rates have gotten high, you gotta ask, how long, what's your plan for this house? Is this the raise the family house that you're not moving in out of for 20, 25 years? Or is this the stepping stone to another one? And that's where you talk about the different loan types. But you could still do the buy down. If the house is sitting there, it's not selling, you can still negotiate the buy down. And the sellers, if they haven't got an offer in 30, 45 days, if you come along with an offer and say, yeah, I'll give you this, I'll pay this price, but I want you to buy my rate down, this is what you're gonna net. It's like, wow, it's a bird in the hand. It's like, you're gonna walk away from that, hold out, you're probably gonna take it. And your buyer's got a decent rate. So you understand that? So again, you've got to translate loan points to a percentage of purchase price, because the contract's set up for percentage of purchase price. But again, you get your help of your loan officer. They'll be able to tell you what you got to work with. Show you where things are. Again, I mean, see, the way I look at it is it's basically taking a buyer and putting them where they would have been 30 to 60 days ago had they bought 36. This is where you would have been had you done it then. But because the rates have risen, we can, you don't want that high rate, we'll buy it down. To then it gives them a better reason to go forward, and probably affects their, obviously affects their payment, their affordability, and so forth. Stretches their buying power. And I'm sure you've all started to see listings where that's in there. The seller willing to buy rate down. It's right in the remarks.
No brainer.
Yeah. It's better than a price reduction.
You and I had spoken about that, and you had talked about that. So one of the homes we had listed, and we had a competing property. It was 3-year-old properties, literally the same thing. That gentleman reduced the price. So and he was in a better location with views, we were not. So we almost forced our hand, we had to reduce the price, but I put that language in there, seller open to that. So actually the folks who ended up buying, the reason they actually reached out, the realtor reached out, because that was of interest to them. We mentioned that, the other folks did not. But because we reduced the price, the first thing I went to, I said, listen, you know what, we're totally open to that. So it's either that or you take the reduced price, but if you're willing to go a little higher on the price, we're willing to. So it wasn't like it was either or. And they chose to stay with the lower price. They worked out the numbers. They thought, to them that was better. Yeah. But without that, we probably wouldn't have even been in dialogue.
Yeah.
Obviously, eventually they may have bought the other property, because I would have bought that other property if I'm paying the same thing.
Yeah.
So it enticed them to start that dialogue, and we were able to close.
Brought them to the table, yeah.
Yeah.
Yeah. Yep.
In most cases, the lower the interest rate, the easier it is for the buyer to buy.
Sure.
So buying the interest rate down for a seller is a really good idea.
Yep. Yeah, for sure. Yeah, as long as the net to the seller is reasonable, and it gets the house sold.
Gets the house sold.
What you need to do, whether you're the listing agent, whether you're the seller's agent or the buyer's agent, you need to educate your clients on it and how it works. Because I know when my seller agreed, on my flyers I printed out these white oval stickers. Seller will credit 2.4% towards interest rate buy down. I forgot how I worded it, and I put it on my flyers that I'm handing out in open houses. Almost every buyer had no idea what I was talking about. So then I had to sit there and explain to them, and I could tell when they got it and when they didn't get it. I said, well, and either I established a relationship with them and then went further, or I said, go back and talk to your loan officer, they'll explain what I'm talking about, to you, so you understand.
How to educate the other agents.
Because they kind of, they kind of, sometimes when you talk about credits, people kind of think it's like smoke and mirrors and stuff. No, it's a real deal. It's, but your seller has to understand that, they both need to understand it's coming out of the purchase price. It's not free money up here, it's not money being pulled out of a hat. It's coming out of the purchase price. All right, moving on, the H1, 2, and 3s talks about verification on all cash purchase, verification of down and closing, and verification of loan application. By default, they're attached to the offer, which you should have those in place when you write your offer. Always make sure on verifications of down and closing, make sure that the names on the documents that are provided match the name of the buyer, that they are, that it is true money that's available to the borrower. We had a case where it was an all-cash purchase, and the buyer provided a copy of a Swiss bank statement with $1.7 million, but it was Dad's account, it wasn't the buyer's. Said, well, no guarantee Dad's going to give him that money. As to H3, verification of loan application, you're looking for either a pre-qualification letter, a pre-approval letter, or a fully underwritten pre-approval. The difference between a pre-approval and a fully underwritten is, lenders can issue a pre-approval based on the receipt of certain documentation and input into their system, and it'll generate a pre-approval based on their credit score and the information that's been provided to them. But an actual underwriter has not sat down and reviewed the package yet. When you have a fully underwritten approval, that means the underwriter has gone through it, reviewed it, conditions have been satisfied, and it's pretty much a guarantee that they're going to get the loan. Pre-approval is, one step short of that, but I would certainly recommend and suggest that you provide, at least a pre-approval letter. A pre-qualification letter typically is just done by a loan officer. Loan officer may not even have all the information. I mean, I've seen letters that turned out to be bogus because they were based on inaccurate information. Back in the REO days, the REO lenders, all offers were subject to pre-approval by our designated in-house lender, and I would take pre-approval letters from major institutions and hand them to our in-house loan officer, and she'd run them and go, they're not qualified. They don't have enough income. So I don't know what income they told the loan officer, but it wasn't their income. They had no business making an offer on a property. So you kill the deal before you even get into it. Final verification of condition to be done 5 days prior to close. We'll get into the more detail of that when we get into the body of the contract. We talked about assignment. That's to be a request for an assignment is to be made within 17 days after acceptance. It's automatically in the contract, but then there's provisions that have to be satisfied there. Okay, L deals with all the contingencies. There can be as many as 8 contingencies in a contract, depending on the nature of the transaction. You generally, if there's financing involved, there's typically going to be anywhere from 3 to 5 contingencies, and then there's 3 others that could apply. So you've got your, and the default time frame is 17 days for all of them. It doesn't mean it has to be 17. You could shorten some of them. You could lengthen some of them. 17 days, you got to check with the lenders whether 17 is sufficient for them. Some lenders can pull it off pretty easily in 17. Some want about 20, 21 days, sometimes 25. Depends on the lender. So I would check with your loan officer before you leave at 17, because you want to make sure it's a realistic time frame. If there's not going to be a loan contingency, you check the box to the right saying there's no loan contingency. In that scenario, you will have from time to time buyers who can get a loan. They have the requisite income, employment, credit. They are going to get a loan. They're gold-plated. Typically 800 plus FICO score, tons of money in the bank. sufficient income, you know they're gonna get a loan. So if you're in a competing situation where you've got multiple offers, you know, you may be able to write an offer with no loan contingency. The only thing that could happen to them, and I've had this happen, is they get laid off unexpectedly. And I did have that happen once on a high-end house right before Christmas. Seller started crying when they found out.
So is that okay to back out of this?
Well, no, your deposit's at risk. Yes, if you put up a deposit and you write an offer without a specific contingency, and your basis for cancellation is that contingency that you removed, you are losing that deposit risk. And, you know, we wrote a lot of non-contingent offers over the last, up until 5 months ago, we were writing a lot of non-contingent offers. Those deposits were all at risk if something happened.
Well, we'll say it's 17-day contingency.
Yeah, if you have a
removed,
contingency, then you're fine.
And then 5 days later lose the job, still.
They're
like,
out of
well,
luck. The deposit's at risk if they can't go through with the purchase. See, there is consequences to removing contingencies.
Yeah.
You don't get, there's no.
So that's just bad luck, it's just like.
Yeah, it's bad luck.
It's
Yeah,
bad
you,
luck.
there's no, you can't go back and go, but, doesn't matter.
Does the seller ever give like some back, or are they like, no? it's
Well, sometimes, there will, you know, it depends on the seller. I mean, I've seen sellers not insist on a deposit. Not too much lately, but I have seen it. I have seen it where they feel sorry for the buyer.
Yeah.
Yeah, but you need to understand, do not ever give your buyer the impression that they may still be able to keep their deposit once they remove contingency.
Yeah.
It's at risk at that point. On appraisal, the way the appraisal contingency is worded is it says appraisal contingency is based upon appraised value at a minimum of purchase price, or you could put a floor to the appraisal price. You could put a lower amount. You could say, yeah, I'm offering you, I'm offering $1.5 million, but we're not sure it'll appraise for $1.5 million. I'm okay buying a house if it appraises for $1.2 million. Now that means you're gonna be putting 20% of the $1.2 million plus, the lender's gonna lend 80% of the appraised value.
Period.
So you're looking at, if on $1.2 million, that's $960, so you're gonna have a $340,000 down payment, because you gotta make up that delta, okay? Whereas if at $1.5 million, you only would have been putting down $300. But yeah, you can put a low, you could say, you could have a contingency, but put a lower price, and if you know it's not gonna appraise at that high price. Now, we're probably not gonna be dealing with much of that going forward, but that's what that was in there for.
The rising market is an issue.
Yeah, it was a compromise to having no contingency at all. Buyer's going, yeah, I'm okay as long, sometimes it's because the buyer only has so much cash. Not everyone has unlimited funds. And that's the other thing you always have to remember when you've got to be conscious of appraisal. When you're writing an offer with no appraisal contingency, you got to see how much cash does the buyer have if it does come in low. Same thing if you represent the seller. I mean, you can write an offer that looks great on paper, but it's not going to fly because, number one, the property's not going to appraise for the purchase price, and number two, the buyer doesn't have enough cash to pay any extra down payment beyond how the offer's written. I've seen it. I've had offers be head and shoulders above the highest offer.
But it can't close.
But then I look at how much cash they have. They only have 20% down for that price. They have no more cash, and I know it's not going to appraise. So I might as well just throw that in the garbage can because it's an unrealistic offer. But agents will write those thinking that the buyer's going to jump on it. So you got to check their available cash to determine whether they can play that game.
They want to get the offer accepted, and then come back and renegotiate the purchase price.
Yeah. And this even talks about to the right that a removal of appraisal contingencies does not eliminate appraisal cancellation rights in the FVAC form. That's that FHA-VA mandatory clause that I talked about earlier. That overrides whatever the contingency is in the contract. Any questions on that? I mean, obviously, we're in a you know, declining market, so appraisals should be easier and easier to get right now because values are
Hopefully
going
they'll
down.
Come in, yeah.
Steve, I did have a question on K, that assignment request, can you just,
Well, we'll get to, there's a whole paragraph on it we'll get to, yeah, when I hit that in the contract, we'll go through all that. Okay, your next big contingency is the investigation contingency. And remember, investigation contingency includes inspections, it includes any review of any third party or offsite matters. Neighborhood, Megan's Law, underground transmission pipelines, going to the city and checking permit records, checking out the schools, whether they have room for your child based on their grade. Those are all things, everything that's in the statewide buyer and seller advisory, those are all things that fall under the investigation contingency. It's not just inspections. I could pull 10 agents into a room and ask them, what is that, what is that contingency? And they'll say it's an inspection contingency. Everyone still uses inspection. And when you say inspection, you make the buyer think that's what it's for. It's not limited to inspections. It's all this other stuff. That's why I make a big deal about the SBSA and now the local advisory. That's like 36 pages or whatever. You need your buyer to read all those pages, because when you ask the buyer to remove the investigation contingency, they're telling the other side, I've read those 36 pages and I'm okay with everything in it. Now, how often does that happen? I had someone come to me one time and their friends had bought a house and was all pissed off because he bought a house on a golf course. And after he closes escrow, golf balls start flying in his backyard. I'm going, I said, he didn't realize what was gonna happen if he lived in a golf course? He said, no, he wasn't a golfer. I said, well, he should have got a document called the SBSA that had a paragraph in there on buying houses on a golf course and talking about errant golf balls. And I never heard back, but I'm sure that was there. It was right there in the advisory. If he'd have read the advisory, then you would have understood that, depending on where you are relative to the tee box or the green, you're probably gonna get some golf balls in your backyard. I mean, I've shown property that back up to a fairway and they've got a swimming pool, they got a big screen, and you look in the pool and there's like 30 golf balls in the pool. They still go over the screen and into the pool. Do you imagine just sunbathing, laying in a lounge chair, and pop, you have a golf, that can happen to you. So whenever you show on a golf course, if you're not a golfer, you gotta go look in the backyard and go, now where is the tee and where's the hole? Where's the green? And that's gonna tell you what direction that ball is gonna be going and how far and what's the likelihood it's gonna hook or slice into the yard. You gotta kind of explain to people, this is how golf works, okay? Sometimes people can tee off, and guess what? The ball, when you're shooting that way, the ball will go that way, okay? Believe it or not, it can, okay? Or it'll go straight up in the air, and who knows where it's gonna land.
hey, Steve, on the
We had on the insurance issue, but before I forget, there was a time when insurance companies were denying insurance if there was any claim on the house, and we had a seller who had put a golf ball through someone's window, and the claim went to the insurance company, and then the insurance company wasn't gonna insure the house, the new house he was buying because he had a claim, but it wasn't gonna insure the house he was selling because he had a claim for putting a golf ball through a window. That had nothing to do with that house, but they were denying because it had a claim. And finally, they did away with that process.
I just had a question. If the buyer were to use the investigation of property as the contingency, and they use that to want to get out of the contract, do they have to give the specific reason within that?
Technically, most things that you read will say no. that because it's such a broad contingency, you can have any reason in the world. Because it even goes into personal factors. Oh, this house, I like the house the first time I looked at it. I just don't like this house now. You know, if you read the SBSA and you get to this one, it deals with personal factors. It's just a very broad. It just doesn't really matter. That's why it's so important to keep that contingency in play, because you could have a problem in some other area, but be able to rely on
So anytime change
investigation.
of heart, you could use that.
You could, yeah. Yeah, it's that broad. The other big part of this, and it's, it's become more important because of, we're getting lunch early. It's getting more important. I was told 1 o'clock.
Oh, wow.
No problem.
Who brought the wine though? Let's start with that.
Never mind.
Steve for that.
Never mind. Thank you, Rob. With the advent of all of the fires that we're having, insurance is a big, big deal. And so part of that investigation contingency includes insurability. When it was first added, it was added because of the golf course situation. Because what happened was State Farm pulled out of California because of a big mold verdict in Texas, and everyone scrambled to get insurance from all the other carriers, and all the other carriers only wanted to insure houses if they were in perfect condition and there was no potential of claims. And they would come out and inspect the house and say, oh, that's bad, that's bad, that's bad. Yeah, we'll insure, but you gotta fix that in 6 months, and do that, and do that, and do that. And it got hard to get insurance, so that's where we threw insurability in as part of this contingency. Well, now, you've got fire insurance has gotten very expensive. And I have a listing that the insurance last year was $25,000.
Oh,
This year, under the California Fair Plan, it's still $16,000 because it's in a very high fire hazard area. So insurance can get very expensive. So, you've got a buyer looking at a property that's in a rural or wooded area. If it's in a very high fire area, they need to be getting insurance quotes to figure out how much the insurance is.
and that comes
Make
under
sure
the investigation.
That's under the investigation contingency.
It's huge.
Yeah, so here's what you need to understand is, here's what I do. If I'm showing properties to a buyer, and then we find the house that I think they're likely gonna wanna make an offer on, I'm telling them, depending on what time of day it is, I said, tomorrow morning, call your insurance agent and get a quote on that house. Give them that address and get a quote on it. Then they're gonna look it up, and they're gonna figure out, where is it? Is it in a very high fire hazard area? What kind of claims history does it have? They're gonna give you a quote. Most people wanna stay with the same carrier they have if they have their home and their auto, because they get discounts from multiple policies and so forth. A lot of people don't like to change insurance companies. And so sometimes if their carrier says, no, I'm sorry, we can't insure that house, they may choose not to go through with it. They may not want to go to an alternate. Now, you have the California Fair Plan as a fallback. That provides you insurance to get the deal closed, to satisfy the lender, but it's not the greatest insurance policy. Okay, the California Fair Plan doesn't cover a swimming pool. You gotta get a separate policy, you gotta get a separate liability policy for a swimming pool if you're relying on California Fair Plan. So again, it's very important, especially with all the fire situation, and we've got these fire hardening and defensible space. And that's the other thing. What happens is, if you're familiar with the fire hardening and defensible space requirements, what the carriers are, when you're in those very high fire hazard areas, the carriers are typically looking for proof of compliance with all the fire hardening requirements. Okay, which means like you've got to have, basically a fireproof roof. It's got to be comp shingle, or if it's got shakes or wood shakes or shingles, they've got to be fire retardant shakes or shingles. You got your gutters have got to have covered. There's got to be covers on the gutters so the embers don't fly in. You know, you go back and read that, you know, the defensible space, there's about fire hardening, rather, there's about 6 elements there. And the carrier can't ask for that as compliance before they'll insure, or they may put a time frame on it. We'll insure it, but you gotta do all this stuff within 6 months. We're gonna come back and check to make sure you did. Okay? Now remember, at least as of right now, we rely on the NHD report to tell us if a property is in a very high fire hazard area. As to a high fire hazard area, and I don't think that most companies have done this yet. Right now, the NHD reports will tell you it's very high. Then the next level of reporting says moderate. Okay? Well, moderate means it could be, actually it's not moderate, it's, what do they call it? Drawing a blank now. Senior home. What is the word now? I'm trying to remember what they call it. Wildland, yeah, it's called wildland. So it says if it's not in a very high, they'll say it's in a wildland zone. Well, when you go to wildland zone, there it will tell you if it's in a moderate or high fire hazard area. And the high fire hazard area still falls under that fire hardening and defensible space requirements. Everyone familiar with the form I'm talking about? You've heard of it? We don't use it a lot, and they revised it again. They made it actually easier to fill out. The new version's a little easier. But that's what we're talking about but the latest thing I read was that the NHD companies were supposed to revise their reports to be specific as to very high, and moderate, and spell it out so that you didn't have to dig into the report. Because right now you got to go from wildland and then go and look for the description of wildland to see which one it's in, which is it's kind of confusing. So that the industry was supposed to, the last word I had was the industry was supposed to change their reports so they spelled out one of the 3, so you didn't have to study the thing, figure it out. Yeah.
All this time I thought it's a wildland area, like literally with animals.
No,
and
no,
stuff.
no,
But
that's
if you read
not,
all
no,
the-
no, it's talking about fire,
risk.
and that's where it's, you gotta go down, you
Yeah,
gotta
it's
dig
yes or
deeper in the
no.
report to
Mhm.
look for it.
So Steve, it's ready just whenever you are.
Got it,
Whenever
okay,
you have a spot.
okay, we'll finish contingencies and then. So, then after investigation, you've got what's called informational access to property. That says buyer's right to access the property for informational purpose only is not a contingency and does not create additional cancellation rights for buyers. The reason that is there is because in the old contract, once the buyer removed the investigation contingency, they had no further rights to go to the house or inspect the property. Their only right to go back to the house was for the final verification condition. They could not bring an inspector out or go back to the house. This informational access is for the situation where you have removed the investigation. Let's say the seller's provided pre-sale inspections, you've removed your investigation contingency, you're not doing any further inspections, at least you're contemplating you're not doing any further, but then something comes up and you decide you want access to the house to do an inspection or do whatever. This gives you access to the property for however long you put in there. Defaults to 17 days. So you understand, the buyer doesn't have carte blanche authority to go to the house any day they want during escrow. So without an investigation contingency, you rely on that informational access to the property time frame to go to the house. Understood? Make sense?
Many buyers though think that just visiting the property because they have to measure. and
Right,
stuff,
yeah,
it's-
they're not,
it's-
they're
it's
not,
normal,
the
but-
seller can say no. I mean, it's obviously, it's a bigger deal when the seller's still living in the house. The seller can say, no, you have 17 days, you don't, yeah. So that's why it's written in that way. Now, if you have a situation where your buyer's contemplating wanting to look at the property, beyond the final verification condition, you need to extend the time frame there. Otherwise, that's the controlling time frame. And that does come up from time to time, typically with an occupied property.
So we'll have a situation, so we're gonna rent back 60 days, but the buyer like periodically would like to get a bid to fix some here and there.
Okay, that's covered in the rental agreement. That's after close.
After
That's a different situation, and that's covered in the rent back agreements.
Okay.
The seller has to allow the buyer with reasonable notice to bring people in for bids and estimates and so forth. That's covered in those
A
agreements.
reasonable notice is like what, to like
24 hours typically, yeah. Yeah, but yeah, that's addressed in those rent back agreements. That's why you need one of those agreements.
And that's in the car form, the rent back agreement?
Yeah, there's two forms. There's a SIP, SI seller possession, and that's 29 days or less, or there's a residential lease after sale, RLAS, which is for 30 days up to 60 days,
So
if assuming it's an owner-occupied loan.
So for that, should I get that signed now when we're?
You should negotiate that when you negotiate your offer.
Okay.
If you're writing an offer and you're going to negotiate a rent back, there's gonna be a seller rent back, you negotiate that as part of your offer. You don't wait and do that later, because you have no leverage. See, if your buyer wants the seller to put up a security deposit, you gotta negotiate that up front. You can, once you're in contract, you can't insist on security deposit after the fact. Also, sometimes if it's a long, let's say the seller's gonna rent back for up to 60 days. And the buyer wants to know, when's the seller gonna move out? Well, then you can write in a provision for the seller to provide notice to the buyer of the day the seller intends to vacate. That could be give me 14 days notice, give me 30 days notice, depending on the length of the rent back. That way the buyer
What's the name of that form for the 60-day or what?
the residential lease after sale.
So.
Now, it automatically, when you check the box in the contract, it automatically populates.
So
If you're filling this out, it will automatically populate.
M2 addresses.
Yeah, if you look at M3, it says SIP and RLAS auto attach. See, so when you check one of those boxes for a rent back, it's gonna automatically bring that form up, and you've gotta fill it out. Now, while we're on that subject, and this kind of relates, actually goes all the way back to close of escrow. One of your biggest challenges you're gonna have with buyers who are currently renting is they're going to want to give notice to their landlord. And they're gonna wanna try to do it as soon as possible to try to save money on rent, okay? Now, let me give you the best piece of wisdom I can give you after having done this for almost 33 years. You sit down and tell those buyers, number one, you do not give notice to your landlord until you talk to me first. Under no circumstances do you give notice to your landlord. Here's what happens. The day you enter into the contract, and that contract says close of escrow is gonna be on this day and possession is gonna be on this day, your buyers mentally have moved into the property that day. How many escrows close on time? Probably less than half. Okay? Stuff happens. Escrows get delayed. And they don't understand that. And what happens is the next day, they go to work and they start telling everybody, oh, and they call friends and go, hey, we just bought a house. How, really? When you close? Oh, yeah, can you help me move? Yeah, okay, we'll move. We'll be that Saturday. All right, so we'll call the moving company and say, it's like, no, stop. You're moving too fast. I tell people to overlap their rental with possession by at least 2 weeks. At least 2 weeks, if not 30 days. It's a stressful situation, don't make it more stressful by putting pressure on yourself to move out of your rental property. Give yourself a week for a delay in close, and give yourself a week to go in and paint and clean up and do all this stuff to the property, because it's easier to deal with when it's vacant than when you got boxes all over the place. Don't be hung up on trying to save a few bucks on rent. And the reality is, guess what, folks? You close escrow tomorrow. Do they have a house payment on October 1st?
No.
Say no. Their first house payment isn't until November 1st. Do they pay rent on October 1st? If they moved out? No. They actually skip both, if the timing's right, but don't let them do that. I mean, the worst situation I hate is when there's a delay in the closing and the buyer has to move out of the rental property because the landlord's got it re-rented, because they gave them 30 days notice too soon. Don't let them do that. They don't, you talk to me before you get, I will tell you when to give notice. There's your value proposition. I'm here to keep you from being out on the street homeless. Or you're gonna be going to, Embassy Suites or some extended suite situation, because you're not gonna have a place to live.
When's the best time after they release contingencies? That's the best time probably to have to give the notice. Probably.
Yeah, well, you want to make sure the deal's going through, yeah, and you want to know that there's not gonna be any hiccups with closing. The problem is the lender's the one who typically causes the delays. And sometimes they're aware that there's problems, but they don't know the consequences of the problems. They think it's just all gonna go away and be all hunky-dory, when no, it's not. I mean,
Right now, they can't find a replacement property.
yeah, well, yeah, it's,
That's a huge one.
yeah.
Don't sell a house with a tenant in it. You pull out now if you
Yeah,
find it.
So L4 is review of seller documents, so we're talking about disclosures, all your disclosures, your pre-sale inspection reports, and so forth. It's to occur in 17 days after acceptance or 5 days after receipt, whichever is later. Remember, if you have a 17-day contingency to review disclosures and reports, and the seller gives you disclosures on day 14, you have 5 days to review those. It's not day 17. You have 5 days from receipt. Preliminary title report, same thing, but typically we have those pre-sale. Combination disclosures, the HOA documents. Now this is one that you got to be real careful when you're writing non-contingent offers, because if you don't have HOA docs and you write a non-contingent offer, you have no right of cancellation based on those HOA docs when you get them. You've waived any right as to those HOA docs if you get them after the fact. Review or lease deleted items is dealing with when there's solar panels or some other energy-saving appliance financed with either with a lease or with a PACE loan or a HERO loan. We'll get into that in more detail. Again, that defaults to 17 days. If you're going to remove any of these contingencies at the time of writing the offer, you use the contingency removal form, and then you check the boxes for the ones that you want to remove, and then that's attached to the offer. Yeah.
So what do you advise your buyers if they want to write a non-contingent offer, like is there a
Well, we don't recommend it.
Yeah, of course.
We don't recommend they do that. They're acting against our advice. But it is a practical matter. If there's competition, sometimes that's what it takes. My lawyer answers it depends. It depends on the property, it depends on the buyer, it depends on their knowledge and sophistication and understanding of home improvements and home repairs. It depends on whether there's existing inspection reports, how thorough and accurate those reports are. Do you have a clear picture of the condition of this property as disclosed in seller's disclosures and inspection reports? And how much money does the buyer have if a problem does arise? There's a whole bunch of things. And you're gonna have some buyers that they're fine. They've got a construction background, or they're an engineer, they know what they're looking at. We don't care, we don't care if it's 10, 20, 30 grand here, it doesn't matter. But then you got other people that they can't afford anything. It's like.
So what if it's a title issue? Like, let's say the title's not clear as a title issue.
Well, no, you're gonna have a preliminary title. See, when most of us, when we take a listing, we open a pre-sale escrow. We provide you with a preliminary title report.
Yeah.
So we see the title. Yeah. The seller has to clear title.
Yeah.
That's not a contingency.
Okay.
What the buyer is reviewing is all those things that are gonna stay on the preliminary title report, like easements,
Okay.
those sorts of things. And mineral rights and oil rights and water rights.
Okay.
Things that are gonna stay with the property is what the buyer's approving. Title it, when the seller signs the dotted line, the seller has agreed to clear all title issues.
Yeah.
Because the title insurance company won't insure title unless they've been cleared.
Because there could be like an easement, like a neighbor. or
Well, the
someone-
easement runs with the land.
Yeah.
That's what your contingency is for.
Yeah.
It's for your buyer to approve the easements which appear on the preliminary title report. Now, if there's an easement not on the pre, but it exists because of a verbal agreement, that should be on the disclosures.
From the seller.
Yeah, the seller has to disclose easements or agreements.
Yeah.
Now, very important that you and your client read the preliminary title report.
First thing.
We had a situation, it was out of the Oakland office, when I was a broker there. And escrow closed, and in the backyard of the buyer's house was a bunch of playground equipment. First weekend comes along, the neighborhood kids are playing on the playground equipment. They're going, what's going on here? Why are these kids playing on this playground? They had an easement, and it was on the pre. And I asked the agent, I said, did you read the pre? He goes, no. I said, did your buyers read the pre? I don't think they did.
It was like the whole block.
No, this one house had it.
Oh, okay.
Yeah. And kind of unusual, but it was right there in the preliminary title report.
Was it a door that went there, or they had to,
I
they just called it?
I think there was a gate.
Gate open.
Yeah, they just didn't pay attention to
It was
preliminary
on
title
the
report.
prelim too.
It was on the, oh yeah, that's how it was disclosed.
It said,
That was-
so
it
this
was,
playground
they had an
is for-
easement, yeah,
so the
they had an
playground's
easement to
for the-
use that
And it
playground.
was in the.
Yeah, it was on, it was in the pre.
And
It's
the listing
unusual.
I'm going.
agent doesn't have to point it out.
What's that?
The listing agent doesn't have to point it out.
No, it was just right there for you to read. That's
It's
part of the
unusual.
disclosure.
It's unusual though, right?
It's unusual, but
It
I gave the agent, heck, I said, you gotta read the preliminary title report. Gotta point it out to him. Oh, because it is unusual. Oh, by the way, guess what? This isn't your garden variety preliminary title report here. The
So what
neighbor's got
happened?
an easement.
So what happened with?
As an
They had to
agent,
live with
you
it.
gotta read it.
There's nothing they could do. Easements run with the land. You can't, unless you.
So the
can-
next
unless you-
neighbor that comes in could use it?
Sure, it runs with the land, unless you can get an agreement with that owner to remove it, but they're not gonna do that.
Yeah.
Okay, last contingency is sale of buyer's property, so, in this market, you've got a better shot. I mean, how many, I see more and more contingent sales, meaning buyers made an offer contingent on the sale of their house. I just had one, we went 3 months, buyer couldn't sell their house. This is a complicated form. It contains 2 contingencies. One is contingency to get the property sold in escrow, the other is for it to close. You gotta read that form very carefully before you start filling that form out. But again, in this market now, you got a better shot at making a contingent offer. I mean, a lot of sellers would gladly take a contingent offer over no offer. Okay, but again, don't just grab that form on the eve of writing an offer and think you're just gonna start filling it out. I mean, you gotta study and read that form, ask questions, because it's got a lot in it, a lot going on in that form. All right, let's take a break for lunch. How about if you can be back in your seats by 12:30? Okay.
I would make sure that I check out the buyer's house if it's contingent on the sale, if that house is saleable at what.
Oh, yeah, right, yeah, you gotta go.
Because
Yeah,
they may be completely.
Oh, yeah,
out
you
of-
gotta run a market analysis and check it all out and see whether, yeah.
Did you read this morning's newspaper?
Not yet.
Okay.
I usually read the paper at night. I've been
In
told.
local, there's I think it was on the front page, a gentleman died, he was 70-some odd years old, in Berkeley, and he had the community use his hot tub for the last 40 years. No, that's like.
Yeah. There you go.
Steve, let me ask you, so we've removed all contingencies,
In my hot tub.
but the HOA dogs are provided in outdoors.
Oh,
Question.
you have an easement for it, the person has the easement.
They agree.
We had a
And we
situation.
went to sellers and said, hey, you give them land, they let them out.
They know, you know, and
farmer,
remove it.
5 acres, farmer.
By removing it in your offer, you didn't make review of those.
We can put that away and do some of it for
It's different if you have a contingency and they don't bring it, but you either make a
review करो फिर हमारे पास
waiving
को आगे बढ़ना है थोड़ा
you don't have
and then see what your math work is in Google Classroom.
See, where this gets, where we'll talk about later, is when we get into the 3 and 5 day right of, there's a 3 or 5 day right of cancellation on what are called statute. If those aren't provided prior to, or they're not provided, there's right of cancellation on the statute. HOA documents are not statute. They're not a TDS, but they pertain to fire hardening.
So there are exceptions, HOA docs just.
No, HOA docs are not a statute of disclosure, yeah, there's basically 6 disclosures that can provide for a 5-day right of cancellation if provided incomplete or after contract acceptance.
Okay, so from the time that they're provided, you have 5 days.
See, yeah, we'll see, yeah. Yeah, yeah, you can rely on a 5 day, but that's assuming they're complete. If they're incomplete, then the 5 days doesn't start. On any one of those documents, if it's incomplete, the 5 days doesn't start until it's complete. So the buyer can still have a cancellation right after that. When you have to get real sloppy with disclosures, yeah, you can have ways under the statute.
The exception to the calendar days, to the business days is, say the 5th day, end of the day happens to fall on a weekend.
You don't have to run
automatically
Mondays.
goes. Okay.
Yeah, you can't, by state law, okay, you cannot, a party to a contract cannot require a party to perform a contractual obligation or term.
So let me ask you this, if day 5 is Friday,
Then it's Friday.
so it's Friday, so it's not Monday, so it's not the next day, it's
Day
that.
5, yeah, if you count, if you're counting from, if you're counting on, say, on Sunday, then day 5 is Friday. If acceptance would say, acceptance was Sunday, day 5 is Friday. So they've gotta perform that action by 11:59 p.m. on that Friday. Otherwise, they go to Monday. But if acceptance is Monday,
yeah, then
day
it
5
does.
is Saturday, it goes to Monday. If it's Tuesday, it goes 5 days is Sunday, it goes to Monday.
Got it. Okay.
Once you hit Wednesday, then 5 days becomes Monday. And then Monday might be a holiday, and then Tuesday. Yeah.
Great, thank you.
So, Andrea, I met your next door neighbor the other day. The guy that works out in the Keller Williams office in Oakland,
Oh, Mike.
Mike.
Mm-hmm.
Yeah,
Mm-hmm.
he's struggling though, he hasn't done anything yet.
He's new, he's pretty new.
Huh?
He's pretty new, I think.
Yeah,
I don't
so
know if he
he's
has
been,
1 year.
he's been in the market, he's been licensed now for a year.
Mm-hmm.
He's a real nice guy,
He is.
he needs some help,
Mm-hmm.
you know,
Mhm.
sometimes agents need,
Okay.
need help.
Yeah,
Oh, okay.
yeah, he's very happy with his office, Castro Valley and, Castro Valley. So, I don't know, I'm sure they have the resources that
Yeah, they
need.
do,
That he
and I'm
needs.
surprised that they have got him up and running.
Mhm.
But then I can say that same thing about my daughter, Carrie.
Mm, what?
I get the feeling she doesn't want to work.
Mm.
I don't know. Well, I think that only thing is a good decision.
Vegetarian?
एक में नहीं है। I think ये first वाली में नहीं है। इसमें नहीं है। This is just Alfredo sauce. तो नहीं है, उसकी hand की तबीयत खराब हो गई।
Good.
अब next time I will be.
Have you been coming there? Yeah, we haven't had it the last 2 months because of, the KW. What about you? How was it?
It's good.
Pick up property.
Trying to connect with people. Going out of business, but that's it. All of this is so.
Yeah, I feel it.
Take a property
Were you
that's
able to find someone?
I don't
you have to
like to.
subscribe to the neighborhood,
They're
right?
like,
In the, yeah. So, so you tell him that something about what's happening in the market. Says the house sold for this much. Whether it's sold over the asking, whatever, make us positive, say that, so below, don't say that.
Yeah.
Different. And then see, they're interested in selling.
Credit card? Oh, mine has my wrong number, let me send it to you.
taking a break right now? Did you say how long? Oh, so it's open. Wanna go say hi to Carla?
Come on, babe.
Her other reception. What's the Wi-Fi service?
It said it should come, it should come. Region 8.
Oh, yeah, lead gen R8. Then we're gonna go to designs. And then create design.
Pretty good.
Good,
Yeah.
a good decision on their part.
Quick question, can I pick your brain?
Sure.
Okay. So I have a buyer. Right, contact, she is a non-resident. She has a L1A visa. Her concern was, she doesn't pay a big old chunk of taxes or anything, like buying.
Not fine.
Yeah, you said you sell,
No,
right?
for yourself.
But she looked at.
Where's she from?
Germany.
Yeah. Is she still, is she gonna remain a resident of Germany? Okay, in that case, when she sells, she won't pay big taxes. They will withhold. And then if she has a profit, she'll have to claim that and pay taxes on that profit. And then the amount that they withhold will go towards that taxes and then they get a refund.
So that would, because she sent me a screenshot.
Huh?
She sent me a screenshot of like this form or something like that, going over like. Disclosures, maybe about non-resident aliens, but that probably pertains to like selling.
When you sell.
Yeah.
Non-resident alien.
Yeah, okay, so that's just.
What happens, the sad part, is you gotta have a good title company. I stay with one title company and one title officer as long as I can, because loyalty pays dividends. It really does. And what happens in that case, I had a seller from England, he was a citizen, there.
Yeah, you cannot.
So that we withheld the taxes,
Follow up to a point.
sent it into the IRS. No, I didn't send it in, the title company did.
Yeah.
The IRS immediately lost it. Oh, yeah, no, they're just a mess.
Right.
So, when it came time to file his taxes, there was no record that he had paid this in.
How much?
We finally got it straightened out because my escrow officer went to bat, really went after him.
Yeah. So they have all the record keeping, I don't know how. Should.
Right.
Tell him don't sell.
Oh, I see.
How much you plan on staying here, who knows?
She's planning to get married, so, for a while. She just came over here 4 years ago. She permanent at her job. So, that's why she wants to buy now. Right? They made her permanent.
Is it somebody you know? If she's a friend, tell her don't put your new husband on the property. Cause marriages don't last.
Well, they make it really tricky now when you're not a resident and then you marry an American. There's a lot of stipulations. Cause they know a lot of people are doing it for the benefits, right? Yeah.
I see it more when parents give their daughter money to buy a house. Daughter married or marries a scumbag.
And you gotta take over the house.
The parents were trying to help the daughter and the money's gone. The scumbag, he divorces her, sells his house, sells the house, takes the money.
Yeah. Now it's
In California, the law presumes that whatever is the wife's property, whatever the wife has is her property. That's the presumption, because we're in this, we're in 9 states.
He went back home because my son was home alone. And then I had to do
This one?
then वहाँ पे थोड़ा लेट हो गया because डॉक्टर का बताया ना वो वेट कर रहे थे फिर उनको खत्म हुआ फिर मैं घर छोड़ कर then I
This one. I don't use this one. I literally open things. I don't wanna close it though. So this one I do.
Is she marrying an American? He makes me stuck in. Huh? Oh, okay.
You know,
Well, she may be the stuck in.
And,
Both relationships.
and the partner is getting divorced, selling her home between her and her husband. Then about the score over there.
Huh, good luck.
And it's like, yeah, right, right.
Whole new world.
And what's tough, kids, so when they ask about my clients and stuff, I tried to
Do
say.
they have
client,
children? Does the partner have children?
the one that have children, so I'm saying, so I just tell my kid, you know, her partner, client. It's a different world these days.
It is. It certainly is. I have 8 children,
Oh, wow.
4 boys and 4 girls. And not one of them has an owner's manual.
Yeah.
Oh, we got a lot of that.
तो मैं थोड़ा वो भी करने की कोशिश कर रही हूँ बिकॉज काफ़ी सारी चीज़ें जो हैं लाइक हाँ तो वो चल रही है ट्यूसडे थर्सडे वो उसके अलावा एक इवेंट होने वाला है फ्रीमॉन्ट अभी है जो कि तो ये कोई फ्रेंड है उसने मुझे बोला कि उसको bring your stuff with you and then we can do it together. अब वो opportunity मिली तो मैंने छोड़ा नहीं लाइक सो फ्रेंड का फेस्टिवल है तो क्या काम तो मुझे कहीं पे भी करना ही है ना
No, I think, but even 80, I think is too much for the old guys too. If we just sit there for maybe that's in the.
Dave? Dad just raised the rates again.
Yeah, I saw it, yeah, 0.75. That's what they're expected to do.
I get the Wall Street Journal notifications. It's really nice.
Yeah, well, I get, when I hit the stock button, then I get all these, I get the, when you hit the stock button, then you get you get where all the stocks are, and then you get all these articles
Right.
below it, yeah.
They send me the article and then I can listen to it, or I can print it, or download it, or just read it.
Well, the other thing I saw today is that existing home sales are down again in August for the, they just reported that this morning.
I'll bet you interest rates
Down
on
to-
houses
we're down to
are
like-
gonna go close to 9–10%.
Down to, what's that?
I think we're gonna see interest rates on houses going up as high as 9 or 10%.
Hard to say.
Maybe a couple of years
Well,
out.
it depends on how many more rate hikes it takes to get inflation. They haven't been able to they haven't been able to make a sizable dent in it yet.
Well, they want to stop inflation. They reported housing sales down again in August. Total is at
year-to-date total now is at, or 12 month is at 4.8 million
I
sales.
think that the housing market's been the biggest issue of inflation.
Pardon?
Do you think the housing market across the nation has been the biggest issue of inflation?
No, I think it's,
You think so?
I think it's consumer goods. I think it's gasoline, been gasoline and consumer goods.
Gasoline, yeah.
Consumer goods. You see how expensive it is to, and I go to lunch, and I used to spend, no matter where I went, I used to be able to get lunch for about $8, $9 maybe. Hell, I'm paying 15, 16 with a tip, $18 for lunch. It's almost double. You go like, I go to Bodine, get a lunch, do a tip.
Well, it's $20.
Yeah, yeah, and it used to be less than $10.
Yeah.
Now it runs 12 to 18 bucks.
Routine for the day, huh?
Literally.
Yeah.
I used to be able to take out my
I
kids,
usually buy dinner.
kids and wife
now
around
at
$50
home.
a dinner back in the day, and that was like $100 a dinner for a family.
I was in Kauai, we stopped in, my buddies wanted to get a local breakfast from McDonald's with the Portuguese sausage and the rice, and so we stopped at McDonald's on the way to the airport so he could get the local breakfast. And there was a local gal there talking about how high the prices are on Kauai versus some of the other lines. Because you can get a cup of coffee at McDonald's in Oahu for $1, but on Kauai it's $1.50.
Oh.
You know?
Yeah.
That's huge.
See, McDonald's now has an app. They want you to download their app. Because they have all these coupons and codes and stuff for save money.
No, they don't wanna use manpower for cashier.
Yeah.
When people thought they were gonna give minimum wage, high, they thought the restaurant owners were gonna pay for it. Now they're realizing they are the ones who have to pay for it.
Steve, do you have this in PDF form, like the email out, the color coding?
Ask Harshita,
Okay.
front desk, she has it.
You got your computer with you?
Yeah.
Do a screen capture.
Oh,
Make
yeah.
notes.
Oh, yeah.
That's what I'm doing.
Okay.
Really helps. Because things are discussed that are points that you want to remember.
Or you just type on in the text.
Yeah, you can do a screen capture, put it into a Word document, save the Word document as this class. Type out your information underneath the screen. You're writing, I see you're writing. notes.
Yeah.
Same thing.
Yeah.
I just took Irish because it's like it's same but I can't just buy. Full force, so.
Yeah, sure.
Okay. Don't threaten us.
You're all experts on the contract, we can go home now?
So let's say we forget to put the interest rate into the purchase contract, we go back and put it
Yes,
in.
you can go back and do an amendment to the contract, if put one in. Or just cross your fingers and nothing goes wrong.
Yeah.
We had a market, Steve, where inflation was out of control back, I hate to say it was in '66. You were just a little guy, but.
It was 13.
The lenders, instead of raising the interest, they increased the loan fees, the points. Well, at that time, a seller had, if it was a VA loan, the seller had to pay the points. And my God, they got up to 10 points. So it cost them 10% on the VA to sell plus the 6% commission. And it's the same thing. I'm surprised they're not doing that now, instead of raising interest, just increasing the points. Because it is interest, it's an upfront interest,
Right.
but it's not long-term.
Yeah, yeah. Well, see, that only affects housing. It doesn't affect consumption. See,
Right.
they're trying to stifle consumers. They're trying to hit consumers across the board. They're trying to get people to slow down on credit cards and auto loans and all that stuff. That's what they're trying to do. That's their way of hitting inflation, is hit it on the demand side. You know, raise the cost to borrow money to buy all these consumables. All right, moving on, we're on the grid on page 2. We're at 3M1, time of possession. The default is that possession will be delivered to the buyer upon notice of recordation. Well, that could be depending on how early the deed is submitted for electronically for recording. I mean, it could happen anywhere from 10 o'clock to 11 o'clock to 12 o'clock to 1 o'clock. It depends. Or you can check a box that says it will be at 6 p.m. Or it could be some other time on a date specified as applicable in 3M2. 3M2 is the, what are you gonna do with my 3M2? 3M2 is the states that it's close of escrow date. For seller occupied or vacant units. So you've got, so it's either notice of recordation is the default, or if you check a box, it's 6 p.m. on the close of escrow date, or based on an attached tenant occupancy possession addendum, tenant occupied property addendum. I think most people are not checking the boxes. They're making it notice of recordation on the assumption that it's seller occupied or vacant unit, but that means,
That could be 3 o'clock in the afternoon.
could be.
In fact, sometimes,
It could be.
in the morning.
It could be, so you've got, obviously, it's more of a concern for the seller than it is the buyer. The seller, if the seller doesn't, counter that out, they've got to know that they've got to be, they've got to be out of the house by whatever time notice of recordation is received. And I don't know that a lot of sellers agents are advising or even paying attention to that, because that's the default. If you want to go to the 6 p.m., you got to check a box for 6 p.m.
because we don't know when escrow really gonna close,
Yeah.
if you trust the seller, you should let them stay in possession for a few days after the close of escrow. That helps everybody.
Yeah, well, again, it's, you know, the buyer makes their offer and puts down what they want, and then the seller, you know, the seller decides whether that works for them or not. You gotta discuss with the seller. You know, I tell you, one of the most difficult things that we deal with is delivery of possession when you've got a seller occupied property. I mean, it's some of the worst days of my real estate career all turn on delivery of possession of the seller occupied property.
So you'll have to.
Because typically what happens is the seller's agent has not fully explained the process and the timing to them. They don't realize the finality of what happens when, you know, they don't plan, they're not prepared for it if the agent doesn't go out of their way to discuss it. And you do that when you've got an offer in front of you that you presented. You've got this section here is one of the most important things to sit down and explain to the seller before you go into contract.
It's serious.
Exactly.
Steve?
Yeah.
So if it's gonna be tenant occupied, you have to attach the TOPA and the RLAS if it's over 30 days?
No, the RLAS is for the seller.
Okay.
Those two documents under M2, those are for seller occupied property.
Yeah, if the seller's.
Tenant occupied is down below.
Yeah, so if the seller's gonna rent back.
Yeah, then it's either 29 or fewer days, you use form SIP, seller in possession
Yeah.
addendum. Because then it's a license, it's not a rent, it's not a rental. It's a license to remain in the property for up to 21 days. If they're gonna be 30 days or longer, then it's a rental, it's a residential lease after sale. They are now a tenant. But if they're gonna be there 30 days or more, they're a tenant under landlord-tenant law. That's why there's a different and longer agreement.
Is there an additional form, the TOPA? It says attached TOPA.
Yeah, that's the document I gave you. That's for a tenant, not the seller.
The tenant.
See, we go to M3, that's tenant occupied units.
Like an ADU or something?
Or just a house. The house is a rental.
Oh,
It's not seller occupied, it's tenant
Oh, I
occupied.
got it.
We talked about it for ADUs.
Yeah, but
earlier,
no,
that's why.
that was an example, but no, you could have a single family home occupied by a tenant, and the tenant's going to may remain in the property.
Okay.
But there's two ways this addendum addresses, we'll talk about it in a second, there's two options as to how to deal with a tenant occupied property.
Tenant,
Okay, so remember, we start out, the default, I mean, can you look up the RPA, can you look up RPA in zip forms while you're on the computer?
I'll look it up.
Look it up, just check the form and see if it still says the same thing.
Okay.
The default is, if you don't check any boxes, possession to be delivered upon notice of recordation. Okay, well, that could be, like I said, it could run anywhere from 10 o'clock to 3 o'clock. So whatever time that is, that's when the keys should be given to the buyer.
It makes no difference.
Vacant is not an issue, yeah, and vacant property, no deal, no big deal. But it's the seller, you gotta be concerned about the seller occupied property. You've gotta make sure your seller knows, hey, the time for delivering the possession is a floating time, the way the contract reads right now. If you wanna make it, see, as a seller's agent, if the seller says, well, I'm planning to move out, I'm planning to finish my move out, on that day, I go, okay, well then how long do you need?
And
Do you need till 6 o'clock? Do you need 8 o'clock? Do you need 10 o'clock? How long do you need?
And do you need your money to move out?
Yeah, well, that's
That's a huge issue.
Yeah, well, yeah, it could be, but that's usually already discussed at the time that you're listing the property and so forth. You're already discussing, at that, when you're dealing with listing and selling a property, that's when you're discussing with the seller, well, what are you gonna do when you sell? Where are you going? Are you buying another house? Do you already own another house? Are you gonna rent? you know, and then you've gotta help them whichever way they're going there. My point is, if you have a seller and you get an offer that says possession upon notice of recordation, that could be any time during the day. If your seller has plans to be out by the end of the day on the close date, then you would counter back, you know, possession to be delivered at such and such time on the day escrow closes. And you'd counter that so that you buy time for your seller. Give them till 6, give them till 8, give them till 10 p.m. But that would be in a counter offer. Okay? Now, as a seller's agent, you could put in the remarks, you know, seller requests possession until 10 p.m. on the day escrow closes. Well, then as a buyer's agent, when you're writing an offer, you see that and you go, all right, this is what the seller wants. Are you okay with that, Mrs. Buyer? Okay. So then you could write the offer and you could check the box and put 10 p.m. And that would be the applicable time, 10 p.m. on the day escrow closes.
Okay.
Now,
the residential purchase agreement is dated 6/22.
so it's been revised.
Yeah,
but
look at possession there.
What does the
on notice of recordation?
It still says the same, so it's still the same.
Still
They
the
haven't
same,
changed it.
yeah.
Okay, they haven't changed it. Okay. Okay, so we got time possession, defaults to notice upon notice of recordation, which could be, you know, any number of hours during the day, or 6 p.m. or some other specified time. If it's a seller occupied unit, it's going to be at close of escrow, or if you check a box, it's either going to be 29 days or less, use SIP. If it's 30 or more, it's RLAS. Now, remember, if the buyer is going to own or occupy the property, the rent back cannot be longer than 60 days. A lender on an owner-occupied loan requires the borrower to be in the property by day 61.
Provided there's a loan involved.
Yeah, you gotta, yeah.
Yeah, there's just no loan.
There's no loan, yeah, no, this is when, so remember, you got, a rent back cannot be more than 60 days when there's owner-occupied financing on the property. Now sometimes you'll be in a situation where the seller will want a longer rent back. You're gonna have to negotiate a longer escrow period. Now, I've had one situation where we did a 60-day rent back. It was waiting on a new home to be finished. There was a delay in the new home construction, and it was gonna be a 15-day delay, and we went back to buyer's lender and got asked if they would be okay with another 15 days, and they came back and said, all right, we're okay with another. Remember, the lender gives an owner-occupied buyer a lower interest rate because they are living in the property and they're protecting the property, unlike a tenant. That's why there's a difference in the interest rate between owner-occupied and non-owner, because a tenant's not gonna take care of the property like an owner. So there's a bigger risk with rental property, and so the lender charges more for the interest rate on a rental because the buyer's not there preserving the property. Now, if you have a tenant-occupied unit, our old contract said that absent an agreement otherwise, the property was to be delivered vacant at close of escrow. Well, that could be very problematic if you haven't served any kind of notice on the tenant yet, and now you're negotiating a 30-day close and there's a tenant in the property, even if you're on a month-to-month. We now have, that's been changed. We now have what's called the tenant occupied property addendum, which you should have a copy of. The way it's set up, it defaults to the tenant remaining in possession. You know, under the terms and conditions specified in the remainder of the form. Or it states that the property is to be delivered vacant without existing tenants. But it goes on to say that, and this is at 1B2, and this is very important, it says, If seller, after exercise of good faith attempts and subject to applicable law, is unable to remove existing tenants by close of escrow, or you can check a box 5 days prior to close of escrow, buyer may cancel this agreement, and buyer's sole remedy shall be return of deposits and buyer's reasonable out-of-pocket expenses for inspection reports and appraisal fees under the agreement. Or, if the buyer doesn't want to cancel, the buyer may elect to proceed with the transaction with the tenants in possession and waives any claim for other damages or compensation arising out of the tenants remaining in possession. We just had that happen on a closing the other day, where they couldn't get the tenant out. Tenant kept dragging their feet, and finally, the tenant wanted more time. They didn't want to delay the close. The buyer finally agreed to close escrow with the tenant in possession, meaning they were going to assume all responsibilities for evicting that tenant.
Now, was that a finance situation?
I don't remember. I don't know if it was or not.
Because if it is, then you got the loan, the lender
Yeah,
issue.
you got that, yeah. Yeah, well, you got 60 days to get them out, and, yeah.
No, but if they don't
Right,
move.
exactly.
They may never move.
Yeah, right. Yeah, I don't remember the specifics on that, but they went ahead and closed. You know, and I made the agent, made them aware that, you know, the buyer needed to be aware of all the potential pitfalls with attorney's fees and delays in evictions and all the things that come with that. But they were willing to go forward. Now, you've got a whole series of things that come out of a tenant remaining in possession when you've got, you know, transfer of unused security deposits, any prepaid rents, and be prorated, so forth. Talks about, you know, giving by written notice of any changes to any existing leases. Need to provide a list of personal property that's included in the sale, if there's anything that the landlord owned that's in the rental property. And similar to the residential income, you've got to provide them with any rental service, all the leases, income and expense statements if you check the box. And then the big one is the tenant estoppel certificate. That's very important when a buyer's taking on a tenant. You want a tenant estoppel certificate. And the tenant estoppel certificate, the tenant fills that out and states, this is the date my lease started, this is when our rental agreement started, this is when it ends, this is how much I pay in rent, this is how much my security deposit is. Do they have any issues or claims against the landlord? Are there any other side agreements? Because you want that so that when the escrow closes and the buyer assumes that the tenant doesn't come back and go, oh yeah, did they tell you that if I mow the lawn once a week, they're gonna reduce the rent by $100? No. If it's not in that tenant estoppel certificate, it doesn't exist. You use that against the tenant trying to make up stuff. That, oh, are they, they said that, yeah. That's why the tenant fills it out. And that way you use it against the tenant when they come back trying to say something's different than that's in that certificate. So again, just be careful when you're dealing with if your buyer's going to assume a tenant. Now understand, this doesn't get as much press as it probably should, but understand that here in Alameda County, the Alameda County COVID eviction moratorium is still in effect. The state no longer has an eviction moratorium, but Alameda County's is still in effect.
And some cities have even stronger ones. Hayward and Oakland.
Some go beyond it, but so basically in Alameda County with an existing tenant, the only thing we can do if a seller wants to sell a property and it's got a tenant in it, the only thing a seller can do is try to negotiate possession in exchange for money, or what we used to call cash for keys. Say, hey, if you'll get out by this day, we'll give you X dollars. That's all you can legally do with a tenant who's under a month-to-month or a lease. You can never give notice on a tenant in a lease anyway. We're really only dealing with month-to-month. So you understand first, if a tenant has a lease, a 1-year lease, and the landlord wants to sell the property has to be subject to the lease. You can't evict the tenant who's under a lease. They get to stay there for the duration of their lease. If you have a tenant on a month-to-month agreement, well, if they've been there less than a year, you can give them 30 days notice to vacate. If they've been there more than a year, you can give them 60 days notice to vacate. If the property's under foreclosure, federal law says you gotta give them 90 days to vacate. But that doesn't apply right now under Alameda County's eviction moratorium. You can't serve notice on a tenant and kick them out because you wanna sell the property.
You know, Steve, people are doing it.
I know, it's violating the Alameda County eviction moratorium. The Alameda County's eviction moratorium is not going to be lifted until it expires 60 days after they lift the order. They have not yet lifted the order.
So let me ask you this, if a landlord gives a notice, the tenant
doesn't have to move out.
No, but let's say the tenants move out. Because a lot of those guys don't know about the moratorium, right? The tenants don't know. They move out. Later on, once they've moved out, they find out.
They could, if they end up having to pay more for replacement property, they could conceivably come back and sue for the possibly.
There's huge consequences to force.
Oh, yeah. Oh,
You
yeah.
can talk to them about it.
Yeah. All you can do is negotiate cash for keys. You can say, hey, if you'll get out and you can give them incentivize it by giving them more money to be out in a shorter period of time. That's what we used to do with the REOs. With a borrower or a tenant, we'd go, hey, if you're out in 15 days, we'll give you $5,000, or say we'll give you $5,000 if you're out 15 days. If you're out in 30 days, we'll give you $3,000. If you're out in 45 days, we'll give you $1,500 or whatever. We'll give them an incentive to get out earlier. We'll throw more money at you the sooner you'll get out. You can do that with a tenant. That's the only thing you can do with a tenant.
So this is on the seller side, not on the buyer side?
This is the sellers, yeah. Well, because the seller's the one that's got to get the tenant out if they want to sell. You got to understand, if you're selling a single-family home, a condo, or a townhouse, your most likely buyer is going to own or occupy the property. Not a lot of investors buying, at the high prices of houses, condos, towns, not a lot of investors are buying single-family units because they're too expensive. The numbers don't work.
As an investor, you can't raise the rents.
Yeah, well, it depends on the type of property. Remember, rent cap and just cause eviction applies to multi-unit properties, doesn't apply to houses, condos, and townhouses. Now remember, right now, inflation's so high, the rent cap across the state's 10%. Because inflation's so high, 10% is the maximum. Remember, rent cap and just cause evictions applies to a duplex, triplex, fourplex. Doesn't apply. It did for a while. During COVID, state said, we're gonna apply rent cap and just cause eviction to all properties. But they pulled it in March, I think it was. I think as of March 1, they pulled it as to single-family homes, condos, and townhouses. So that rent cap doesn't apply. But like Jerry said, you've got to look at some of the cities. Hayward has rent stabilization ordinance. Berkeley, Oakland, you've got all kinds of rent control. But just generally speaking, in Alameda, yeah, our hands are tied right now. LA County's the same way. LA County isn't like Alameda. LA County just said, we're extending our moratorium to the end of the year. And that's where it is right now in LA County, December 31st. Alameda's ordinance from inception said the moratorium will be lifted 60 days after we lift the shelter-in-place order. They haven't done it yet. It's a big problem because it's really made it difficult for people that want to sell. Because you don't even know. Yeah.
You said this doesn't apply to Berkeley?
No, it does. Berkeley's in Alameda County.
Oh, gotcha.
No. See, you have cities that go beyond the Alameda County. You have cities that have more rent control beyond, see, the cities can regulate even more than the county. Right now, you have it countywide, and then then each city has stricter rent control provisions. Berkeley, Oakland, Hayward, yeah, so you have to look at their rent control provisions also. But generally speaking, it doesn't, right now, it doesn't matter when it comes to wanting to serve notice on a tenant to move them out, to sell the property, which is our world, it doesn't matter what city it's in. Can't do it. Doesn't matter what the rent control says, you can't do it, period, in Alameda County. Okay? And there's been there was a little bit of press, there's some talk going on, they're looking for input from landlords as to how the burdens that are being put on them by this, but there's apparently been no real movement yet by the County Board of Supervisors.
They're not gonna listen to the landlord.
I know.
Because the landlords are a small minority for the voters. The tenants are the big group of
Oh, yeah,
voters.
they're bigger, yeah.
Yeah, that's the issue.
Yeah. All right. So anyway, yeah, just remember, if whichever side of the transaction you're on, when there's a tenant in that property, you gotta be on red alert, okay? You can't just, we've had them, I had one cross my desk a couple months ago. The listing agent was just out in left field. She entered into a contract with a tenant occupied property and hadn't addressed anything. Had no clue what she was doing. Nothing had happened with this tenant. And I'm going, well, what does she think's gonna happen at close of escrow? You think this tenant's just gonna miraculously disappear? Or, it's like, gotta deal with it. But remember too, like I said earlier, because I get this question probably too many times. If the tenant has a lease for a term for say 1 year, a specific lease, you cannot kick that tenant out. You have to sell the property subject to that lease. They stay in the property. They do not have to move out until that lease is up.
So if you do have a potential seller or a seller who's planning to sell their house but they have a tenant, at the end of the lease, would it be better to go month to month?
Well, no,
If they have, let's say, 2 months.
well, no, you want a tenant out as soon as you can get them out. You do not let them hold,
Okay.
No, if you've got a single family home, a condo, or a townhouse, you want that tenant out as soon as possible. Because they're hindering your ability to sell that property to an owner-occupied borrower who's your most likely buyer.
So end the lease as soon as possible.
Yeah. Well, the lease ends by its terms.
Yeah.
Okay? You need to let that tenant know, I expect you out by the end of the lease.
So you let them
There's
know
not
like 30 days ahead, 60 days ahead?
Yeah, technically, you don't have to serve notice under a lease, because it ends by its terms. It's different than a month to month, it just rolls over month after month after month.
But they don't have to move at the end of the lease, that's the problem.
Well, they are supposed to move at the end of the
They're
lease.
supposed
Yeah,
to,
unless
but
it's
they
renewed.
won't.
Yeah.
Because they can't find a place to
Yeah,
go.
well, again, that's another issue.
No,
Yeah.
it is the issue.
No, what I mean, I understand that, but that's what, you've gotta talk to them ahead of time to get them to understand what they need to do.
Get the tenant out first.
But you're saying that COVID.
Because you can't sell the
Yeah,
property.
that's the thing, you've gotta get the tenant out. If it comes to that, you deal with that. If it comes to that.
But you're saying-
Most tenants, I've been doing this for a long time, and I've dealt with lots of tenant occupied properties. And what generally happens, as soon as I tell them, we're gonna sell and we're gonna serve notice, they go out and find a place within a week or two.
Yeah, but they can't.
Well, no, they're out there, Jerry, they're just more expensive.
Very much more
I know,
expensive.
but they will find a place, most of them do.
We
They
just
don't
did
wait
two
till.
sales this past month, both of them the same. one gentleman, one family had been at the same house for 20 years. And, you know, right or wrong, the sellers reached out to him and says, hey, it's come to a point where I've gotta sell the property. You know, I'm gonna be flexible with you. He was easy with them. And the gentleman says, no problem. He goes, you know what, I've been kinda contemplating, maybe it's time for me to buy. And so they went on and chose to buy. They moved out. Another one, the gentleman said, hey, I'm gonna sell, and they went, found another place, so it was.
Yeah, I had one where he'd been there over 40 years, through 2 generations of landlord. Went from father to son,
And
landlord.
you can imagine how low their rent
Oh,
was.
yeah, dirt cheap. I mean, every
Yeah.
guy, man, it's like, here, doing you a favor, man, you've been saving so much money on rent, don't be complaining at this point, man. Then I thought to myself, it's sad. Guy's been renting for over 40 years, he's got nothing to show for all that rent money he spent, even though it was low. We negotiated, we gave him, so we negotiated $3,500 to be out in 90 days. He goes, okay. Within the first 30 days, he said, I'm having trouble finding a place. I need another 30. Okay, we'll give you another 30.
But to find
Day,
out
day
now.
120, he was out. That last day, his truck was full of the last stuff. That property was spotless, man. It was perfect, man. Yeah, because they were like family. Yeah, they'd been with him for so long. And, yeah, it'd been over 40 years.
Each case is different.
Terrible.
Each case is different.
Yeah, it's all different. I mean, yeah, you deal with it, but again, you gotta, you know, start that dialogue early, because your goal is you wanna get that tenant out. I mean, I went through 9 condos in a 2-year period, all tenant occupied, and in every case, I had tenants out in less than 30 days in every one of them. So we could go in and paint and carpet and put on the market.
Well, usually you get tenants after screening them and making sure that they are decent, respectful people.
Most people, they don't wanna be on the street, that's why they wanna go look right away and find something, because they don't wanna get in legal trouble, you know, there's other people that don't care.
But you're saying, Berkeley, Hayward, and Oakland, it's different because of the COVID restriction or something?
No, they have a lot of rent control provisions relative to raising rents and serving notices and so forth, they have more
But
provisions.
you're saying something about the COVID.
Well, now, the Alameda County is COVID related, it's a shelter, it's part of the shelter in place order and eviction, there was an eviction moratorium when COVID started, and it's still in place.
Okay.
Alameda County hasn't lifted it.
And what is that talk
Well, that
about?
provides protections to the
Protection,
tenants.
yeah.
You can't serve a notice to vacate on a tenant, but tenant's sitting there paying rent, and you wanna sell your house, you can't serve them notice. See, under a normal month-to-month agreement, the tenant's sitting there, even if they're paying rent, I can say, here's 60-day notice, you need to move out in 60 days. You can't do that right now.
So it says Alameda County. and you said-
Alameda County, no, you can't do it.
All right.
All you can do is say, I'll give you cash to be out in 30, 60, 90, whatever it is.
And what's
That's all
the-
you can legally
what's-
do right now.
And what's the given, like, cash people usually give?
Well, we had one of our aides had one where they were gonna give them, I think, $7,500 to be out in 60 days. Now, one thing before I forget, never, ever, ever have an attorney negotiate on behalf of the landlord. The landlord does the negotiations. Because what happens is when the attorney's representing the landlord, the tenant goes into an attorney, now they're gonna try to blackmail you. They're gonna want 15, 20 grand, because they know you can't do anything legally, so they're gonna try to extort more money out of you. So as soon as they get, when there's an attorney on the landlord side, yeah, you could be looking at 15, 20 grand to be out. So you always you can have an attorney behind the scenes, but they don't do the negotiations. The landlord does the negotiations, yeah.
So just to clarify, it doesn't matter if it's like a lease or month to month right now.
Well, you can't, okay, stop. You can't serve notice on a tenant, you can't serve a notice to vacate on a tenant who is on a lease. Okay? Like if I entered into a lease on September 1st for 1 year, okay, through August 31st, you can't make me move out. I have a lease, a 1-year lease.
What about a month?
Month to month, on Alameda County, you can't serve a notice to vacate on a tenant. period.
Okay.
Jason asked me to fix this.
Oh, okay. You can't serve a notice to vacate on a tenant
Okay.
in Alameda County.
Okay.
Here.
No, at this time.
I got it.
This is what
Thanks. Okay, you understand the difference? See, absent Alameda County's eviction moratorium, you've got a tenant on a lease, on a month-to-month, if they've been there more than a year, you can serve a 60-day notice to vacate. If they've been there less than a year, it's a 30-day notice.
Okay.
Under Alameda County right now, you can't do it. There's been a little bit of press about it, but not a whole lot, because it's down to just one county in the Bay Area. And the landlords aren't complaining that much. But it is a problem for us when we try to sell tenant occupied properties.
So it comes down to discussions. If it's 30 days lease, then it comes down to discussions.
If it's a month-to-month
Month-to-month
agreement,
lease,
you
then-
can't serve a notice of vacate. You need to negotiate
Okay.
possession in exchange for cash.
Mhm.
Now, and you don't give them the cash until after they move out.
Okay.
Now, you can say, hey, you could say your rent's, say your rent's $3,000 a month. If you're out in 60 days, I'll give you half of that back. If you move out in 60 days, give me the keys, I'll give you half of your rent back. And then deal with security deposit based on the condition of the property.
But you cannot do that, a cashback to someone who has a yearly lease.
No.
No.
Well, no, you could.
You
No, you
could.
still could.
You
Oh,
still
no,
could.
you could still ask somebody
You
under.
cannot take
Yeah,
them on,
you
but you
can.
can offer.
You could ask someone under a lease too. Yeah, you could do that.
Okay.
There's nothing saying you couldn't do that.
But you
I was
cannot
talking about
make
notices to vacate. You can't serve a notice to vacate on someone under a lease. Yeah, you could go to someone, let's say they're at the tail end of a lease, you know, you could try to negotiate an early move out. And nothing saying you can't ask, you just can't demand. See, there's a difference.
Yeah.
What if they have not been paying rent?
Okay, well, no, there's provisions to serve, yeah, that's an eviction, that's a different situation. Now you look to the
So
type of
currently
property.
in
Yeah.
the county.
You can, if someone's not paying rent, okay, then that's a different situation, okay?
There
But
are
it
some,
depend- yeah,
some things you can do
Yeah.
to evict people that are not
yeah.
good citizens.
Basically, the way it works in Alameda County is they've gotta be breaking the law. Rent's not, see, the whole reason for the shelter in place is because of COVID and loss of income and inability to pay rent, okay? It's, you gotta find, if they're you gotta be able to find that they're breaking the law, there's a health and safety situation in order to try to evict the tenant. But see, you understand, that's usually not our world, typically, okay? We're typically dealing with tenants who are just legally there in place, and we want them out, but we can't get them out. That's what we typically run into. Okay. Last grid on this page, in seller delivery of documents, 7 days after acceptance, that's never changed, the same thing, all your.
They added one more.
What's that?
They added one more, M5.
Oh, did they? What's that one say?
Evidence of representative authority.
Evidence of, representative authority, okay. I will,
3 days after acceptance.
okay. I'll have a new copy for everyone tomorrow. So we can make sure we cover anything that's been changed.
And that's added to this new one?
Yeah,
Oh,
yeah, there's a more recent version,
when was that revised?
June.
Oh.
Then you've got N2 only applies in Southern California. In Southern California, title and escrow are separate companies, so they use separate escrow companies in Southern California, and that's what N2 is talking about, signing and returning escrow holder general provisions, supplemental instructions within 5 days after receipt. we deal with escrow instructions at closing. We don't deal with them up front, because the title company handles escrow. And 3 is the time to pay fees for ordering HOA docs. It's 3 days after acceptance. And that's just talking about the time to pay, and who pays is on the next page. But there's a time frame for paying the fee that's specified here. And then you have a time period for installing smoke alarms, carbon monoxide, and water heater bracing. That is supposed to be done within 7 days after acceptance. Now, why do you think that's in there? Why do you think we have a short time frame for doing that?
Appraisal.
Appraisals. Because appraisers check properties to make sure they have the necessary smoke detectors, carbon monoxide, and water heater bracing. So you've got to make sure that gets done within 7 days. So that means you got to make sure you don't have your appraiser out there before it's been done. So there's got to be, both agents got to be kind of working hand in hand. Basically, as a listing agent, 9 times out of 10 as a listing agent, you're gonna be the point of contact with the appraiser. Appraiser's gonna call you and want to set up a time. Well, you as a listing agent should know whether or not your property is in compliance or not. Now, most of us will have it in compliance before we even hit the market. Okay, that's one of the things I do with the pre-sale inspection. One of the first things I do is get my handyman or contractor out there to get all that stuff done and in place, so I don't have to worry about it. Then that way, whenever the appraiser comes, and it's all taken care of. Because there's a provision in the contract that says if you don't have that all taken care of, appraiser comes out, there's stuff that still needs to be done. The appraiser's going to charge to come a second time. The seller's paying for that appraiser to come back because the seller didn't have the property in compliance.
So you're saying if it's not in compliance and the appraiser won't appraise it?
No, they'll appraise it, but they have to come back again to confirm that it's been done.
Okay. And when you send your handyman out, they just go to make sure the smoke alarms, carbon monoxide detectors, and water heater bracing is in compliance? I have an inspection report that tells me what's not in compliance. Mm-hmm.
And then I give that to the handyman to show him what needs to be done.
So it's more than those 3 items that could be out of
Well,
compliance?
no, only these 3 items are required
For
for point of sale ordinance.
Okay.
Yeah. Any other repairs we do beyond that is totally voluntary between the sellers.
I was just wondering compliance appraisal wise.
An appraiser's going to, is going to turn faucets on, make sure there's running, make sure there's hot water, make sure the water heater's putting out hot water. They may turn on a stove to see if the stove's working. Yeah, you've generally got, your appliances have to be in working order, and so forth.
How about the furnace, the AC heater?
They'll quite often, they'll kick the furnace on, make sure that it's working. It varies from appraiser to appraiser. Some do more than others.
The big issue is smoke detectors, carbon monoxide.
The 3, and water heaters, yeah.
Can you go to 3 on there?
Go to what?
Go to page 3.
Okay, well, I'm not there yet, I'm just finishing.
Oh, I thought you were.
I'm on the bottom of 2 right now. Okay, so you understand what we're talking about. We're talking about the things that are statutorily required. These aren't, understand folks, these aren't negotiable items, these are statutorily required unless you have, it doesn't matter if it's an exempt seller or not. You've got to have smoke alarms, you got to have one in every bedroom, smoke detector, you have one in every bedroom, you got to have one in the hallway or the entrance to the bedroom, if you got multiple floors, you got to have one on both floors, you got to have carbon monoxide. It's recommended one for every 1,000 square feet, okay? And your water heater's got to be double strapped, okay? So as a seller's agent, that's something you should be checking when you first see the property, or your property inspection is going to point it out.
So it's 1,900 square feet and under, you only need 1 carbon monoxide detector?
If it's a single story, yeah. Well, I would go 2 if you're that close to 2,000.
Okay.
Every 1,000 would be, yeah. What was I gonna say? Threw me off there. And then.
That's when you sell a house, you make sure that.
Yeah, like I said, you either look yourself. Now, remember, if work was done to the house recently requiring permits, in order to get the permit final, the inspector's gonna look for smoke alarms and carbon monoxide. So usually you have pretty good assurance that there's been recent work done with permits that it's in compliance. Maybe not so much the water heater, but the smoke and the carbon monoxide, because the inspectors will look for that.
I have a question about pre-sale. So when you do the listing agreement and any work that's done from there on, that should be kind of documented in invoice and disclosure and all that, like?
Well, no, okay, you got two different things going on here. If you do any work pre-sale before you enter into a contract, it's gonna be in your disclosures.
Okay.
The seller property questionnaire is gonna ask for repairs that you've done. That's where you're gonna list the work that you've done in the seller property questionnaire. Anything, once you enter into a contract, now the contract under repairs specifically states that any repairs that are to be done, the seller is to provide a list to the buyer of all the repairs done by seller, repairs done by others, provide invoices and all that. That's all dealing with repairs in escrow. We don't do that very much, do very little. Most of what we do is pre-sale. Now what I do, I just had a contractor do about $3,000 worth of work to a condo. Okay, I take his, and it's all property inspection stuff. So I take his invoice, I make a copy, I white out the dollar amounts, and then I upload that as a disclosure showing all of the repairs done to the property to get it ready for sale.
Why do you white out the prices?
Because I don't want them to see how much it costs.
Okay.
It's none of their business.
Yeah.
Okay. Now, in that case, my seller was exempt, was an exempt seller. So that's why we weren't filling out the SPQ. And so that's why I provided that separate list of all the repairs. Now, when it comes to dollar amounts, understand, one of the requirements under an SPQ is if you have any written estimates for work, you have to provide those written estimates.
When you're in escrow.
As part of your disclosure.
Yeah.
Maybe leading up to.
Estimates, yeah.
Okay, if the seller has gotten, if you, or even on behalf of the seller, you've gotten estimates for work.
Put it in.
Okay?
And the work's not done.
And the work's not done, you've got to provide those estimates.
How about when work is done, when you're in escrow?
That's all covered under the repairs paragraph. You've got to provide them with evidence of.
Yeah, would you disclose the prices and the invoices?
Yeah, it says, yeah, the repairs paragraph says that.
Okay.
Yeah.
But you don't have to show the estimates then.
Well, I would disclose any written estimates in your possession, I would still disclose them. That's still relevant to that.
Dollar bids.
Yeah.
Well, like with your condo, that was prior to being in escrow.
Yeah, and it had an exempt seller too.
Yeah.
That wasn't required to do the SPQ.
What's the definition of SPQ?
Seller property questionnaire.
Yeah,
It has
SPQ.
its own specific provision for reports and inspections and estimates.
SPQ.
It's right on the first page. In fact, they moved it up because people kept missing it and not, it was at the end and people used to kind of blow right by it. They put it right up in the front in the first page because it kept getting missed so
No
much.
listing agreement.
What? No, I'm talking the seller property questionnaire. If you have not done many transactions, I mean, Pat teaches the disclosures class. We have a link to her class. Okay, you should listen to that disclosures class. Okay, I mean, we could
I have
spend.
one coming up in October.
Oh, yeah, yeah, she's got one coming, yeah. I mean, disclosures can take 2-3 hours, okay, to go through all that. Now, this is a class to give you an overview of everything. I do address a lot of detail as it relates to, knowing what to know when you're writing an offer, but I don't go into all the detail, okay? Because it can go hours and hours. Okay, any questions? You guys know it all, okay, very good. There'll be homework. Okay,
It'll be on the test.
it'll be on the test, yeah. Okay, page 3 of the grid, we've got paragraph P1. This is kind of confusing because this list is meant to be a list of items that are included, which may be above and beyond what's listed in paragraph 9B. 9B is the paragraph that lists the items that are included in the sale. And then this is like a reference to additional, it's kind of clarifies some of the items that sometimes aren't considered, or allows you to put in additional items that aren't specifically referenced in 9B. Okay, that's the best way I can explain it. It's this, in other words, this in it by itself is not controlling. It's 9B and this. Okay, does that make sense? You have to read them both together. Sometimes I think agents just look at this and go, oh, the box is not checked. Well, it doesn't matter. Is it in 9B? It's included. And that's why it says, all items specified in 9B are included and the following if checked. Okay, because 9B says, for example,
9B or 9P?
9B. It says built-in appliances and appliances for which special openings or encasements have been made, whether or not checked in paragraph 3B. Well, you know, it goes on, and this is kind of to make sure the seller understands. It's a refrigerator. If there's a wine refrigerator, it includes the wine refrigerator. Doesn't, you know, it's not just the refrigerator. I mean, washer and dryer, obviously, that's a perfect example of this. Washer and dryers aren't in 9B, but they're personal property, but they're included if you check the box. Any kind of freestanding, you know, washer, dryer. It defaults, you know, if there's bathroom mirrors, they're included unless you specifically exclude them, because a lot of bathroom mirrors are hung on the wall like a picture frame. Okay, and we've had buyers surprised when they move in and all the mirrors are gone in all the bathrooms. That's why this got put in, because people, you know, it's like, oh yeah, it's not built in. Let's take it. You know, it's like, wait a minute. You know, it's like that was a real problem. Potted trees and shrubs is another example of a personal property that that normally would be personal property and not included in the sale, but if you check the box, they stay. Now be careful there with potted trees and shrubs, because you really need to identify them, especially if there's a lot of them, because you may not know which ones, whether they kept them there, left them there and all. I mean, I had a house one time that backyard was tremendous. 90% of it was potted trees and shrubs. If the seller took all those pots out, it was going to look like the Sahara Desert. You know, so buyer would have been for a big surprise if I hadn't addressed it. I said, well, what do you want all these plants? Yeah, I want them all here. Well, then we got to identify them, and how many are, you know, what are they? How many are there? And all to make sure, take pictures, make sure the seller leaves them all, because you can run into a big problem. We'll talk about fixtures in more detail when we get to paragraph 9. Allocation of costs. You've got the NHD report. I'll go back in the shaded area. Who pays? Where it uses the word both. If both is checked, costs to be split equally unless otherwise agreed. So if you check the box both, then you know it's 50-50, automatic. You don't have to say anything more. Natural hazard zone disclosure report, you're always going to order an NHD report. Doesn't matter who the seller is, what the status is, there's always going to be an NHD report, customarily paid by seller, typically only $99. And get in a habit of checking environmental and making sure most NHDs do include environmental. And then you got to indicate the company that's providing it. Q4, again, this is smoke alarms, carbonized water. Who's paying for that? Now, understand this. If the buyer checks the box and says, I'll pay for smoke, carbon, and water heater, and if the buyer, even if the buyer hasn't paid, Oh, I'm sorry, it's not there. Even if the buyer, what was it? Okay, anyway, if this says buyer to pay, even if the buyer hasn't paid, the seller still has to make sure they're installed within 7 days. And then go after, and then deal with the buyer's reimbursement to the seller for the cost, because it's gotta be done.
They can reimburse the seller.
There's a provision in here for dealing with that deals with that whole issue. Okay, government required point of sale inspection reports. That's dealing with what we call, there's point of sale ordinances, some requiring certain inspections or reports, some requiring corrective or remedial actions. So you've got a perfect example of a point of sale report would be in the city of Livermore, you have to provide the buyer with the record of permits. And last time I heard it was up to about $75 to get that report. That's what's covered under Q5. If you're unsure whether a city has a point of sale ordinance, you can go to the Bay East website, check on community information, and then go to the individual's page for the city, and that will list any point of sale ordinances they have. You've got Livermore's got the permit report, Pleasanton has a spark arrestor that's required. Fremont doesn't have anything, Newark doesn't have anything, Union City doesn't have anything. You've got, when you get down to Q6, corrective remedial actions, you've got there needs to be it's kind of a combination, inspection and remedial action. You've got to have it done, an inspection of the sewer lateral. You got to get a certification of the sewer lateral, that the sewer lateral from the house out to the main is in good condition. Most plumbers will do it for free. They run a camera through there. They give you a DVD and shows you whether there's problems, and then they'll give you a bid for. If they can't certify it, then they're going to give you a bid for repair, and then those repairs are going to have to be done. The repairs are negotiable. If the buyer assumes responsibility for that, typically the buyer has up to 6 months after close to do the repair. The city will give them 6 months to do it. I will typically, depending on my seller and the property and the market, quite often, and if my seller's got the money, I'll quite often will go ahead and have the sewer lateral replaced, and then that's just adds to the value of the property, and just it's just an added feature when they're marketing the property. Okay, again, depending on the length of the lateral, you could be looking at $4,000, $5,000, $6,000, $7,000, $8,000. Nowadays they do them. They're done trenchless, where they don't have to dig up the ground. What they do is literally they have it's a pipe. It's about 6 inches in diameter, and they literally dig a hole and where it starts, and it's got an auger in front, and the auger spins and it breaks up the existing clay sewer pipe, and then pulls this plastic pipe through the same place where the other pipe was, and it just continues, and they just continue all the way around pulling it through, because remember, they can run the auger through the sewer line and then hook up the other end and then just bring it back, and they don't have to dig up a trench in the dirt. I can show you pictures. I've had it done multiple times. It's a pretty slick way to do it. And then they just have to depends on how. Sometimes they have to dig a hole at some junctions depending on the bend, and then they run it all the way out to the main and hook up to the main, and then you've got a brand new sewer line. There's a new system out now that in the sanitary districts where they can actually inject a sleeve, like a sleeve inside an existing pipe, and run basically an epoxy plastic material, and it lines the inside of the existing pipe. So that's a different way of doing it. That's what they're doing. They're going to, like local sanitary districts, on the big pipes, like the 3 and 4 foot diameter pipes, it would be so expensive for them to have to dig up the ground and pull those pipes out and replace them. They're using the liner, so they can leave the existing pipe in. It's a pretty cool system. If you ever go to family reunion, the vendor that sells that's always there. They have a demonstration, they show how it works. It's kind of like, imagine taking like an endless tube, cloth tube, that's got a top and a bottom, and you run it through, and then they inject inside that tube, they inject it's like a plastic epoxy material, and then it hardens and creates it just lines the inside of the existing pipe. Let's see what else. You've got, that's sewer laterals and permit reports, spark arresters. Those are kind of the three main things that, you got sidewalk ordinances now. You've got Castro Valley, Oakland have sidewalk ordinances. So if you've got sidewalks that are all torn up, you got to replace the sidewalks. We had one case in Oakland where the sellers had hired a guy and he replaced a bunch of sections of sidewalk and had it all roped off and everything, and come back the next day and the neighborhood kids had just written in the concrete while it was still wet. They just done all this stuff to the concrete, just messed the concrete all up. They had to come back and tear it out and do it all over again. It was Alex Watson from Pleasanton. He showed me some pictures. It was funny, but it wasn't funny. It's like these neighborhood kids were just, being kids,
You ever did
wet
that
concrete.
when you were a kid?
Oh, everyone did that. I mean, you put your hands in it, or you put your name in it and the date. It's like everyone did that. But they went beyond. They went beyond the normal stuff. Well, yeah, that was the big thing to do when you had wet concrete. Escrow fee. Now, when we talk about these closing costs, those of you that are newer, you go to a title company. You should create a relationship with a title rep, one of the title companies. They have a chart. It's called Northern California Schedule of Closing Costs, and it lists all the typical closing costs and who customarily pays. So it shows you who pays escrow fee, who pays owner's title insurance, who pays county transfer tax, how much are city transfer taxes, who pays the city transfer taxes, okay? And it's listed, it shows every county, lists the cities. So you need to get a copy of that chart. Now remember, it's custom. It's not law. It's not required. I hear agents say, "Oh, law." No, every county has custom. Okay, Alameda County is what we call a buyer pay county, which means the buyer pays for owner's title insurance, pays for the escrow fee, and where there's a loan, buyers always pay for the lender's title insurance policy. Santa Clara County, just to the south of this, is a seller pay county. In Santa Clara County, the seller pays for owner's title insurance and the escrow fee, but the buyer still pays for the lender's policy if there's a loan. So you have to be careful when you we get a lot of, because we exchange MLSs, we get a lot of offers from San Jose, Santa Clara County agents on Alameda County properties. You got to be careful with their offers, because I don't know if they're doing it purposefully or they just a knee-jerk reaction. They'll check the boxes for seller to pay title and escrow. It's like, wait a minute, So you got to counter them back, because they're just so used to checking the box. So watch for that, because it can get expensive. It could be several $1,000s depending on the purchase price. Yeah.
When you get out into San Joaquin, San Francisco, you got to Google this stuff. If you can't get it, if you need it now and title's not open, Google it. It's very easy to find out who pays what. It's 50.
Yeah, I have the chart bookmarked on my computer, so I have it, and I used to keep a hard copy too. So because I would always forget sometimes I'd forget when I get outside the Bay Area, and I got double check, and then also with city transfer taxes, and those changed a couple years ago. San Jose is significantly greater than it was before. San Jose was,
Both of them are crazy.
San Jose was just $3.30. Well, not that anymore. Now it's, you're looking at, I mean, I had a 3.3 million, and oh man, the transfer tax was huge. It was that kind of cost my buyer about $16,000, something like that. It was a really large amount. So you need to know that stuff when you're writing your offers. And remember, and your escrow fee and title insurance fees, their schedules based on, owner's title and escrow is based on the purchase price. And then there's a schedule that shows how much it is. As the price gets bigger, the fees go up. Same thing for a lender's policy, it's based on the loan amount. And that schedule will tell you how much that is. Now, when you fill out Q7, you know, again, in Alameda County, you'd say buyer, and in escrow holder, you'd put the name of the title company, because in Alameda County, in Northern California, the title company does both title and escrow. You would put the name of the title company, and then when you get to Q8, owner's title insurance policy, if you check the box buyer, and you get over to the third column, you only list the title company if it's different from escrow holder. That would be Southern California. Okay, so you don't have to repeat it again because it's the same company. Now, you need to remember under RESPA, I'm sure you all remember studying about RESPA when you got your license, okay? RESPA states that, long time ago, yeah, well, I went to law school 40 years ago, and I still remember what I learned in law school, okay? 44, I started 44 years ago, yeah. Little different situation, a little more studying. Yeah. Well, remember, yeah, I was telling somebody this the other day, it's like, imagine if you went to college for 4 years and got a degree, and they said, all right, you got your degree in business, well, now we're going to make you take the next 2 months and study everything that you learned over the last 4 years, and you're going to take a test for 3 days on all that stuff. That's what the bar exam is. Yeah, we have to go back, there's 12 courses that we have to spend 2 months studying again, and then take a 3-day exam on all that stuff that we learned over 4 years. That's why the bar is so hard. Man, it's just like, and there were guys, you could always tell when we're in this bar review course, you know, we'd be inside for like 3 hours, and then we had a pool at the law school, and so we'd all hang out by the pool and study some more by the pool, right? And then there'd be people freaking out and going, because they didn't learn a course. They skated through it, and then they're trying to just spend all this time going, hey, you're not going to learn that one at the last minute. You may not even get a question on that one. I go, make sure you know there's like 6 core subjects. You better have these dialed in. You may not even see an exam on those others, but they would freak out. We get to the bar first day of the bar exam, and we're about, they give you, say, 3 60-minute questions. You got 3 hours. And we're about an hour and a half in, and all of a sudden some guy gets up and walks out. Everyone looking around and go, and we know, yeah, he knew he didn't know it. He was done. Do you imagine 4 years of school, and then, now you can take it again, but still, it's like, everyone's looking around going, oh, gee, well, and we knew he was one of those borderline guys. He just, you got to stay on top of it. It's just, you can't cram it in 2 months.
There's some ads saying you can pass the bar exam by taking video courses.
Yeah. Well, you got to do that. I don't know what I would have done had I not passed it the first time. I would not have wanted to take it the second time. There was a story at school that a guy had taken it like 6 times. At some point, you got to tell yourself, you're not cut out to do this. You just can't pass the exam. And then there's a story of a course reader reviewing blue books on a BART train. It's like, oh, that's great. They're grading our tests while they're on the commuter trains.
Did you pass the real estate exam though?
What's that?
The guy who didn't clear bar.
Oh, I don't know. Well, I should have done that. That's easy.
It took us 2 months to get
So where were we? Okay, so we got escrow, owner's title, buyer's lender title. Then we got county transfer tax. Again, customarily paid by seller. It's $1.10 per thousand, so that means you take whatever the purchase price is. Let's say it's $1 million. Well, $1.10 per thousand means it's $1.10 times 1,000. So that's, what is that? $1,100. That's how we calculate it. $1.10 per $1,000 of purchase price. If you had say you had an $800,000 property, the county trash tax would be $880. Now, say you've got a city transfer tax, which is next. That's typically split 50-50. So you would typically check both. Well, let's say the county transfer tax is, well, at one time, well, Oakland for $800,000, I think it's still the same. It's $15 per thousand. So again, we've got an $800,000 price. So the county tax is $1.10, okay, per thousand, which would be $880. Well, the city is $15 per thousand. So how much is that total? $12,000, which you split 6,000 the buyer and 6,000 the seller. That's a big amount. 6,000. The county tax on $808, the city, you're adding another $6,000 to the buyer's side. So remember we were talking earlier about closing costs being maybe 3/4 to 1.25%. That's not counting this $6,000.
But if the seller pays it all, it's not part of the buyer's closing costs.
No.
And that could be part of the negotiation.
Sure.
Think about it. That's a big chunk.
Oh, yeah. Yeah, no, you could, yeah. In this market, whereas in the multiple offer market, I would have my buyer pay both halves. Now in this market, you could have the seller pay both halves. Make an offer and have the seller pay both halves.
And that doesn't count against the 3%.
No, doesn't, no, because it's not a buyer closing cost, it's a seller closing cost. So yeah, in this, yeah, so you can get creative in your negotiations. Because again, we're,
But the other
as a
side's
market-
got to understand what you're doing.
Yeah.
That's a problem.
Yeah.
I was curious if these are tax deductions, if that
It's
helps
a-
the buyers.
Okay, this is a closing cost.
Yeah, and are these
So
tax
it only affects capital gains taxes. It doesn't affect your annual income taxes. Your closing costs affect your capital gain. Remember, when a buyer buys a property, their basis is the purchase price they paid for it, plus any of their closing costs, which are the non-recurring closing costs, not the recurring. All the non-recurring closing costs are added to that price, and that's their basis in the property.
Capitalized.
Now, then you go all the way to the end, when they sell, we got the sales price, and then we deduct the commissions and closing costs that the seller pays. That gives us what's called an amount realized, which is an adjustment off that sales price. You take that amount realized, you subtract the basis, which had the price, original price and closing costs, that gives you your capital gain. So you're only dealing with these closing costs as part of the purchase and then as a reduction to the purchase price on sale. In between, you're only dealing with interest and property tax deductions. Yeah.
And, but I was thinking that you were saying that the maximum credit that you can have from a seller is 6%.
Well, yeah,
And
yeah.
if you have these big numbers.
Yeah, well, I mean,
In the sense of, you never need 6%, I'm thinking.
yeah,
6%
it's, you
is
gotta
lot,
have a lot,
but-
yeah, 6% is
but
still a
closing
lot of
costs,
money.
But this is, these are big closing costs.
Yeah, 6%'s a lot of money. Yeah. Okay, everyone understand that? No? Like I said, it's, when you get in, yeah, like I said, when you get into, when you get into cities with city transfer taxes, yeah, the dynamic changes quite a bit. Because now you're getting into a lot more money than the buyer otherwise was thinking they're gonna have to pay. And it can get, and with today's prices, it can get pretty expensive. The good thing is it's just a one-time tax, you know, doesn't recur.
I wonder what they do with all that money. The city's a mess.
I don't know. Something good with it. Well, I know what they do. They put in all those bike lanes and stuff. You know?
Good one. So you better buy
Yeah.
a bike
Yeah.
too.
All right, Q13 is when you've got an HOA, you have what's called an HOA, well, go back Q12. HOA fee for preparing disclosures, that defaults to the seller. And the reason it does that is because there's a statute that says that the seller has to pay for the statutorily required documents. So the contract just goes ahead and provides for the seller to pay for all of them, the statutory and the contractual disclosures that are called out in the contract. Certification fee it defaults to the buyer because that certification is what the lender needs if the buyer's getting financing. That's what tells them, you know, what the owner occupancy ratio is, whether there's any pending litigation, all these things that the lender wants to know about an HOA. The transfer fee is typically paid by the buyer because that's the HOA updating their records to show the new owner, the buyer is the new owner of the property, as opposed to, you know, because they're having to update their billing and all of that information. Then it talks over on the right here, unless otherwise agreed, seller should pay for separate HOA move-out fee and buyer should pay for separate move-in fee. Applies if separately billed or itemized with cost and transfer fee. I haven't seen much up around here in move-in and move-out fees. I think maybe they have a lot of it in Southern California, but I haven't run across a move-in and move-out fee by an HOA. But it is
I
good.
think the Woods over there on Fremont Boulevard.
They have.
I think they do.
They have them?
I think so.
Yeah, I haven't done one over there in
It's huge.
years. Yeah. How much is it?
Something like $2,000.
Really?
Yeah.
Wow.
Right. But that, and then.
Well,
they
they've
get it back
always,
if you-
Fremont Woods,
Yeah, Fremont Woods, you get it back if you didn't do anything that you didn't.
over off Farwell you're talking about.
No, not
Behind
Farwell,
Kennedy.
no, Fremont. Fremont near Stevenson and the Fremont Woods?
Yeah, when you go behind Kennedy High School.
No,
I thought that was Fremont Woods.
no, it's not.
What's the name of that?
I'm thinking something else.
I'm thinking of I forgot the name. I thought that was Fremont Woods back in there.
That's, no, Fremont Woods.
Okay.
Fremont Boulevard.
Okay, yeah, well, that's good to know.
They
I
got a
haven't-
move-out fee, but if you did anything to the inside without their approval.
So they come and inspect them?
Oh, yeah.
Oh, good to know. If I ever do one there.
Cause you got a lousy HOA.
Well, yeah, they probably need money. Yeah, they're looking for
Yes.
ways to collect money. Yes. Question?
Just to go back just a little bit, you were saying.
Can't go back a little bit. No. You don't have time for that, sorry. Go ahead.
You were saying there was a one-time like tax fee, what was that? Or it was like a one-time payment you have to do?
City treasurer?
City of Oak, some cities transfer fee is a one-time fee.
Well, we're talking about, okay,
Transfer fee is a one-time.
the fees that are spelled out, all the fees that are spelled out here in this contract are all one-time fees. They're at the time, at the sale. They don't recur every year. So you only pay a county transfer tax each time the property is sold and transferred. Same with the city transfer tax. You only pay that once at the time of sale. And it's typically, and again, customarily, it's typically split 50-50 between buyer and seller, okay? But yeah, you don't, those are one-time fees. I mean, all of these fees here are all one-time fees. The only one that could continue each year and in the future is a home warranty. You know, you can buy a 1-year home warranty for a buyer. Buyer or seller can pay for a 1-year home warranty for the buyer, and the buyer can renew that home warranty every year if they want to. About a month or two before it's gonna expire, they'll get a notice saying if you wanna if you want to renew this policy, pay us so much money and we'll renew that home warranty, and it can continue for a couple, as long as they want to pay it. It's usually, in my experience, it's usually a little higher, a little more money. But it depends on the age of the house and the age of the appliances. I mean, I kept one in place on one of my houses for a couple of years, and I kept using it. Stuff kept breaking, so I got my money out of it. It's an insurance policy. And you can put one on your own house. You don't have to buy a house to go get one, to get a home warranty.
I put them in all my rentals at one time, but they finally wouldn't let me do it anymore.
Private transfer fees, don't see them a lot. They are now illegal for a property built after 2011.
Good.
But anything built prior to 2011, we typically, the only time I've seen them is out in the valley, out in the Central Valley. There's a couple of developers came up with this idea to collect money, try to recoup some of the money they had to pay to develop the property, the payments to the city and whatnot. So they put these private transfer fees recorded on these properties. It means they get paid every time the property sells. They get paid money, and you don't see it too often. But you won't see it on anything built since 2011.
Melrose is different than that?
Melrose is completely different, yeah. Melrose is a special assessment.
Right.
That falls under property tax. Yeah, that's not a private transfer fee. Talk about home warranty. Typically the seller pays for a home warranty, customarily pays for a warranty. Buyer can waive it. You on the right, you want to list the name. On the first column, you want to list the name of the warranty company. Then you check who's going to pay, and then you put the dollar amount, cost not to exceed, and then, issued. Home warranty plan is where you list the type of plan. They have different plans, different price points, and then you put the cost not to exceed on the right, and issued by, you put the name of the company. If the buyer doesn't want a home warranty, there's a box to check a waiver. The reason you want that there is if there's not going to be a home warranty, you want a written waiver so that in the event that you have an E&O claim and the E&O insurance provides for a reduced deductible, one of the criteria for the reduced deductible is that there either was a home warranty purchased or the buyer waived the home warranty. So you need that in the contract. Moving on.
Other terms.
Okay, so paragraph 4, we're dealing with this lists the addendums that are the addenda that are available, and like I said earlier, you got a probate sale. Now you can use this contract and attach the probate agreement purchase addendum. You've got a manufactured home or mobile home, you can use that addendum and attach it to this. You don't have to do this separate agreement. We already talked about TOPA, tenancy in common. You don't see a lot of that around here. You'll see it in San Francisco. That's where you own a piece of the whole building. Stock cooperative, there's some of that in San Francisco too. You don't see a lot of that around here. Under other addenda, you've got the addendum. So let's just say you're writing some. There's an additional term section.
Before the bottom of page.
Where is it?
3.
It's
Other terms are.
Is it number 5?
Where is it here? Where's that?
It's in the bottom of page 3.
Page 4, number 5.
Is it 3? Yeah, that's why I didn't find it. Yeah, other terms, 3R at the bottom of page 3. You only got 3 lines there. So if you've got, for some reason you got some special term that's going to take a lot of writing, then you could put it on an addendum form, and that's where you would reference the addendum.
It just automatically flows to text overflow.
You can do text overflow too, yeah. Backup offer addendum, that's if you're writing an offer as a backup to an existing contract. Again, study that one if you're going to consider that. Don't know that we'll, going forward, we'll see a lot of backup offers at this point, but it's always a possibility. This next one's real important if you're dealing with a property that may have a septic system, a well, needs surveys, or has propane tanks. So if you get into rural areas, then you quite often, and it's an excellent form, it's got everything spelled out as far as what needs to be done when there's a septic system, when there's a well, if it has a propane tank, and so forth. I bought, the house I live in has a well, okay, so I had to go through the necessary steps to have the well inspected. I have a listing that has both septic and well and propane, and so there's certain criteria. Again, it tells you what, what needs to be done as far as inspections for those things. Property monument, you might have a property rural that's not, that the property lines aren't clear, they haven't been fenced, and so you may need a survey to determine exactly where are the property lines on the property. Short sale denim, hopefully we won't see that. That's where you're negotiating with the lender because the loan's greater than what the home's worth. We went through that once, I hope we don't do it again. Could though, if the values keep coming down, we might see short sales again. That'll be a whole nother class. Court confirmation addendum. Court confirmation exists primarily in probates, and that would be addressed in the probate agreement per addendum. The only other court confirmation that typically may come up would be in a bankruptcy, where you've got to have basically you've got to have a trustee, bankruptcy trustee approve the sale. And basically a bankruptcy trustee, if there's no equity in the property beyond the homestead exemption, the trustee doesn't care about the house, and all you do is send them a settlement statement, and they look at what the net is, and if it's less than the homestead exemption, then they'll usually get an approval fax back to you within a day. It's a pretty quick process. At least it was the last time I did one. Homestead exemptions typically going to run up to $125,000. Last time I checked, up to $125,000. So that's a protected amount of equity in a bankruptcy situation. Talked about 1031 exchanges, so it's now got boxes that you can automatically check for buyer intending to exchange or seller intending to exchange. You check the box, and that form will auto-populate. And then I'm teaching a class on tax laws in November. So it'll be at least 3 hours. I'll go through every tax law that affects you. I'm actually going to add income taxes on top of it. But yeah, we'll go through every type of tax law. We'll go through how 1031 exchanges work and so forth.
Steve, do you have a date for that?
Yeah, there is a date, I just don't know it off the top. It's on my calendar, I just don't remember the date. If I think about it, I'll text it to you. I've got dates, I've got classes on the calendar for October, November, and December. Yeah. Okay, then C is buyer and seller advisories. It says, note, all advisories below are provided for reference purposes only and are not intended to be incorporated in this agreement. So your advisories are not technically part of the purchase agreement, but they do need to be given to the clients. They're important for them to receive and to read. The first four are automatically checked, and those are automatically printed out. Inspection advisory, the wire fraud, the fair housing, and the Consumer Privacy Act advisory.
The big one would be the county advisories.
Well, that's where I'm getting to. What I require as a broker is that we include the statewide buyer and seller advisory, and then as a local advisory, if you get to the last page of the SBSA, it has a reference to local advisories, and you would include, if the county has a local advisory, you would include that. So Alameda County has an Alameda County Disclosures and Disclaimers advisory. It's in, if you go to Zip Forms, and you go to the drop down for library, and you go to BASE, Association of Realtors, you'll see Alameda County and Contra Costa County disclosures. So
I'm finding most counties have one now.
Yeah, I think a lot of them have.
If you Google it,
Yeah.
you'll get it quite
Yeah, I think a
often.
lot.
It won't be.
Yeah.
They typically doesn't have all of them.
Well, they just have what's in their jurisdiction, and then
Right.
there's a San Francisco library in Zip Forms as well that'll have a San Francisco one. Basically, the way the system's set up right now is that you kind of have to be a member of the MLS that governs those counties to have immediate access to those forms. Yeah, so you got the statewide buyer and then the county, I mean, it's about, I think you're looking at about 36 pages, I think, total for those two.
I'm
But like I
writing an
said
offer on
earlier.
Lake County.
What's that?
I'm writing an offer on Lake County, in Upper Lake, and I had to go find that. I knew they had one, so I went and found it. I Googled it.
And, you know, I say this over, you need to read those documents. You need to know what's in those documents. You can't adequately represent a buyer-seller if you're not familiar with what's in those documents. There's a wealth of information in there.
One in Sonoma County's got some really odd things in it that, I can't remember what they were now, but I know that they were really different. Ben had a listing over there at one point.
Yeah. Yeah, well, you're gonna have certain areas might have certain, you know, geographic issues, things that you gotta.
That's why you gotta read them.
Exactly, you gotta read it.
We add all these to the purchase contract.
You could get yourself, you know, get you or your client in big trouble if they're not aware of everything.
These are all attached to the purchase contract, right?
Yeah, when you check check one of these boxes, then that form pops up for you to fill out. So again, so always the statewide buyer and seller advisory is.
Well, that local one, I add that local one.
Yeah, the local one you have to add, because you've got to go in the library and pull it up. All right, moving on, let's see.
I'm surprised.
We've kind of covered deposit pretty well. 5A3 talks about buyer and seller advice to consult with a qualified California real estate attorney before adding any other clause specifying a remedy such as release or forfeiture of deposit or making of a deposit non-refundable for a favored buyer to purchase. In a residential transaction in California, non-refundable deposits are not enforceable. So just stay away from even trying to go down that road. There's been 2 cases that have held non-refundable deposits are unenforceable in California, okay? They are enforceable in an option agreement where you have a lease with an option to buy, and you say, yeah, I'll lease you the property, I'll give you an option to buy the property in the future, say for a set price, and you give me consideration for that option to buy. That option consideration is non-refundable, that's legal, okay? Because you're paying money for something that you're getting in return, okay? In commercial transactions, deposits can be non-refundable. It's when they talk, if you ever hear them talk about they'll talk about a deposit going hard. Okay, that means when the deposit's gone hard, that means it's going to the seller. Okay, it's gone out from escrow to the seller. But they're unenforceable in residential transactions in California. Drop down to loans.
You know,
5C, I'm sorry.
When you're more on deposit, I know, so why would someone do an increased deposit again?
Because typically, 1 of 2 reasons, either they don't have all the money up
Yeah.
front at the time they write the offer, or they want to wait and put up some of the deposit after they remove contingencies. On the philosophy being,
Yeah, 'cause
unless I'm in bad faith, you're not gonna have a right to get my deposit anyway, so it doesn't need to be the full amount. It doesn't need to be 3% until I've removed all my contingencies. Now they're at risk. That's the philosophy behind it. Question. Is a deposit, don't blurt out the answer right away, but is the deposit required?
Yes.
Who says yes? Who says no? The no's win. Deposit's not required.
I thought you have to have for a contract to be enforced, you have to have some money involved, no? No?
No, there's
That
plenty,
would be
there's
like
plenty of
conflict.
consideration between the parties as to what they're gonna do and not do and give up and so forth. You don't need that money element.
I thought it was $1, but something has to be there, no? Okay.
Number 2
Question.
is, go ahead.
We never accept anything other than either a wire or a cashier's check. But if the buyer was to insist on a personal check,
Well, it's just gonna take a while for it to clear. that they,
But if you haven't, if that wasn't in the contract, which it never is, that, hey, we'll only take, a
you
wire
can issue
or
a notice to
kitchen set.
perform, you can issue a notice to perform as to what was required.
No, but what if it's not stipulated in the contract?
Well, the contract stipulates wire.
Or it does stipulate one?
Yeah.
Contract
By
So
default.
you can't hold them, listen, we'll only accept a cashier's check in lieu of a wire. Okay.
The contract defaults to wire.
Oh, thank you.
I have a question on adding to that. So if buyer says, okay, I only have a check and I'll drop off the check at escrow, in the meantime, we take a non-contingent offer and we, seller and buyer, we are in acceptance of that offer, and they next day say, hey, I want to put a stop payment on my check, I don't want to buy a home.
Okay. So what happens? If there's no deposit put in escrow, the liquidated damages clause does not apply. It's null and void. So now, seller has to prove damages. So seller has to determine, have I been damaged by this cancellation after 1 day? Well, that's gonna be a question of, that buyer agreed to pay price X. When after 1 day of canceling, I put it back on the market, am I gonna get X or more, or am I gonna get less than X? If I get less than X, that difference is my damages, which I can sue that buyer for. So then it just depends. Now, obviously in this market, who knows? That next buyer might come along right away, or you may take a couple months and the price may be going down. That would establish your damages to go after that buyer.
Steve, there's practicality, have you seen much of that, where the seller goes after the buyer?
Well, I've seen sellers keep full deposits where buyers were trying to buyers were canceling and not wanting to give up the deposit, and but they made a crazy offer, and this is say example, deposit's 50 grand, and they made this ridiculous offer and then canceled later on, and the seller resells the property for $150,000 less than that price. Well, seller was damaged and seller's entitled to that $50K, because they, see, a buyer can argue if the seller resells the property for the same price or has very little damages, the buyer can argue that deposit's unreasonable, that 3% deposit's unreasonably high because you didn't incur any damages. Well, you gotta wait for the seller to resell to find out whether they are damaged or not. You can argue that number down. Okay, it's not an automatic that the seller keeps 3%. But in the market we're in now, the sellers, quite often end up selling for much less. The damages are established. The buyer can't make that argument.
But you haven't seen much of that if the deposit hasn't come in, let's just say the offer.
Oh, we get yeah, I see it. For a while there, I was seeing about once or twice a month. That was happening.
Even without deposit coming in?
Without, they weren't putting up a deposit. Well, what was happening in most cases is the seller was just moving on and just forgetting them and not worrying about it.
Right.
And in
what
most
I meant
cases,
was the seller going after them.
no, I don't, because typically, until recently, they were able to pretty much get close to the same price again. They hadn't dropped that much.
Or more.
Yeah, so it just depends, the challenge now will be, if you lose a buyer, how long is it gonna take to get to number two?
Yeah, I wasn't referring to in the last few years, because obviously markets have on the rise, but if you go back to your earlier days, say, 2007, 2008 through 2010, 12, when the market was driving down.
Yeah, we didn't see.
Even then, yeah, okay, got it.
The problem is, it costs, attorneys are expensive to go out, and it costs a lot of money to go after someone for 30, 40, 50 grand.
Is it worth it?
Yeah, and so it may not be worth it, it gets a point where you just gotta, cut your losses and move on, I mean, there's gotta be, generally speaking, if you don't have a dispute over at least $100,000, it's probably not worth it to even go down that road. I mean, you can go to small claims court for 10,000, but yeah, I mean, the $30,000 to $50,000 to $70,000 claim you're kind of in no man's land, because you're gonna probably spend 30, 40, 50 grand on an attorney. to try to get that 30, 40, 50. Is it worth it? Probably not. That's just the reality of things. Now, when we talk about going to, very few cases go to trial. I mean, I've seen trial estimates after a case has already gone through some discovery. I've seen trial estimates for $100,000 to $150,000 to take a case to trial. Well, how much is in dispute? You're gonna spend $150,000 to go after $75,000? Probably not. Yeah, that's the challenge with litigation. Very expensive. Did I see a hand somewhere?
So where does it state in the contract that money has to be wired?
Right in the beginning. 3D1, within 3 business days after acceptance by wire transfer.
Yeah, and then if you're not, you gotta check and put by like check or something.
Yeah, it's right there. Defaults to wire transfer. If you're doing it up some other way, you check the box and write in the other way.
Okay, thank you.
Yep. Okay, 5C3 talks about buyer's loan status. Buyer authorizes seller and seller's authorized agent to contact buyer's lender to determine the status of any buyer's loan specified in 3E or any alternate loan buyer pursues, whether or not a contingency of this agreement. If the contact information of the buyer's lender is different from that provided under the terms of paragraph 6B, buyer shall deliver the updated contact information within 1 day of seller's request. So again, that wasn't in the contract before. That lets the buyer know that it's okay for us to contact their loan officer to check. Now, here's where it gets a little tricky, because it says check the status of the loan. It doesn't ask about, what's their credit score,
How often that's done.
Okay. Now, if you start asking those kind of questions, then the loan officer says, I can't answer those for privacy reasons. You go, no problem. Just hang up the phone, call the buyer's agent. Now, you're the seller, okay, you're the listing agent. Call the buyer's agent and say, hey, loan officer won't answer some questions I have about the buyer's creditworthiness. Would you please call the buyer and have them call the loan officer and give the loan officer permission to talk to me? They'll do it every time. Because when I'm sitting there looking at an offer, especially if I've got more than one, I want to know who's the strongest, creditworthy buyer. I'm not going to rely on the pre-approval letter. So I always make those calls to find out, tell me about this buyer. Do you have it? Have you run it? Do you have a written application? Have you run a credit report? What's their credit score? Do you see any issues with getting this loan approved? Tell me about it. Okay. Get it all out on the table so you know what you're dealing with.
First of all, you gotta get that back on for people on YouTube. And, I see, and just by listings, that buyers have one lender, and then later on, it's a different lender.
Yeah.
And can you address that?
Yes. It's okay for a buyer to switch lenders. However, they can't cancel for failure to get a loan from that switch lender. They've got to, if they can get a loan with the lender that they started with, they're obligated to get that loan. But they don't, the courts have said that buyers don't have to notify the seller if they switch the lender. Yeah. Now as a listing agent, you'll find out typically, you'll find out when you get, depending on when the switch occurs, because you'll get a call from a second appraiser. Now, I've had cases where the buyer's dual tracking a loan with 2 lenders, and that's perfectly fine. And they have 2 appraisals. And you'll know it as a listing agent, because the appraisal will have been done, and then 3 days later, you get a call from the appraiser, go, well, who are you? Oh, they're running a loan through another lender. There are loan officers that will do that.
Okay.
Boggles my mind. So you're gonna process a loan with no guarantee of getting paid? More power to you, because that's what they're doing. They're both doing it. I've had my own clients do it. And there's loan officers willing to do that, knowing, one of them knows they're not gonna get paid. But they're running it all the way right up to the end.
Wow.
Sounds
But you
crazy.
don't have to notify.
No, they don't, they're not.
So-
What they're obligated to is, where is it here?
it's not important unless it doesn't close.
What's the
Yeah,
reasoning for
right,
that?
exactly, it's not important unless it doesn't close, yeah. There's a representation, where's the representation clause here, hold on.
But isn't the offer contingent on the terms you present from the beginning, including the lender?
Yeah, well,
and
the-
the pre-approval?
Yeah, it doesn't, yeah, the terms are what are important, doesn't matter.
Oh, I see.
Well, let me get to the clause I'm thinking about here because it addresses which Pat's saying here. Here we go.
One says the buyer has to use.
Here's what it says, buyer stated financing, 6C, top of page 5, okay? It says sellers relying on buyer's representation of the type of financing specified, including all cash, amount of down, contingent or not contingent. Sellers agree to a specific closing date, purchase price, and to sell the buyer in reliance on buyer's specified financing. Not the lender, just the financing specified. Buyer shall pursue the financing specified in this agreement, even if buyer also elects to pursue an alternate form of financing. See, so buyer has to pursue the financing specified, but they can pursue an alternate form, which could be with another lender. So it's okay to go with another lender. Seller has no obligation to cooperate with buyer's efforts to obtain any financing other than that specified in this agreement, but shall not interfere with closing at the purchase price on the close of escrow date, even if based upon alternate financing. But then it goes on to say, buyer's inability to obtain alternate financing does not excuse buyer from the obligation to purchase property and close escrow as specified in this agreement. See, all it talks about is, doesn't talk about, it's not about switching lenders, it's alternate financing. Now, alternate financing likely is another lender, but it's okay. But if you're over here, let's say you write the contract and say, I'm gonna get a fixed rate loan, and then you go over to this other lender and you're trying to get some adjustable type loan, and you can't get it, you're obligated still for that fixed rate loan. That's what the contract says. You can't cancel, you can't cancel the contract in good faith because you can't get the adjustable loan. You wrote down fixed here, that's what you've got to pursue. And that's what that paragraph says. You can do all this alternate stuff, but at the end of the day, if you can't close on the alternate, you're obligated to close on the fixed rate loan.
Okay, so if you do an addendum to all this, saying I'm
Or an
changing.
amendment, yeah.
Go ahead. I did,
Yeah,
I
go ahead.
don't know what I did.
Go ahead, I'm
Anyway,
not playing
I
it.
don't know what I did.
I'm just trying to get
I
it
might
in the
put it on the
vocabulary.
amendment, I don't know. Anyway, that, we're switching lenders. Now we've switched if everybody agrees, right?
You can do that, but you're not required to. Not,
Dang.
yeah, no,
I'm doing these extra steps. now.
not required.
So why were your clients doing all that to them, both two lenders?
Because, it was all about interest rate.
Oh, interest rate. So they do it up to a release of contingencies and then pick one, or?
Yeah.
I mean, once they release a contingency, they just.
It was a $3.5 million purchase. So it was a $2,800,000 loan. It was a big loan.
Mm.
You know, an eighth or a quarter can make a difference when you get to 2.8 million.
Yeah.
Yeah, I mean, it, you know, and so they were tracking, had two lenders tracking it, two appraisals. I met two appraisers at the property at two different times. Actually, yeah, I think there were two different times. I think I tried to get them there. Oh, actually, I think I got them both. I actually got them both at the same time. And it was funny because they were both from the same company. They both worked for the same company.
And the lenders know of each other?
Yeah, oh yeah, they,
Yeah.
well, they didn't know who they were, but they both knew they both knew the buyer was getting, they both knew they were competing with another one, yeah.
Mhm.
Yeah, I've had it, about three times that I can think of.
Okay, it comes down to the better rate, and.
Yeah, well, that's what, yeah, I mean, they all have different sources and then, well, you can try to beat them up on points and stuff too, and get them to credit, get credits from them and stuff like that. And you can really try to work some of these guys. When you get into you get up that high of a loan amount, yeah, you can, they don't want, they'll give up a little, they don't want to lose the deal.
Yeah.
When you get into that amount of money.
Yeah.
I mean, generally, just so you know, folks, generally speaking, a loan officer's gonna, depending on who they work for, they could be getting, some of them are getting like flat fees, but they could be getting up to, say, half a point on the loan amount.
Even 1 point.
Now, they don't, no, their broker's taking usually 50 to, the broker's usually taking 50 to 50%, 40 to 50% of that. When I did loans, I was on a 60-40, so I was getting 60%. And at that time, the prevailing points was 1.5. And I was charging 1 1/4. And I have clients that, well, customers are Fremont Bank, and I quote them a rate, and they go, well, we're gonna go to Fremont Bank. I go, fine, go to Fremont Bank. They get a quote, and they call me back, and say, well, what'd they quote you? I said, well, I got that beat. Not even counting the points, I have the rate beat anyway. Because at any given time, there are certain lenders that have really good rate. There was a company in Texas that just had unbelievable rates. They were beating everybody out. So we just kept giving all our loans to that same company until they dried up with money. That was the one, because their rates were really attractive.
If a buyer writes an all cash offer and then goes to the lender to get a loan.
Well, they're gonna be in trouble if they can't close.
Yeah, that's the only thing.
I've had that happen. But where that ticks you off is you may have had a higher offer, a higher finance offer that had you known they were gonna switch. Usually they're switching from cash to hard money. It's usually not conventional.
Yeah, that's what they do.
But still, I mean, it's still a loan approval process. And I mean, I've had it where had I known they were gonna do that switch, there was another loan buyer I would have gone with that was offering a higher price that was financed. So that's where you get upset, is it's like, you go with them and then they pull that switch. I don't even know, that agent for the longest time when he'd see me, he'd walk the other way, because he knew I was ticked. He wanted to join our company. I didn't want to join our company.
So the difference was in the closing period of time, from cash to hard money, or what?
Well, yeah, it was, yeah, I mean, I'm on vacation. I think I'm on Maui. And I got this one of my escrows that's due to close like a couple days later, and I get a call, and it's the agent saying, hey, we got a problem, we're gonna, closing to be delayed, the lender's not ready to fund. What do you mean the lender's not ready to fund? This is supposed to be a cash deal. I was just,
What lender?
well, see, and I mean, it wasn't, I didn't care if the closing was delayed a couple of days, but I was upset because of my seller. I mean, my seller's expecting this thing to close. You have no idea what this seller's financial situation was, how bad they may need the money. Who knows, a couple of days could be a do or die situation. I'm exaggerating, but the point is, you don't be that flippant about it. You should have said from the day one, oh, we're getting a hard money loan. Don't tell me it's all cash so you look better in a multiple offer, and then you're doing a hard money loan at the end. I mean, hard money loans typically are pretty easily to get, but it depends on how much. Depends on how much.
Do you provide proof of funds? Proof of funds.
Oh yeah, I had full proof of funds of cash.
So they had the money.
Oh, they had the money, yeah,
okay.
yeah, but they wanted to get a hard money loan. They decided to get a hard money loan.
Hard money loan.
Oh,
Yeah,
so-
but they wanted to delay. They were delaying the close.
As long as they close.
They were delaying the close.
So that was their alternate financing, they switched to hard money loans instead of using.
What's that?
So that was their.
Contract
alternate-
didn't say that back then.
Oh.
This clause wasn't even in the
But I mean, that's what they did, they had like a bank account
Well,
showing
now,
no
but
cash. and
alternate
it's just-
financing compared to some other states' financing is different. This
But-
is cash to finance.
I know, but their proof of funds was like a bank account, and then they switched to hard
And
money.
they had the money, they had all the cash.
But then they
So
just did.
for the extension, I would ask for the deposit to be released to the seller, and we'll give you the receipt.
It's unenforceable.
Oh, it may not be enforceable, but if they release it,
Yeah.
collecting it back is not easy.
Oh, yeah, no, it's not.
That's the
No,
point.
it's not. All right, moving on.
Another question that I have, there are many buyers who are like, oh, they found someone, a lender, and they will say, after we get in contract, I'm gonna look for other lenders. And my response to that is, if you know know that you're shopping around, shop around before the offer, and now that I know they can make a choice between two
Yeah.
or three after,
Well,
but.
the problem is
It's the time
the
frame.
potential delays
Yeah.
in shopping around and then going with someone late into the process. That's what they're not taking consideration. They're thinking, oh, they can just do it, in whatever time is left. No, you're right. You're better to shop around before you get in the contract. I mean, I always tell a buyer, you need to know, in order for me to write an offer, you need to know what type of financing you're gonna get. Until you know what type of financing, I can't fill out the offer.
Yeah.
If I say, are you getting a fixed or adjustable? Well, I don't know. Well, then you're not ready to write an offer, because I gotta specify one of those two on this, and I gotta know what the interest rate is.
Yeah.
You're not ready, see, you gotta educate them. The agent, where they worked in the past, didn't educate them. You gotta say, you're not ready then. You need to finish this pre-approval process. You need to figure out who your lender's gonna be and what kind of loan you're gonna get, so we can specify that in the contract.
But don't you also contact the lender to confirm stuff or no?
Oh, yeah. Yeah. For sure. See, typically, if I'm referring my preferred lender to them, I'm back and forth with that lender constantly. I know exactly what's going on. I know wherever the status of that loan throughout the whole process. Today, it's a lot different. I mean, everything's so automated. You can, people that are good record keepers know how to use their computers. They can give the lender everything they need in 30 minutes. And they can upload it in their system, and they can run a credit report, and boom, they do, their system will kick back an approval. Say, hey, I got an approval, there it is, because assuming everything they gave us is correct and true, it's just a matter of verifying that information. But if they give them all the right stuff, it's really not that difficult anymore.
Yeah.
The biggest challenge is people having all the paperwork that the lender needs readily available to give the lender everything.
Yeah.
That's the biggest challenge.
So who's the lender like Texas these days?
I don't know. I'm not in it at that level. I did loans for about 2 years while I sold, and the problem was I was spending too much time on the loans and not enough on real estate sales. When you look at the 3% versus 60% of the 1%, 1.25% of the loan, would do the math. It's like, where do I make more? I make more money over here than I do here. I was chasing down paperwork all the time. It's like, after a while, this doesn't make sense. Okay. We talked about the FHA, VA, the lender requirements. That's what 5C4 talks about. Buyers to deliver either a repair request or amendment of any lender requirements the buyer requests seller to pay for or otherwise correct, or state that there are no lender requirements. Notwithstanding seller's agreement, the buyer may obtain the financing, seller has no obligation to pay or satisfy any or all lender requirements unless agreed in writing. So, like I said earlier, I mean, the way this setup, there still needs to be an agreement. There's no concrete agreement at the time you enter into the contract. It's still negotiable. Well, that doesn't really give me a warm, fuzzy feeling when I'm representing the buyer. I don't know whether we're gonna have a deal or not. So if I'm representing a veteran and it's a VA deal, I'm writing in seller to pay for a Section 1 certification from a registered structural pest control inspector. So there's no question. Well, and it's even easier if there's already a pest control report. You know exactly how much money. I mean, I had a seller on a VA deal a few years back. We already had an inspection. I saw the dollar exposure, and I said, Mr. and Mrs. Seller, or Mrs. Seller, I said, hey, this is a veteran. In order to do the deal with him, you need to do these repairs. Are you okay doing it? I said, sure. So we did all the repairs. I'd have the appraiser come back and look at them. There was a bunch of damaged boards and a deck, so I brought him out. I said, well, tell us which ones you want us, and he goes, well, do that one, no. I picked out which ones I figured he was gonna call. So I told the seller, her boyfriend, I said, replace all those boards, the ones I marked, do all those. Then brought the appraiser out, and he looked, and goes, oh yeah, this looks good, you know. And we were off to the races. But, you know, that was at a time when it was hard to get sellers to consider VA, because they didn't want to do, we were selling everything as is.
What's the reason behind that, kind of, just because they're veterans, they could be injured or something, so you want everything?
No, it's just, it's the cost and the time. And the problem when you get into pest control is there may be further damage. When you start opening stuff up, it grows, it gets bigger.
Why is it mandatory for VAs and not like FHA?
Because it's a government loan.
Government loan.
The VA loans still to this day require Section 1. FHA removed it about 10, 15 years ago, 20 years ago probably now, but the veterans still insist on it. CalVet loans, I think they're still out there. CalVet still requires them too. But CalVet's typically about a 5% down loan. Last time I checked, they weren't that competitive. For a while, they were competitive on their interest rate, but I don't think they are. But they want Section 1 and roof as well, if they're still out there.
They are. We've got one in our office right now.
You have a CalVet? Yeah.
Wow.
Yeah.
I don't know, CalVet is not FHA, it's a veteran, right?
CalVet, yeah. CalVet's different than CalVet. I think that's a different loan. CalVet's. I've gotten away from the first-time buyers loan. I'm not on top of all that type of financing. It's a different world now.
Market conditions dictates everything.
Yeah. Limits on credits to borrow, we already talked about that, okay? You can only have a credit up to actual closing costs, and any unused credit, you know, doesn't go to the buyer. But you shouldn't have any unused credits. You should always, you know, use the total credit up for a rate buy down. 6B, we talked about verification of loan application. We talked about pre-approval letters. You know, the letters should state that it's based on a review of buyer's written application and credit report. So I will question loan officers on that. You know, do you have a loan app? Have you run a credit? You know, what's their score? That sort of thing. Buyer stated financing, we've already talked about that. The contract on paragraph 7, closing and possession, paragraph 7A, occupancy, the contract that says that the buyer intends to occupy the property is indicated in paragraph 3E3. Remember that you get a lower interest rate when the buyer's going to own or occupy the property, so the lender's looking to the contract to confirm whether the buyer is going to own or occupy. Plus, the buyer owner occupying is relevant to the liquidated damages clause. The 3% liquidated damages applies when the buyer is going to own or occupy the property. If the buyer's not own or occupy the property, the deposit is, whatever the deposit is, that's subject to liquidated damages. There's no limit on it. So you gotta be careful when you have an investor, you put a big high deposit, that 3% doesn't apply on an investor because they're not owner occupying the property. Okay. But again, you've got that argument about how much the seller's damages and is it unreasonably high because the seller's not damaged as much. They're not going to automatically lose it. 7B, property shall be delivered as is in its present physical condition as of the date of acceptance. What does that mean? That means that means there are no warranties as to the condition of the property. In the old contracts, when I started 33 years ago, our contracts required the seller to provide a Section 1 certification and to certify that all the appliances built in, all the equipment was all operative, plumbing, electrical was all operative, there was no defects in the chimney and fireplace, that the roof was leak-free. Those were warranties in the contract. And then we'd go do all these inspections and reveal all these problems, and the seller was on the hook for everything because they'd already contractually agreed that the property was in good operating order. So a seller was really signing a blank check back then. I can remember when I got into business, I go, this is a crazy way to do business. Because we'd go off and we didn't do pre-sale inspections. Buyer go off and do inspections, come back with $15,000 worth of work, and the houses were only, $200,000. And the seller go, if I'd have known I had to pay for all that work, I would have never accepted the price I did. Well, sorry, you're out of luck, that's how it works. Well, then we learned real quick, and by 2000, this isn't gonna work with all these multiple offers. We gotta change this whole process. That's when we got into pre-sale escrows, pre-sale inspections, to determine the condition of the property, and went to the as-is sale. But before, it wasn't that way. So as-is just the way it sits, subject to seller's disclosures and any inspections that the buyer may do. Now, the buyer can request repairs, but the seller's not obligated to agree to any repairs unless it was contractually written in up front. The property, including the pool, spa, landscaping grounds, is to be maintained in substantially the same condition as on date of acceptance. This is huge. This is what you gotta remember. Remember, whether you represent the seller or buyer, that seller has to maintain that property in substantially the same condition as on date of acceptance. Was it fresh, was it clean? Was the lawn mowed? You gotta maintain it. You gotta keep the utilities on.
What if it's not? What if the sellers live in there and they live kind of
subject
like,
to damages for the correction of that.
like they kind of live messy and there's trash
Yeah,
on the.
well, yeah, that's all, those are all costs that the buyer can get from the seller in small claims court or through mediation. Because they're
I mean,
obligated.
it was like that when it was for sale.
Well, then that's how, they only have to deliver it in that condition.
Yeah.
They don't have to upgrade it.
That's right.
They have to maintain it.
So if it's
substantially.
already trash,
That's
then they
how
can
it
leave it
is.
trash.
That's how it is.
But if it's clean and then they
It
leave
has
it
to stay
trashy,
clean.
then, yeah, okay, all right.
You gotta make sure that vacant properties are the most difficult. Vacant properties without automatic sprinkler systems
Yep.
are the most difficult.
Yep.
Because the lawns aren't being watered, especially now in the drought. You gotta get sprinklers on timers. You gotta do something, because you gotta keep this lawn green.
And to make sure that.
Gophers can be a problem with a vacant property. We had one where the high-end house, and sellers were gone, and the gophers went crazy. Backyard looked like a scene out of Caddyshack. Gopher holes all over the place. Cost the seller over $1,000 to get rid of all the gophers in the backyard. Buyer didn't buy a house with gophers in the backyard. Same thing when it comes to doing repairs. Watch out for pest control companies that they'll bid repairs and there's painting involved, and all they'll do and put in their bid is primer paint. Did the buyer buy a house with primer paint on it? No, I bought a house fully painted. Doesn't matter what the pest control report says. Seller's gotta satisfy the contract.
So it's like section 1.
Yeah, like, so I mean, like if they're replacing all these rafter tails in the eaves,
Yeah, they gotta repaint.
they can't just stop and primer it. It's gotta be painted to match. That's what the buyer bought. Gotta watch for the shower enclosures. The companies are notorious for bidding shower enclosures with plain white tile. And the shower's got granite or marble or whatever. What did the buyer buy? He bought the granite. I can't tell you how many deals closed with white tile showers when they should have been granite, but no one put two and two together. Because because they thought what was in the report controlled. No, it's not. The contract controls. Yeah, we don't deal with a lot of that now because we haven't done, generally speaking, we haven't done that much in the way of repairs and escrow for 20 years. We might start again, but we haven't up till now. So but you gotta be careful, you gotta be real careful when you get into that, because here's the challenge, folks, or the problem is, if you write a contract that calls for repairs, the seller to perform certain repairs, guess who sees that contract?
Lender.
The lender. So now the lender is gonna say, oh, you're asking for a section 1 pest control certification. I wanna see the pest control report. Now the underwriter might start asking for more stuff. We've had lenders ask for section 2 work.
This is a strong argument to get all the inspections done before you ever hit the MLS.
That's right, that's right. That's why we
It's
do
the only
them.
way to go.
Yeah, that's why we do it.
Sellers don't want to, because they don't want to know what's wrong with their home. But lately,
Don't
we've
want-
been able to talk them into it and say, look, it's in your.
Well, especially
best
now,
interest.
especially now, in this market. Now, you gotta get it up. I showed a house the other, before I left on vacation in San Jose, downtown San Jose. And I don't know what this agent's thinking, this house has a basement. Not almost as big as mine. And it was built like in 1912 or something.
Oh, jeez.
Now, there's some beautiful houses down there in South San Jose over by the university. And it's full of stuff. I mean, it's got a concrete floor, but I mean, there's just boxes all the way everywhere. Just the whole basement is just full. You can barely walk around the basement. You can't even walk up to the furnace. It's just full of stuff.
Thank God.
And I'm sitting here, and the inspector managed to get in, crawl his way through and see some of it, but he didn't see all of it. And I'm thinking, you expect a buyer to buy this house and not be worried about a further inspection of the basement? I mean, you gotta get this stuff out of here. I mean, if we do decide to make an offer, it's like, that offer's gonna state that they've got to clear that basement out completely to allow for a complete inspection. I wouldn't let that buyer buy that house
See,
without
they
being able
weren't
to
counting
inspect.
on you showing it. They wanted some dummy to show it.
I mean, I couldn't even check the foundation. It's a house over 100 years old. We're gonna buy it without having its foundations inspected?
But
I mean,
usually the garages are full.
What's that?
If the seller is still in the house, the garage is usually are full. You have no access to the garage.
Well, there was
But
stuff in the garage, but this guy was, they were into Halloween. There was boxes, the basement, the garage, closet, had Halloween. In fact, I can't imagine what this house looks like, if they're still around. But you walk into the garage, and in the back of the garage was this big old, it was like a big desk. And they're sitting, there's like a chair, and there's like a mannequin all dressed up in long hair, sitting at the chair up against the desk. It was the weirdest thing. I walk in and go, at first I thought, oh, there's somebody, I go, oh no, it's a Halloween decoration. But it made you think there was someone in there. Like, I could tell the one guy was kind of getting a laugh out of that when people walk in there. Anyway.
So Steve, going back to that, if a basement is more important than a garage for sure, but sometimes, let's say just the garage.
Well, generally speaking, yeah, garages are pretty straightforward. My take on it is this: if there's been a section 1, if there's been a pest control inspection's been done, and they find drywood termites in the house, but they're not able to thoroughly do an inspection of the garage, at least you know that if you do a fumigation, you're gonna get rid of the drywood termites in the garage. Now, you may or may not address any wood damage that the termites did, but you'll get rid of the termites that are in there, okay? I mean, I had one where the seller collected wine. The garage was full of cases of wine, from floor to ceiling. They literally had a path about 2 feet wide around the outer edge of the wine. So this was the side of the garage, there's wine all the way to the ceiling, the whole garage.
Wow.
And we walked around all this wine floor to ceiling. So all you could see was just the perimeter. Now, the inspector was able to see all the wood sills along the edge, which was great, but we have no idea what the feel of that garage floor looks like under all that wine.
Did the wine stay?
No, the wine went. No, well, and I wrote in a further inspection of the garage after it was emptied out.
Where do you write that in?
Wrote in as another term.
Like, do you put it in?
Additional term.
Additional.
Yeah,
Okay.
because I wasn't gonna have the buyer assume, the condition of the garage without knowing what that floor was like.
Didn't you have a lawsuit?
I'll show you that in a second. Yeah,
Floor?
yeah.
But if the sellers are planning to move everything out only after they close,
Yeah, but we've gotta have we've gotta have a contingency period, we've gotta have a time for it to be emptied out so the buyer can see it, so they can decide whether they wanna accept the condition or not.
So the sellers can put it out and then put it back.
They could, they weren't gonna do that with this.
So you just put under other terms right here?
Yeah, you just write it into other terms.
Other terms, all right.
We wrote in that the seller was to remove all possessions from the garage by no later than such and such
Other
date
terms.
to allow for a further inspection of the garage by the inspectors.
Other terms, right?
Uh-huh, yeah. So what Jerry's talking about is one of the, I've been sued 3 times, so. Go figure, okay? One for every 10 years in the business, I guess. So I've got well, I'll just do this is the garage.
Oh, there was a carpet down.
Yeah, there was carpet there, yeah.
Oh.
I'm not an artist. So that's a car. This is an area rug. And that's a crack
Oh, all the way through.
on both sides.
Oh, my goodness.
So, was doing my visual, did you use this in your disclosure class? No, this example?
No, I
Oh,
didn't.
okay.
This is the first
Well,
time
anyway.
hearing it.
First time you see me do this? Okay,
I know.
so anyway, this is the garage. So I do my visual inspection, so I put down in my visual inspection, there's cracks, outside, they were actually in the sidewalks outside of the garage, and cracks in the garage floor.
Oh, you did disclose.
Oh, I put I put the cracks. Oh,
Was
yeah.
this Warm Springs?
Yeah. Warm
That's
Springs.
why.
Yeah,
That's
Warm
why.
Springs.
Okay.
So I put cracks in garage floor and cracks on the north and south sides of the garage. And then I put you always remember this, you always want to put this in your disclosures. I put area rug and automobile preclude a complete inspection of the garage. So that's what my AVID said. I didn't think we even had AVID back then.
It wasn't that long ago, I remember.
No, it's back, we still had I remember the seller, when I told the seller how big his house was, he goes, no, it's bigger than that. And he goes, I still have the printout from the MLS book. He had the little printout from the MLS book, and he brought it to me. I looked at it, I said, well, let's measure, only one way we're gonna find out, let's measure the house. So I go out and I had 100-foot tape in my garage, back then we were taught how to measure houses when I started the business. So I had 100-foot tape, get it up my trunk. I go, come on, Mr. Seller, and I'm in like a suit, and I'm going, here, you take this in, and I'm measuring the house, and did all the measurements, and go, well, tonight I'll sit down and graph this all out, and then I'll tell you tomorrow. And it came up within feet of what I told him it was. It was smaller, burst his bubble, because all these years he thought his house was like 1,700 square feet, and it was only like 1,400 square feet.
Oh, my goodness.
Oh, yeah, it was a big difference, yeah, the agent just totally wrote how much it was. So anyway, so I put that down. Now the buyer got the disclosures, and buyer accepted them, removed contingencies. Well, the seller moves out, car's gone, rug's gone. I think the rug was gone. Remember, the rug may have stayed, didn't wrap. I think the rug stayed. Car's gone, rug stayed, escrow closes, buyer rolls up the rug, and the crack was a little wider under the rug. And it may have been a little displaced a little bit too. Not much, but I know definitely, as I recall, it was definitely a little wider under the rug. So then the buyer's all upset. Oh, you guys didn't disclose the crack under the rug. I disclosed the cracks. I said I couldn't inspect that. I didn't have a duty to tell the seller to move your car and roll up the rug. I didn't have a duty to do that.
And it says that right in the.
So he wants to go to mediation. All right, we'll go to mediation. So we set up a mediation. I think it was in San Jose. We all drive to San Jose. I drive to San Jose, the sellers, the mediator, and then the buyer. Buyer's a single guy. And we all sit down. The mediator goes, all right, who bought this claim? And the buyer goes, I did. Goes, well, tell us about your claim. We tell the claim. And he gets done explaining his claim, and he goes, I don't want to continue any further. This is unfair because he's an attorney, pointing at me. I'm going, what? I go, I'm not here as an attorney, I'm here as the listing agent. He goes, I don't care. He goes, you're an attorney. I don't have an attorney. And the mediator goes, are you kidding? You don't want to go, we got everybody here to talk about this. You don't want to talk about it because he's an attorney and you don't have one? He goes, yeah, I don't want to talk about it. I said, okay. So we all left. Never heard from him again.
Went away.
No attorney in my mind is going to try to take that case.
Steve, talk about Warm Spring, because it's a problem.
There's a reason why it's called Warm Springs. Okay? Back in the day, off of Stanford Avenue, there was a resort there that had hot springs, hot, warm water. People came from all over the Bay Area to go into those springs. Okay?
Like Yellowstone.
Yeah. Anybody ever been in a hot spring where it's, yeah, okay, yeah, there's out in the Gerlach, out in the Nevada desert, you go to this one place, like, you're out in the middle of nowhere, and there's all this hot water coming up out of the ground. It's interesting. But yeah, there's underground water there. There's the Hayward Fault running right through Warm Springs. The Hayward Fault runs just west of the 680 freeway, all the way through. If you drive down some of the older neighborhoods and you look, just look at driveways and garages, you'll see on each corner, outward corner of the garage, it just drops off. Because there's so much, because there's the groundwater and the fault, there's so much settlement there. I went on a listing appointment in one house in Warm Springs, and the buyer and seller were sitting at the dining table, and I'm walking around going from room to room, taking my notes, and I got into one room and I opened a closet, and the access door to the crawl space was just right there. It wasn't covered. So I don't normally do this, but I lifted up the access doors to look underneath there. Oh. That much water. There was Coke cans floating in the crawl space. And I go, and these people had lived in the house quite a while. It's like, I go, Mr. Stroud, come here, I want to show you something. I go, did you know you had a foot of standing water in your crawl space? No, we didn't know that. It's like they just got used to the smell and the humidity and the smell. It wasn't that bad, but to them it was just normal. And they just lived, and it wasn't a room that they used a lot, but the water was that high. Yeah, you got to be careful in Warm Springs. That's it.
There's also the one up in Union City, that's Appian. They have like active.
Oh no, yeah. By the Masonic Home, Seven Hills is terrible.
Yeah, there's active springs.
Oh yeah, Seven Hills is. I mean, I won't even show property in Seven Hills. Oh no, I won't. I refuse to show property there. I said,
this weekend.
I won't even. I tell the buyers that you don't want to buy it.
What's the issues? I didn't know about that.
Oh yeah, they've got it's earthquake faults because the fault crosses. The fault runs through the pond behind Niles School, goes through the Valle Sierra neighborhood. Okay, it goes right through School Street and D Street and Hillview, and it goes through the California Nursery, which they're all, if you've been by there, they've done a major development. It's beautiful, big, they've spent a lot, it's really nice. Well, the fault's running right through there. And then the fault crosses over at Nursery Avenue, and it goes up into the hills on the other side of the houses, and then it runs along those foothills, right where the Masonic Home is, and Seven Hills is right next to that. Those homes are there's grounds moving like crazy up there. It's terrible.
Well, the
I said, I
freeway
like-
out in Warm Springs, always, if you go out there, you'll see it's got these rises and dips.
Yeah.
It's
yeah,
horrible.
Yeah.
And it's just seismic, it's not
Yeah,
gonna change.
yeah. But yeah, I don't, yeah, Seven Hills, I won't even waste the gas driving up the road. I said, I'm not, don't worry about it, you don't want anything up here, yeah. Yeah, that's why it's a good deal up there, the prices are reasonable, because they got so much earth.
They are building,
Hmm?
they are building houses there now?
Now, these were built years ago. Yeah,
Appian Way.
yeah, before they knew how bad the problem was. Because it goes uphill and they kind of build them at different levels, and yeah, they're all moving all up crazy. Yeah, I wouldn't even touch that.
You need to set your screen down.
What's that?
I think that's discrimination, Steve.
Well, I don't recommend that they buy a house there. Then, where were we here? I was going with somewhere with something, then I got a question, and now anyway.
Buying a house as is.
Yeah, we were talking about as is.
Condition of property of closing.
Yeah.
Yeah, I know where we are in the contract. I was thinking of something else. Moving on, paragraph, so we're 7B, little I, little. All debris and personal property not included in the sale shall be removed by close of escrow or at the time possession is delivered to buyer, if not on the same date. So again, that's another thing that, your seller's agents need to remind the sellers of their, of their contractual obligation to remove all debris and personal property. And that's something you want to be, doing a final verification within 5 days prior to close can be a challenge if the seller's still living in the property and hasn't moved out yet. But you can kind of get a sense of how much they've done and what they're planning to do based on what's still there within 5 days prior to close. If anybody's planning to move, if anybody's done a move lately, you're not waiting until 5 days prior to close to start moving. I mean, you're packing and getting rid of stuff. And there's telltale signs of somebody getting ready to move. If you show up 5 days prior to close or 4 days prior to close and they haven't done a thing, well, that's a telltale sign of Houston, we got a problem here, okay? And that's where you gotta get with the agent and say, hey, what's the seller's plans here? They gotta get all this stuff out of here. It's gonna take them a while. What's going on? And so, hopefully you get a reasonable explanation for what they plan to do real quickly, but you could have a problem. Now, what the contract now goes on to state, this wasn't there before. If items are not removed when possession is delivered to buyer, all items shall be deemed abandoned.
That was a good.
Buyer, after first delivering to seller written notice to remove the items within 3 days, may pay to have such items removed or disposed of and may bring legal action as per this agreement to receive reasonable costs from seller. So it provides a remedy in the contract. So there's no surprise. Okay, now that legal action will normally be small claims court. But remember, you have to make a written demand first before you can bring a small claims action. So you would make a demand of the seller receipt for the cost of disposal. If they refuse to pay it, then you'd have to go to small claims court if you want to choose to do that. Again, you got to decide, do you want to spend all your time chasing down the seller for however much money it costs you to get rid of the stuff. It may not, may be a lot of money depending on how much is there. Bless you. 7C, seller remaining in possession after close. One of the advices here is that the parties are advised to consult with their insurance and legal advisors for information about liability and damage or injury to persons and personal and real property. Because you need to understand that, then it goes on to say buyer's advised to consult with buyer's lender about the impact of seller's occupancy on buyer's loan. That's what we talked about before. You've got a 60-day limit on owner-occupied loans for a rent back. Here's what you got to remind your clients. Remember, when your buyer buys a property and if they're getting financing, the lender's going to require that there be a homeowner's insurance policy in place. So as of the close of escrow, the buyer's homeowner's insurance is in place. If the seller remains in the property, the sellers will have canceled their insurance, their regular insurance as of close of escrow, okay? So the buyer's homeowner insurance is not gonna cover the seller. It's not gonna cover the seller's personal property in the event of a fire or theft. It's not gonna cover the seller in the event of someone sues them for personal injury or property damage. So you have to remind your seller who's renting back that they need to, when they cancel they call the carrier to cancel their policy, they need to notify them that I am gonna remain in the property and rent it back, so I therefore need insurance coverage, like renter's coverage, for the length of time that I'm gonna be there. So very important that you tell your seller to do that, because otherwise, that house burns down, there's no coverage for their personal property. Because they got rid of, their policy was expired, their regular policy was expired.
So how about for the, sorry, go ahead.
Steve, the question I had was that if the seller who's renting back for a period of 60 days, say, they just choose to continue on with their existing policy that they've had all along, and then something happens.
It may not be coverage because they don't own the house.
So they should change it.
They should change, they should tell the lender, because see, they don't own the house anymore. It's not their house.
Is that stipulated in SIP, or is that the rental insurance requirement, is that stipulated in SIP, in the form?
No, because it's there's just there's advice to do it, but it's not a mandatory requirement. But yeah, but you want to remind them to do it.
So for the new owner that's renting, 60 days back to the previous seller.
And they need to let their carrier know that that this is a rental property.
So they gotta get like rental insurance for 2 months.
Well, there's just some endorsements that are added to
Oh,
the
yeah.
policy they already have.
Yeah.
There's just some other things that need to be added to their policy
Okay, something
as
happens.
a rental for those, yeah.
Yeah.
You just need to make sure that they've got
Agent.
adequate coverage in a place for the situation. Just don't ignore insurance when you're dealing with that. And now, just a segue, when you're buying a condominium, the homeowner association has a blanket policy on the buildings, but the homeowner association doesn't cover the unit itself. That's a separate, the condo that the buyer's buying is from the unfinished walls in, and the buyer has to get their own condominium policies, an HO6 policy to insure the unit they're buying. Now, for many, many years, it wasn't a lender requirement. And I know I remember one of our aides in our old office, she didn't even know the policies existed. She never even mentioned her. I said, she thought the HOA covered it. No, they only cover the building. And,
Even
but now,
even the paint inside the condominium isn't covered.
no, yeah, it's from the unfinished wall in. In law school, we always taught it was the airspace, but it's really, for insurance purposes, it's from the studs in, is the
Well,
body.
even the drywall?
Yeah, yeah.
Oh.
Yeah, it's from the studs in.
Jeez.
That's, yeah, it's just, that's the easiest way to separate the two. That's always been my understanding, yeah.
I had a client that happened to, they didn't have insurance, what a mess.
Yeah. So,
I was gonna list their home, it wasn't
Yeah.
when I sold it.
now, lenders finally woke up to the problem. Now, lenders now require the buyers have to get an HO6 condo policy. They can't close now with it, because lenders finally realized, we don't have enough security for what we're lending money on. Or, if we don't require insurance, the blanket policy doesn't cover the unit. Yeah, it's been a few years now since they started doing that. 7D is another little small, minor, innocuous little paragraph that you may read once and not consider anymore. Deals with seller assigning to buyer any assignable warranty rights for items included in the sale, and deliver copies of any such warranties, and we cannot and will not determine the assignability of any warranties. What that's talking about is things like, say, a roof. Roofs have warranties on the material, and the roofer may have a labor warranty. So most of your typical warranties now, particularly with composition shingle roofs, are what are called limited lifetime warranties. And those warranties, if there's a change of ownership, if the home is sold, that warranty has to be transferred or assigned to the new owner. And there's a process for doing that. And it used to be, actually a lot of them manufactured, it's through the manufacturer of the material. A lot of them used to have, where you used to have to get an application and fill out the, your name and the buyer's name and send them $25 or whatever, and then they would send paperwork back and so forth. Now, major manufacturers such as Certainty, you can do it online, where you go online and actually do the assignment, the transfer of the warranty to the new owner. So if, you need to understand that either, if you represent the seller where they just recently replaced the roof, or even I've had furnaces that had assignability of warranties in the furnace warranty. Now, typically with like remodel kitchens, with kitchen appliances, generally speaking, appliances have 1-year warranties, manufacturer's warranties, and most companies, most stores that they're bought from don't make a big deal about proving purchase and whatnot. And everybody has records of everything that they've sold now, so it's a lot easier. So you don't really have to, you don't necessarily have to have all this formal, I mean, it's nice if a kitchen was recently remodeled, it's nice to give them all the receipts and everything so that if they have a problem, they can call up, and deal with the warranty, and there's, what's that? Yeah. Now you can have a home warranty, as well, that would cover for a whole year. But like I said, you've got, on new appliances, they're gonna be covered for a year anyway, even without the separate home warranty. So that's just something. But the area the problem area is the roofs. And the way roofs are like car batteries. You get credit for how many years the roof lasted, and then you get money for however many years you didn't get out of it. In the old days, well, a few years back, the roofs used to have like 50-year warranty, 40-year, 30-year, and if you had a 50-year warranty and it failed after 45 years, well, you got 90% of the life of it, so you only got money for 10%. You didn't get a whole new roof. Okay, so that's how those work. If the material fails, typical roofer, more often than not, will usually give you like a 5-year warranty on their labor, on the workmanship and labor and the installation of the roof. Because typically, if a roof's not put on right, it's going to leak right away. It's not going to take years for that to manifest itself. It's usually going to happen pretty quickly.
Do you see these transfers often, or do you always keep that in mind when you find out that the roof is newer, so the seller...
Yeah, that's just something you just have to remember. This has got a newer roof. There need to find out from. I mean, we're not supposed to do it ourselves. I will do it just because I know what to look for. But yeah, you should always be on alert when you've got a house that's marketing a newer roof. They should have that paperwork, and there's got to be a transfer of that.
I sold a house in Hayward, brand new house, it's about a year old, and the roof was missing the whole, shingles.
Crazy.
It happens.
And I guess got off work and forgot to come back and finish that last row.
Left Friday and came back Monday and started a new house. I'm sure that's what happened.
I forgot, never went
Got
back.
signed off too on Friday. Oh yeah, all finished.
Yeah, right, yeah. Yeah, everyone always thinks, you got permit inspectors got to be checking all this stuff out, they're going to bless everything, and that's not always the case. That's not a permit inspection doesn't always guarantee that the work was done correctly and properly, because they can only just look at what they physically see. You know, they're not there watching them do the work, so forth. I did construction litigation for 5 years, so I know what, all the stuff that can happen when it comes to building houses. It's pretty crazy. 7E, dealing with, and this is a loaded paragraph. On close of escrow, seller on close of escrow unless otherwise agreed. And then they added this line to it. And even if seller remains in possession, seller shall provide keys, passwords, codes, and/or means to operate all locks, mailboxes, security systems, alarms, home automation systems, internet and internet-connected devices included in the purchase price, garage door openers, and all items included in either 3P or paragraph 9. And if the property is a condominium, common interest development, seller is responsible for securing and providing such items for association amenities, facilities, and access, i.e. the infamous pool key, okay? And the buyer may need to pay a deposit for that pool key. So you need to, as a seller's agent, you need to, this is another one of those paragraphs that you need to point out to a seller before you go into contract, and that is, the contract requires you to provide keys, codes, passwords, and everything, all of the locks. Do you have them all?
Right.
I had one time at the kitchen table and asked the seller, old guy, and he goes, well, I'll be right back. So he comes back, he leaves, and he comes back with this pile. It was about that big of keys. They were all connected together, and he throws them on the table. He goes, well, this is everything I got. You figure it out. I don't know if I've got keys. You know, it's like, oh my goodness. You know, it's just, and this is one of those houses that had a separate man door for the garage outside of the unit. You know, there's certain developments where you got the front door, and then you got the garage, and there's a man door for the garage. And it's not an interior access. And sure enough, it's like he's got all these keys. Sure enough, he did not have a key to that garage. He had keys for everything. I don't know where all his other keys were. He had no key to that garage. So here's what you've got to do. Unless you want to become good friends with a locksmith or be buying a bunch of lock sets, you got to make a note in your file if the seller doesn't have all of the keys or all of the codes or all the passwords. You got to make a note in your file so that when an offer comes in and you do a counter offer, you state, regarding paragraph 7, where is it? Regarding paragraph 7E, seller will not provide keys to all locks. That protects you from a buyer coming back and saying, where's the key to this? Where's the key to that? Where's this? Where's that? Where's the remote? Now with remote controls, always state that on the TDS, always state 1. Because if you put 2 or 3 and you only have 1 or 2, buyers get really upset because you didn't give them all the remotes. So always put 1, because invariably what happens is remotes get left on visors of cars and get packed onto a moving van, and by the time you realize they didn't leave that other remote, it's halfway across the country. Oh yeah, we'll get it to you when we get to the other side. Sure you will, you know? Now, with all that said, I'm aging myself because it's a lot easier now because you have universal remotes for $35 that you can program and it throws. Back in the day, we didn't have universal remotes. We had to go to a store in San Leandro called Dolson Electronics and go, hey, this is the garage opener, can you get me? Oh, yeah, it'd take a week or so, and it costs a lot of money. We didn't have universal remotes. You had to get the one for that manufacturer. So you learn real quick, one garage door opener, because that's all you owe them. If you give them 2 or 3, they'll be fine, but don't shortchange them on the remotes. They don't like that.
Steve, just for, I think I missed the point there. If the way to avoid for them having to give all the keys?
You'd have to write in an additional term. You'd have to say, seller shall not provide all keys to buyer at close of escrow. But see, yeah.
They're entitled to those keys.
Oh, I know, that's what the
Yeah.
contract says that, I mean.
Unless, of course, otherwise agreed upon.
Yeah, right, I mean, do you think a landlord has keys to their house, to their rental houses?
I do.
Of course you do. You own the house, you have keys, you gotta have access to the house in case of an emergency. If the seller's living in it, the seller's just like a tenant. They don't own the house anymore, it's the sellers. What if there's an emergency? What if, this is the buyers, what if there's an emergency, the sellers are out of town? God forbid, something's happening and you gotta, shore up the house, it's gonna flood, or whatever it might be. You own the house, you've gotta have access to that house to keep that house safe. Even though it's hard psychologically for a seller, because if they've lived in the house for years and years and years, they think of it as their house. And even though escrow closes, they still think it's their house, but it's not. You don't own this anymore.
That's why it's hard to ask for a deposit.
Yeah, it's hard, I know. It's your, you gotta give the buyer keys. They own the house. They've gotta have an ability to access in the event of an emergency. Don't worry, they're not gonna come in the middle of the night and come into your house. I mean, it's like, geez, people get paranoid over stupid things. All I'll say about this is, all I'll say is, with respect to Ring doorbells, there is a process for transferring a Ring account from the seller to the buyer, okay? And it's
not the easiest.
What's that?
It's not the easiest.
Well, it's not as easy as they make it sound, but I'll just tell you, there is a process, and I don't even think the Ring customer service understand the process, because I keep getting different stories from the seller and the buyer as to what Ring's telling them to do to get this account transferred over. But just be aware that there is a process for doing that. And the reason they have it, there's got to be instructions that initiate from the seller so that they can make sure that the Ring wasn't stolen. Okay, that's why they have this process to transfer from one to the other. Now remember, like in a condo, I mean, a condominium complex with a garage, I mean, you could have a front door key, you could have a mailbox key, you could have a pool key. The garage could have, and even, we could have a remote, could have a keypad with a code. And then it also has, if you look in the garage door, it's about eyeball high. There's a little tumbler lock in the door, and that lock is connected to a cable that connects to the garage door opener, the arm of the garage door opener. So typically with detached garages, and it's there in the event of a power failure. You take that key in that tumbler lock, and you turn that key, and then you pull it, and that pulls the cable, which manually unlocks the garage door so you can open the roll-up door. You understand? Have you ever seen it in a garage? What is that? Well, you're supposed to. That's the only way. You gotta have a key to get in. Because if you look at your garage door, you should have a rope with a handle. Okay. Yeah. Well, this cable goes from the door in and connects to that, because these are detached garages. In condo complexes, it's just a building of garages. There's no doors into the garage. The only door is the roll-up door. So you've got to have that system in case of a power failure. Because if the power goes out, you can't, that pad's not going to work, the remote's not going to work. So so they install those. Yeah, and that's another lock. So you could have about 4 or 5 keys that you with a condo that you give to. Yeah, you'll do this long enough. These are particular condos that are in Centerville and Claremont Meadows off on Paris Circle off of Peralta near Paris Avenue there in Centerville. But yeah, they have that. It's a pretty cool system, Rich. Because otherwise, you're having to dismantle that garage door because there's no other way into the garage. Moving on. I'm going to be talking really fast tomorrow. Okay, contingencies. We talked about implied covenant of good faith and fair dealing. In paragraph 8A, you have what's called, A1, you have what's called, in the loan contingency, you have buyer shall act diligently and in good faith to obtain the designated loan. That's an express covenant of good faith and fair dealing, which means the buyer can't dilly-dally around. I mean, they've got time is of the essence, that's in the contract too. You've got to be diligent and be on top of it with that lender, giving that lender what they need and so forth. You can't just be dragging their feet, letting a week go by and doing nothing. Okay, time is of the essence. You've got, because you've agreed to close in a certain number of days. And you could be in default for breaching that express covenant. If there's no appraisal contingency, or the appraisal contingency has been waived or removed in favor of the property to appraise it, the purchase price does not entitle buyer to exercise the cancellation right pursuant to the loan contingency if buyer is otherwise qualified for the specified loan and buyer is able to satisfy lender's non-appraisal conditions for closing the loan. So that means just what it says, that you can't, just because you have a loan contingency, if the property doesn't appraise, you can't use the loan contingency to cancel the contract. Okay, if you removed or waived the appraisal contingency, which a lot of buyers did, there's no right of cancellation under the loan contingency if there's a loan contingency. You have to use the appropriate contingency to cancel for the reason that you're actually canceling. You can't use some other. And I can't tell you how many times I'll hear situations where buyers will write an offer with no contingencies except loan. And then during that informational access, they'll do some inspections, or maybe do some inspections over and above what the seller had already done, and find stuff wrong. And then the agent will tell the buyer, oh, don't worry about that. You can just cancel under the loan contingency. No, it doesn't work that way. Now you got to be careful because sometimes they may try to pull a fast one on you. But loan is the easiest one to investigate. Pick up the call and call the loan and say, hey, just call and see how's the loan going? Oh, the loan's going great. You know, okay, that's what I thought. You know, it's like, who are you trying to kid? But there are agents that think that. They think they can just rely on any contingency to cancel for any reason. Can't do that. Doesn't work that way.
Isn't there like a written letter from lender that the buyer doesn't qualify that should be sent to you?
Well, once they get to that point, yeah. Okay. Well, you have a pre-approval letter, but then the buyer will ultimately get the underwriter will issue what's called a conditional loan approval, where they're approved subject to a bunch of conditions. Now, every loan has conditions to close, but most of those have nothing to do with the borrower. They have to do with the process and the property and a bunch of other stuff. But there could be conditions that are personal to the buyer that still need to be satisfied. Okay, so the buyer has to talk to the loan officer when it comes time to removing the loan contingency to find out, am I clear to remove this loan contingency?
Personally.
Okay, because it's a question of how hard or easy is it going to be to satisfy these loan conditions. Sometimes it's hard for people that aren't good record keepers. It's easier now, but I mean, there were times where lenders would put conditions. They want like 12 months. They want a tenant to show 12 months evidence of payments to the landlord of rent, and people were like, well, they didn't have checkbooks, and they'd go get money orders. That's how people. Our first time they'd go get money orders, and they would keep paperwork, and the lender would want to see it 12 months of payments. I can't give it to you. I never had a checkbook. It's like, well, lender, are you going to force the issue or not? Then and you get times where they don't have much in the way of credit history. You go, well, you were renting, right? Were you paying PG&E? Yeah. Well, PG&E has a payment history for you. We can get that from PG&E. Did you have a phone? Yeah, well, the phone company kept a record of your, you can go, there's other ways to show credit histories to satisfy the lender. Yeah.
So is there a specific car form when a buyer is gonna back out to any of these conditions or inspections or disclosures, or a certain form?
Yeah, well, there's a cancellation of contract form. And it's a two-part form with a cancellation of it takes one party to cancel, it takes both parties to release each other to cancel the escrow, return the deposit, and release each other from all contractual obligations. And on the cancellation part, if the buyer's the one who's canceling, they have to check a box and state based on which paragraph in this contract are you canceling. You have to state the reason that you're canceling.
Okay. And that's various throughout the contract, what it could be for, right?
Yeah, you go to whatever right of cancellation that appears here, that's the paragraph you put in the cancellation form. You look to that. Typically it's gonna be 14B1, which is your contingency removal paragraph. Yeah. Okay. 14B1 is the typical one you're dealing with, cancellation based on inspections, investigation, and that sort of thing. That's the most common one.
So you just put 14B1, and do you add any verbiage, or you just
No, you just put 14B1, and there's just a small space, you just put 14B1. That's your reason for canceling.
So it's a two-page, it's a two-page on the car then?
Yeah. Where were we here? We talked about insurability. Yeah, buyer's advice to investigate the insurability of the property as early as possible. This may be a requirement for lending. Buyer's ability to obtain insurance, including fire insurance, as part of buyer's investigation of property contingency. Failure of buyer to obtain insurance may justify cancellation based on the investigation, but not the loan contingency. So that's important there. Failure of buyer to obtain insurance may justify cancellation based on the investigative contingency, but not the loan contingency. Okay, that's why it's important to check out insurance right away. You can't use the loan contingency to cancel because you can't get insurance. Appraisal. Appraisal of the property is to be at no less than the amount specified in paragraph 3L2, which is the purchase price, without requiring repairs or improvements to the property. Sometimes an appraiser will go, yeah, I can bring it in at the purchase price, but it needs a new roof, provided you put a new roof on. Well, this contract says it's got appraised for the price without requiring repairs or improvements to the property. Appraisals are often a reliable source to verify square footage of the subject property. However, the ability to cancel based on the measurements provided in appraisal falls within the investigation of property contingency. So, again, if the buyer's concerned about the size of the property, they are to determine the size of the property during the investigation contingency. The fact that the appraiser measures the house with a different size does not give the buyer the right to cancel based on the appraisal contingency. The purpose of the appraisal isn't to disclose the size of the house. I mean, it's part of the appraisal, that's what it says. But if you want to cancel based on or negotiate price because the house is smaller than you thought it was, that's the investigation contingency. That's not the appraisal contingency. But quite often, that's when you learn about it is through the appraisal. I had one time where the standard appraisal principles, at least what I was taught, was that you round to the nearest, if you're round to the nearest quarter of a foot. Well, this appraiser this is a big 2-story house, and this was a big 2-story house. It was 3,500 square feet. He or she was rounding down to the nearest foot. So you could have had a wall that was another 10 inches, and she was rounding it down. So when the appraisal came back, the buyer called me up and said, hey, it's got the appraisal. The house is about, I don't know, I think it was about 300 square feet smaller. I said, really? I said, well, send me that report. I don't even know if we had email. But anyway.
So they knocked the foot off the piece.
Well, yeah, so I go, and I look, well, look, I said, well, it looks like she's rounding down to the nearest foot. So I go to the house, get out my trusty 100-foot tape, go to the house, I start measuring walls, I'm going, this wall's 30 feet, 10 inches. You know, and this wall's 50 feet, 7 inches. Well, when you start picking up 7 to 10 inches along 30 to 50 feet on 2 floors, it starts adding up, and that's exactly what had happened. The size of a house is what it is, folks. There's only one accurate number. There's not multiple numbers.
It's a shame they don't have the ages tape houses anymore,
Yeah.
really.
So then I said, all the buyers said, I said, the house is what they represented. It's not what the appraiser said. Here's why. I showed them. She just rounded down all these numbers. Here's the actual dimensions of it. Sometimes they can screw up with stairwells, okay, because you're only supposed to count it once. You know, so that sometimes they screw up there. But this was just rounding down too much. You know, it was just, that was the problem. Once in a while they'll get confused, and you know, sometimes these guys are in a hurry. I've seen a house get measured multiple ways, and I looked at it and I go, this is a no-brainer. I don't see how they could have screwed this up. You know, but there were different dimensions for it. And I measured. I said, this one's a piece of cake. Yeah. Well, that was one of the very first things that when you joined Bay East and you went to an orientation. One of the things they had was a class. I still have the outline on it. Was a class on how to measure a house. That's what we were taught to do.
You still have the,
Yeah,
are you a hoarder?
Yeah, when it comes to real estate stuff, yeah. I got a 100-foot tape. In fact, I used to have 2 of them. I made sure I had a tape, you know. Well, but what was good about it was it really impressed sellers, because I mean, you're like, you know, you're out there, you know, boots in the ground, you know, it's like I'd be in 3-piece suits and doing, you know, it's just like, but they saw me doing something that no one had ever done before, you know, and then you come back with your diagram, and again, this was before software programs and all that. I get out the graph paper and I draw it all out, and you know, and they told us how to measure, and then said, "Now here's the square footage of your house." Oh, never knew. I always thought it was that. I don't know. This is what it is. You know, it's only one number. Can't be something different. Doesn't change. Moving on. We're almost done, and I know I didn't give you a break, but you've been getting up and down, huh? No, I'm too exciting to not sit and listen to, right? You're supposed to laugh at that. Now, here's one in 8B1. It says, for any cancellation based upon this appraisal contingency, buyer shall deliver a copy of the written appraisal to seller upon request by seller. So now, buyer cancels the contract because the property didn't appraise, gives the appraisal report to the seller. Seller asks for the appraisal report for proof that what it appraised for, because they don't trust the buyer. So they give them the appraisal report. So now, seller now puts the property back on the market. Oh, I gotta remember, Pat told me I gotta stay over here.
Yes.
They can't hear when I walk. I gotta nail my shoes to the ground here because they can't hear me when I go over there. Seller puts property back on the market. Does the seller have to disclose the appraisal report? How many say yes? How many say no?
I know for FHA for sure.
Okay, that's a little different. That's not the seller. It's because the FHA stays with the property because FHA stays with the property because it's assigned a case number to that property.
I think it's 120 days.
Yeah, Yeah, that's a
But
different
still.
situation. Okay, I'll preface my, other than FHA, does the seller have a duty to disclose the appraisal report? How many think yes? How many think no?
How about, doesn't have a clue?
She's right. Appraisals are an opinion of value.
Ah,
Appraisals are not a material fact.
one person's opinion.
One person's opinion is not a material fact.
Doesn't have to disclose.
Does not have to be disclosed. Now, sometimes a seller may choose to disclose it if it's a really high appraisal, higher than what they're trying to get for the house. But usually it's a lower appraisal, that's why you don't want to give it to the buyer. It is an opinion,
Steve,
it's
can I
not a
ask
material
something like
fact. Yeah.
Quite often, people get an appraisal for a loan. And then you go to list their house and they tell you, it's appraised, I got an appraisal. Well, that was for a loan, and quite often they appraise higher for a loan, for some reason, I don't know.
Well,
why.
sometimes they even come in lower because remember, all an appraiser's doing is telling the lender that this loan that they're getting, has a loan to value of no more than 80% of the value of the property. So they only have to take it so high to hit that 80% LTV based on the amount of the refinance loan. So quite often, they don't need to come in that high because all they're doing is satisfying the lender as to the loan to value.
Has the amount of the loan.
Doesn't matter, that's all the lender wants to know is the loan to value is 80% or less. So there's not an incentive for an appraiser to bring it in real high, because they don't need to, the lender doesn't care. All they want to see is it's not greater than 80%. Does that make sense?
So the point I'm getting across, don't count on the seller's copy of their appraisal from something.
Well, and the other thing too is when they have multiple appraisals, you may likely, depending on the configuration of the house, you may likely see different square footages when they do the measurements. Because again, you got, over time, guys were using, measuring tapes. Now that a lot of them are using lasers. They're measuring tapes and they're using the ones on the roller and they go, like this and write down and start talking and forget now, and then now they use the lasers and those are, seem to be pretty accurate, but they can make mistakes with those too. So, mistakes happen, but you can get different numbers, you can get multiple appraisals of all the different numbers. Now, we have a form to disclose that. If you take a listing and you see on the MLS that property's been listed before and it has different square footages and the seller's got a couple different appraisals they give you and there's different numbers, we've got a square footage advisory form that you can list all the different sizes and all the different square footages and the source of those to give to the buyer to let them know, this house has been, but this hasn't been verified, but this house has been listed as different sizes of house. I've had to do that with some listings because you go to the MLS and there's you'll find 3 or 4 different square footages for the same house.
And the assessor records also, they're quite often in.
Yeah, they may not be accurate, they may not be. We've pretty much exhausted other contingencies. Title, like we said, if you got a preliminary title board contingency, it's, that means it's contingent upon buyer's ability to obtain a title policy, provide for, and a buyer's review of the report and items that are disclosed or observable, even if not on record. Buyer's advised to review all underlying documents and other matters affecting title, including but not limited to any documents or deeds and referencing the report and any plotted easements. So you remember, if you get a preliminary title report, it should be what we call a live report with live links, meaning every exception in the title, every reference to a document has a live link that you can click on and see the underlying document.
Isn't that nice?
Oh, it's beautiful.
Oh, yeah.
When I got into business, I didn't know what half this stuff was. I was an attorney doing insurance defense law. I bought about 3 or 4 houses up to that point, but I never really paid that much attention to everything. So I'd ask the escrow officer, can you give me copies of exceptions 4, 7, 9, 10, 12, and then they'd send over copies of all this stuff. And I go, oh, that's what they're talking about. I mean, You know, there are maps that are color coded and all kinds of stuff, but you don't, until you gotta click on those links to see them. So anything that if you see anything that's an exception on a pre, that means there's a document recorded where that information exists, and you can
Good idea to find out what it is.
Yeah, you get that document to see what it is. Now, I had that agent in Oakland saw that playground easement, they would've got the document that said, yeah, there's an easement for this playground. And it was right there, they never allowed to look at it. But yeah, that's true for anything that's in there. Now, this top of page 6.
Is there Avid for a lot, for land lot?
I'm sorry?
Land lot, Avid?
No. You don't do a visual inspection of land.
For land, okay.
Hello. All right, we got a little serenade there. All right. Okay, top of 6, buyer has 5 days after, this is new, fairly new. Buyer has 5 days after receipt to review a revised preliminary report. Have you ever had where you get a pre and then later on while you're in escrow, another one comes in? Well, typically what's happened is what they've done is they've done a search based on the buyer's names, and then there's a new one comes in after that. But they may have picked up something new depending on how long it's been since the last search. So that's referred to as a revised preliminary report. And buyer can cancel the transaction if the revised report reveals material substantial deviations from a previously provided report. Don't see that too often, but it is possible. The question came up, what if the buyer's already removed the initial contingency for preliminary title report? This clause survives that. So even if the preliminary title report contingency has been removed, this clause survives that. So if after removal of the preliminary title report, a revised preliminary title report is issued, the buyer still has a right of cancellation if it reveals a material or substantial deviation from the previous report.
After contingency has been removed?
Yeah, that's what, this survives that. This clause survives that.
So Steve, you mentioned there was a number of things that survived that, this is one.
This is one of them, yeah. Well, this is different from the statutory disclosure issue. This is specific to preliminary title reports. Because the question came up the first time I taught this class, and then I had to research it and talk to other people, and yeah, this survives the removal of that. Because you're not in control of when the title company will issue a revised preliminary title report. Because remember, when you get a preliminary title report, look at on the first page and look at the date that it's effective. That tells you the last time they searched the property. So if that's a date that's back 2, 3, 4 years, there could be something new that doesn't show up yet. So always look at that date, and that'll tell you how current the search was.
So how years?
Huh?
I've never seen one of those. I see it for months. But
Oh yeah, sometimes you get them. Yeah.
Well, how often?
Well, they'll issue them. Yeah, they'll issue them, and they're and then they do a revised one.
In your experience, how often do they revise it after?
Well, now they typically only do it when they're asked to search title.
Yeah.
Like either through a refi or another purchase, so forth.
But they don't usually.
See,
they don't usually update it like after contingency.
No, they don't. Well, no. Well, they typically have. There's usually something that's causing them to issue a revised,
exactly.
something new thing. Typically, what I see is, well, it depends on when escrow's open, how current the last search was. If it's an older search, see, you have to understand, they search and double check right up to the eve of close.
Yeah.
Okay.
They have to.
Yeah.
So, but they will issue a new written report. If a new escrow is open and it's been a while since that title's been searched, they'll typically, do another one. But you may get a pre that hasn't been updated yet. And then they'll do an update and then send it out. That's why this clause is in here, because that does happen.
I thought when they open escrow, they'll do the search, so they won't have to do it later in escrow.
Well, they still have to do it later in escrow.
Okay.
they do it all to the eve,
So
because they're
what's
waiting for last minute recordings. They wanna make sure you didn't sneak in a deed of
Yeah.
trust or something in there.
So what usually pops up if it's updated, revised in the middle of escrow?
The seller could run off and record something. The seller could have one loan and then go borrow money from someone and get a deed of trust and record it on the property.
I ran into that, up at one time.
Or try to transfer title to somebody else. Okay, and then, what was I gonna say? But the most common thing I see is they have to search the buyer's names.
Yeah.
And then they've gotta do that search. And then they'll come back with.
It's updated,
Yeah, with an
Yeah, we'll get
updated
it
after
updated.
they've done that, yeah. We wanna go down this rabbit hole right now. With 4 minutes to go. Let's wait till tomorrow. That's kind of a loaded one. Anybody have any parting questions?
Yes.
Yeah.
I went into Bay East, community info and city, and I could not find anything for Pleasanton.
Really? Well, I told Bay East a couple years ago that they need to update all those cities, because
But I've
they're,
had one in Pleasanton and we didn't ask for the spark arrested.
yeah, Spark Rusher's been there for years, been there forever as a point of sale.
Right, but
And
not-
it's usually not a big problem, because so much of Pleasanton is newer that everything's got
This
Spark
one's not
Rusher.
a newer house.
Yeah, well, they had, I had a house in Brentwood, and they said that Brentwood had I think it was a sewer lateral ordinance. I don't think Brentwood, and I had to call up the city of Brentwood and say, no, we don't have a sewer lateral ordinance, but Bay East side said they did. And I went back to David and I said, you guys gotta update this, they're not accurate.
Right, so I don't know where to find this.
Call the building
Hey,
department.
see if we can- yes, we'll see.
Call the city of Pleasanton building department.
Oh, okay.
No, it's that one's one of the oldest ones.
So we're gonna
Pleasant
explain
Park
all
has
this
been
to our
around for
clients.
years.
That's all right.
Steve?
Only do it on single family one.
So it's not gonna be like in command, he's not gonna get paid until you go out.
Shouldn't even be on the checklist. Shouldn't be on the- Because there is no.
And then for AVID, when the agents have to do this timeline, they have to do the AVID by
Well,
broadcast
we'll,
purchase record.
we'll talk about that tomorrow, but
I was on YouTube this morning.
what we should do, well, it depends on, depending on when the buyer's gonna remove the disclosure certificate. Because, if the buyer, if a completed disclosure under the contract is disclosure completed by the seller and the seller's agent. Once those two have completed the disclosure, CDS, complete, it's been given to the buyer before the buyer makes their offer. Okay? And the buyer removes that disclosure's contingency as part of their offer. The buyer has no right of cancellation, and you represent the buyer. The buyer has no right of cancellation based on your agent. So, in answer to your question, if you're gonna write a non-contingent offer and remove the disclosure contingency, you should be doing your AVID before you write the offer, so that your buyer can see your AVID before removing the contingency. But that doesn't generally happen.
Yeah, but what if it's just a standard, like?
But I'm just saying, generally speaking, it's very rarely done. Most of us don't do it visual until after we're in contract. But I'm telling you, if you wanna quote protect your buyer, and give your buyer recourse, you need to do the visual before you write inside the office, so they can see it and read it.
What if it's just, it's not a non-contingent offer, it's just a regular year contingency?
Well, the contract requires the seller to provide all the documents within 7 days after acceptance. So that's basically generally considered, that 7 days is the time for the buyer to complete their AVID is considered part of that 7-day process. In other words,
Thank you, Steve.
okay, in other words, the way it's set up, it's
See you tomorrow. So what's the ringtone for
the seller's agent is supposed to monitor the buyer's agent completion of the AVID so that it's part of a complete AVID within 7 days after acceptance. So that's the time frame. There is no time frame otherwise stated in the contract for the buyer's agent to do their
November
AVID.
16th, that one
It's
just came in,
to
so you need to
be
stop
done
it.
within that 7-day period when the buyers get all of the disclosures from the
Where
seller.
did they find it?
So I better write and do.
I have no
Well,
idea,
when
I
did you
don't
go in
ask
there?
those, I
I
just
know.
get it, okay.
Those checks.
Oh, yeah, no, you should have been right on that.
Okay.
Yeah, they were
The date
dated
is-
last
But
Right, they were
you
dated
have a
last
disclosure
Friday,
contingency in the
December-
contract.
Or September 16th.
Yeah, we haven't released any.
Okay, I will let them
Well,
know.
when is it due?
Self-payment
They're
tomorrow,
not
please.
positive, yeah.
Tomorrow.
Yeah,
I
well,
was
see,
told that
you
they'll
need to
give
do
it
that,
tomorrow.
you need to do that before they remove the
Yeah,
contingency.
midnight.
Yeah.
Otherwise, they have no right to,
Checks.
they'll have no right to cancel based on your disclosures.
Yeah, right, yeah, okay, I'll make sure. Yeah, I know it had to be done before it was never removed. Yeah, okay.
Yeah, you need to get on that right away,
Okay.
so they have a chance to review it.
Yeah, yeah.
And ask you any questions. based
Okay.
on your findings.
Okay.
Thank you, Steve.
You're
See you
welcome.
tomorrow.
Okay.
Let's go.
Yeah, you're brave for wanting to drive over the hill to here.
Yeah,
Is that morning traffic?
I think it's perfect.
I haven't done this.
Yeah, get on it. This is an important one.
No, I'm saying.
At the end of the day, it's CYA.
Yeah.
Yeah.
Don't get over it yet.
Well,
I know, but it's like.
I've experienced
Well,
probably not everything, but a lot. You know,
Yes.
I've seen a lot, either personally or as a broker, so.
so if that happens.
We'll see you tomorrow, my friend.
Okay.
Thank you again.
Yeah.
Will you rewrite that? Because that offer is right. I was hoping you would just let it go.
I know, and then that's what you kind of said on the phone, remember? It's like as long as you get me, signed off, like we just,
So Steve, were some of these people not from our office, like him? I don't know him.
No, Gabe is from,
Oh, yeah,
Gabe's
Gabe,
from
my
Pleasanton, and that was Rob and Alka Betty from
Okay, because I didn't
Pleasanton.
recognize them either.
Yeah.
Okay.
Send me like the links and do.
Yeah, I happen to,
October 6th.
October 6th.
yeah, I was
I don't
helping
remember.
Gabe a lot
Yeah.
on a transaction over the last month or so,
Yeah.
and I invited him here, and
Yeah.
then Rob and Alka, I helped them a lot, and I told them about it too. They're huge producers.
Who are?
Rob and Alka,
Oh,
and, you know,
yeah, I haven't ever sat in on your class for
they're,
this.
they're,
for
they're,
this one.
I mean, they're like in the top, they're in like the top, probably the top 5 in the region.
Really?
Oh, yeah, they do massive.
These two right here.
Yeah.
Well, you know, some
They
people.
do massive.
I don't know what you expect
I
them
mean,
to
I'm
look
talking
like.
like.
I know, you never know.
But
I
great.
mean, over, I mean, the numbers are just, I mean, over 150 I mean, it's like, it's amazing, and they don't even have a transaction coordinator.
Do you know John Rocha?
Yeah.
Okay, I'm in a transaction with him. He can be really nice, and then he starts his bragging about how many homes he owns all over the world, and the condos, and he has 4 in Hawaii, they have 1 for themselves, and they rent out 3, and he has some in Portugal, and he has some, they're all over the world, and then he tells me how big his house is, that he has this $5,600,000 house, because this house has rats that we're buying. And I said, well, they trapped them, did they close up the holes? He says, nah, you can't do that. He says, I've got a $5,600,000 house. We probably have mice under our house, there's no way you can get rid of them. I said, yes, you can. And he just goes on and on and on.
Wow, he sounds, yeah,
He's got a pretty big team, or he's
Yeah.
got a team, I don't know how big it is. Well, Gabe, I'm not sure when I'm doing my class, oh, here it is, it's October 6th at 1 o'clock.
1 o'clock, okay. What day is that? That's, Tuesday, Wednesday, Thursday?
It's gotta be, well, it's a Thursday.
Thursday.
Yeah,
okay.
I know it's not a Monday or a Wednesday, I knew that for sure. October 6th at 1.
Okay,
Yeah, and I won't have COVID this time.
nice.
Last time I
Would it be
just
here,
got
would it be
COVID.
here? Would it be right here?
It'll be up here, yeah.
So
Last
this is
time I-
like your guys' training class right here?
Say it again?
This your training class?
Yeah,
Like-
yeah. Last time I just got over COVID and I couldn't stay awake during my class.
Oh, right.
It was so awful. Apparently I wasn't completely over it. Oh, that was so bad.
Really?
All right, Steve, see you tomorrow.
All right,
Okay,
Gabe.
yeah, we're leaving too. Or we'll close them. Just lock the door.
Okay.
What kind of wine?
Does that
Did he
stay
give it
on?
to you? Did Adrian give it to
They
you?
did. It was a thank you. I did a lot of help. I helped them a lot.
Here's some more. Want to leave these up here for tomorrow?
Yeah.
Okay.
Does the screen stay on?
What's that? I was gonna let, I can turn it on. I don't know.
You did such a good job. No, I did, but I forgot. Well, I had already sent it to him. I had already sent it to him. So I don't know why he's saying I didn't.
Maybe it wasn't
He
signed
wants
by
to
everybody.
I think so. No, but now I'm like, wait, Mark, I was like, well, now we have to wait. Now we have to wait to see if it's going to get accepted. But, he's like, okay,
I don't know how, I don't know how to turn it off.
I might, I don't know.
You know how to do it? I'm gonna do it.
I don't know. Oh, right, no, Harshita's got it. I don't know how to do it. I would just be guessing.
I'm trying to push a few off buttons.
So then, in case, we would just send a new offer. In case.
Once you talk to him, right?
Yeah.
Yeah. See, so do you want me to send a new offer or an extension of time on the counter? For the counter.
Oh, for the counter, that's right.
Right, that's what we should have done. Usually just kind of accept it.
I mean, why not?
No, because he's not here on contract. And maybe he doesn't like us.
At this point, he's over me. At this point, he's like,